Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are here with another very exciting webinar that is lined up just for you today. So make sure to watch this session till the end, and you can also ask questions. That is the best part of our webinars, that you can participate by asking as many questions as possible. And with that, we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So check out us there, and also like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information shared by our experts and attorneys, including user comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, once again, welcome back everyone to Immigration Talk Show. I'm your host, Sam. And today, the topic that we are going to talk about is another very important and very essential, especially for E2 visa applicants. And that is, what should investors know about the E2 visa changes in 2025? So, to help me in diving into this discussion and also to make this webinar a wonderful one, I have a very special guest who is joining us for the very first time in Immigration Talk Show, none other than attorney Jessica Weiss. But before inviting her to this webinar, I would also like to tell something about her. That attorney Jessica Weiss is a nationally recognized immigration lawyer with over 2 decades of experience and remarkable list of achievements. She was honored with the prestigious Immigration Services of the Year award from the Global Chamber for her outstanding achievements and exceptional services in the field. Jessica also serves as national mentor for the American Immigration Lawyers Association, guiding fellow immigration attorneys in the areas of adjustments of status and also on E2 visas. The great thing about her that she takes the time to understand each client's case in a very unique way, and she also guides them every step on the way. And whether it's coming to the US as a tourist, moving to a green card, or one day becoming a US citizen. So I'm really thrilled and honored to have a show with her. So, Jessica, thank you so much for being here. We are really honored, and we welcome you wholeheartedly to Immigration Talk Show for the very first time.
Thank you so much. That was quite an introduction. I very much appreciate that. And I can't explain it, but I love doing E2 visas. I've done them for more than 2 decades, and I really, really enjoy them because it's such a great way for people to come to this country. So I look forward to this show today with you.
Absolutely. I'm sure our viewers are really excited for this session, and that too, it's a very important topic. So, I think without any further ado, I would just like to know it from you, Jessica, that what our viewers would expect from today's webinar.
So I think what they can expect is a better understanding of where are we going with E2 visas. Is it going to be the same story as the last, what I mentioned to you a little bit earlier before we started the show was 1815 is when E2 visas started. That's over 200 years of E2 treaties. And do we think in the next year with President Trump in command of this country, is it going to change drastically? So I want you to understand, what are the changes? Will there be any changes? Are we in for another several years of a great ride with E2s? And I think you'll get that from this presentation today, a much better understanding of that.
Absolutely. I think that's great. Our viewers are going to know a lot of things in today's webinar. So, Jessica, let's begin with our very first question. What should investors know about the E2 visa changes in 2025?
Okay, first thing is, I don't think there are going to be a lot of changes. I think we're in for a great ride. If you look at the last time that President Trump managed this country, we didn't have a lot of changes. In fact, we had 2 countries that were added to the list of EU treating countries. We had Israel and New Zealand. And I think we're in for more countries may get added on, which is very exciting because there are so many countries that want to be part of this E2 treaty that we have process, and they're left out. I don't think every country like mainland China, I don't see that one happening so fast. It just depends on our relationship with a country and how much trade we have and how much we want to benefit each other's countries by allowing them to do this E2 treaty. So I think we're in for could be some more countries added. There are a few things, actually very recently something changed, that it used to be that you could have a waiver of your interview, let's say for an E2 visa, if you got it within 48 months of the last one. They just changed recently that it has to be within 12 months that you got your visa. that they will waive the next interview for an E2 visa. So a lot of people are out of luck now. So there are probably going to be way more E2 visa interviews, which also can slow the system down. So that's what's going to be, that's happening right now. That just changed. In terms of if there's going to be a larger investment, like right now, substantial investment, we'll talk about what figure is substantial investment. I would say that figure is not going to change too much because that's the beauty of the E2, that it can be a small investment, could be $100,000, $150,000, could be less even. I've done them smaller, could be $1 million E2. But I don't think that number is going to change so much. I do think that the Buy American, Hire American policy that Trump puts in place could affect some of the E2s. It could be that when you apply for an E2, they want to hear, tell me about all the American workers you're hiring, because we want American workers to get jobs. So the E2, if someone says, I'm going to hire a lot of foreign workers, non-immigrants, green card holders, but not a lot of American citizens, I'm keeping an eye on that to see where the Buy American, Hire American policies will go. And I also would say that scrutiny of the cases, I think there'll be plenty more scrutiny of the cases. Sometimes I'm shocked what they scrutinize over. One gentleman, we just refiled his case again. Why did they scrutinize it? They said, well, you never ran a dry cleaning business before, and you wanted a dry cleaning business to run in the United States. So I'm thinking, for an E2, you never have to have the exact experience in the business you're going to be buying, but you need to have, let's say, managerial experience or, some business background. Just depends, but it's never so precise. Exactly. This man said I didn't have dry cleaning experience, but I have management experience. So he refiled it because we were like, this is ridiculous. And he just got it approved today, actually. So he's really excited. So some more scrutiny could be out there, but we deal with it as it comes. If we know what the rules are, we push on the rules. We know what the regulations are for E2s. So that's some of the stuff I think coming, some more scrutiny, maybe some more E2 treaties, which could be exciting. More American workers they're going to look for in some of these companies. The visa waiver, the being exempt from the interview, that's basically taken away. Everyone's going to be interviewed for extensions, for renewals, for brand new E2s, all that. So those are some of the changes that I could see coming.
All right. That's great. And I love the energy that you're putting up and, beginning our
I love
sessions.
this stuff. I don't know why.
Absolutely. I think everyone is loving, and that too, that's so great that you have put up so many different pointers, that too in very first answer. And I'm too getting a lot of questions in my mind, but I have to be very much particular about the topic. But with that, Jessica, I have just a random question from my side that you put up about trade and tariff from President Trump's administration. So, do you think that putting up tariff and trade, all these things may hamper the relationship between the two countries, majorly the US and the other one? Do you think they will have a hostile relation, or whether the relationship will increase and become better?
It's a very interesting time for that question because half of my clients are Canadian, and we see what's going on in Canada. Trump is taking a very tough approach, putting more tariffs, saying, look, we don't want to give you as free a ride as we gave you before, but there are neighbors. Mexico's our neighbor. And I still believe that we'll work this out somehow. But I do believe that it does factor in. I think because it's a treaty, an E2 treaty, the reason for it, the basis of it is because we have ongoing trade with another country. And we want to give our citizens and their citizens an opportunity to benefit, to build a business, to create jobs in the various, respective countries. So I still believe, I'm telling you, I've been doing this 27 years. It is a great way to come here. And even though there's tariffs and even though there'll be, more restrictions, I still think it's going to keep going because it benefits both countries. And it's all about, how can the U.S. get ahead? The U.S. has benefited so much by having all these E2 foreigners come here, create jobs for American, bring their capital here. That's all good stuff. For, to build an economy, that is all really good, what we want here. So I still think even with the tariffs, it's still going to be good. It's good news. I am so positive about E2s. I love them. Besides the fact I love them, I think it's just such a great way to come here. And it's not just for the investor, it's for the spouse too. It's the children. It gives everyone an opportunity to come here. So it creates a whole life for a family in this country.
Wow, that's great. All right, I'm sure E2 E2 visa applicants are really looking forward to this session, and they are going to have a lot of different information with this. So thank you so much, Jessica, for putting up those very important, pointers. As we are not having much changes, so I would like to know it generally that how is it going to affect foreign investors who are seeking to establish or expand businesses in the US?
So one thing you have with foreign investors is the currency. They have to see the currency. Like I've had clients, because I deal with a lot of clients from Canada, that say to me, well, I don't want to pull all my money out right away because of the currency difference. And right now our Canadian dollar is not as good as the American dollar. So they're slowed down a little bit of like, if they're going to do it, maybe they'll wait a little bit, see what happens with the economy or whatever. But overall, I think that the changes, because there's so few changes and because they still believe that America is a land of opportunity. I know it sounds cliche, but they still believe that they will keep coming. Even some of the changes that we see, like will there ever be a higher investment figure? They say substantial investment for an E2. They never give us what is the figure. So it's based on, they look at the whole picture. They want to see what does it cost to run this business. And years ago, I had a case of someone who invested $40,000 in an E2. It was a little one because I usually like them closer to 100, 150,000 investment. They invested 40,000. It was an administrative office. They would use their administrative office staff at different offices. They had very little overhead, and they only need to invest $40,000 in cars and computers and advertising, attorney fees, and that was it. And it worked, and that was like all they had. So will they look at the investment number and say, well, 40,000 is so little, maybe we want it to be higher? They haven't changed that yet. It's still out there. Your investment can be little. We like it bigger because we want to show that gross sales are strong and their net income of the company is positive. So it's very hard to show that the workers are going to be paid minimum wage 40 hours, 35, 40 hours a week. We need two of them for the E2. It's hard to show that if you buy a company that's so tiny and the gross sales are so tiny. So they look at the whole picture, and they're going to look at the finances, and they maybe even scrutinize it a little bit more to see, do we want to bring this foreigner here? Are they really going to have a productive company? They also look at job creation. They look and see, so you committed to 2 full-time workers, which is required for an E2. How soon are you going to get them on board? I like the workers on board right at the beginning. Even if I get 1 full-time worker on board within a couple months, I got the next one on board. But I really like the workers on board. And then the documentation. I mean, I had a client once, they were from Pakistan, and they had to prove every bit of where that money came from to invest in the US company. Not only that all taxes were paid, but also where did it come from? So they had to show their bonuses, their paychecks. They had to go back to the very beginning, and we had to get a letter from the employer confirming exactly what they paid them. And that was pretty specific. I usually don't have to get that specific, but it's out there. I mean, we go back to the origins. We really want to know who gifted you that money. Where did the source come from? Years ago, a client said to me, I'm so happy I got money out and I put it in a bank account in Switzerland and I never had to pay taxes on it. And I said, that's ridiculous. I can't help you with an E2. You have to pay taxes on the money that you're going to use for the E2 business. So these are some of the little nuances that, we're going to look for, and they may look for more as these E2 cases, and they're becoming more popular because as other categories max out, like H1B, some of the H1B people say, well, I missed the lottery. Let me try to create a business. So the E2 system can get, there's still plenty of E2s available, but it definitely, I think it's going to get busier, actually.
All right. And also, I would like to know, Jessica, that how much money do investors need to invest to apply for an E2 visa? This is the most demanding questions that most of the investors ask.
Yes, it's a very good question because they don't have an answer out there. There's no specific answer. Substantial investment they look at. So you could have, like I said before, I had a business, $40,000, that's all they invested. I tell people to stay around $100,000 to $150,000. So what does that mean? Let's say you find a business that cost $80,000 to purchase. Well, that's not 100, 150,000, but there's so many other expenses that are involved in making that business happen. Attorney fees, travel expenses, maybe you buy a car, other fixtures, any renovations. So now we're getting it over the 100,000 mark. So the contract itself doesn't have to be exactly 100, 150,000. If you're creating a business from scratch, you're going to keep track on a spreadsheet every time you pay something, and you're going to show proof that you paid for it personally as the investor. And you're going to keep track of all that till you get to a substantial figure. But what is substantial? I would say, look, as close as you get again to 100,000. But I have clients that say, look, all I can do. One gentleman, he was creating a painting business. I have some great stories, by the way. I've been doing this a long time. But one gentleman, he was creating a painting business and he
Mhm.
hired two painters, only needed so much money for all the painting supplies, advertising, overhead, office location, whatever. And that was it. He said, I can't get higher than 60,000. That's all I have. That's all I need to run this business. Another gentleman, he bought two trucks. Each truck cost over $100,000. That got him to over $200,000 his investment. He bought two trucks, had two full-time truck drivers, and he had plenty of opportunities to use the trucks to bring products to different locations. He ran the business as an E2 investor, and that was it. So it just depends. What does it cost to run this business? And the other thing I'll just mention is that when you're going to buy a business versus creating one from scratch, you can create what's called an E2 contingency clause, where you say to the seller that the whole entire deal is contingent upon me getting an E2 visa or a change of status by immigration in the United States. And either way, so then you're not putting all your money down. All of a sudden you're like, what? Why didn't my case work? You can, if it doesn't work, you get your money back because it was a contingency clause. The seller has to be willing to do that. And sometimes the seller wants a non-refundable deposit, a small amount, could be
Mhm.
5, 10,000 something, but it holds them for a few months while you're waiting for this case to get approved. And sometimes that's what the buyer needs because they're nervous. This is like, could be all their money that they've saved up and they're throwing it into a business and they don't even know if it's going to get approved or not. But
Mhm.
thank goodness I have a very, very good track record. I mean, I'm telling you, I do one E2 probably every week for the last 27 years. I'm always doing E2s. Always. And my track record is very, very good. In fact, one of my cases they use to educate their staff at the US Consulate in Toronto. So
Mhm.
that's pretty exciting. My client was like, they asked for permission to take that file and show it to the staff. I'm like, yeah, sure. Why not? So
That's lovely. That's lovely, of course. With that, Jessica, here's another very interesting question that most of our viewers are waiting for. That how do you see the future of E2 visa under the Trump administration?
I see it as great. I see it as great. I'm telling you, this is what Trump wants. He wants to bring in more capital into the country. He wants to create jobs for Americans. He wants industries to thrive. There's certain industries that are very popular with E2s, like salons are popular. I'm not saying Trump wants all the salons to thrive, but he wants certain, it definitely can build up different areas in our country. And it's a win-win. It's a win for everybody because there are people in countries they just can't wait to get out of there. They don't see a future for themselves. And coming here, it also doesn't take that long. And
Mhm.
E2 can be done either E2 visa at the consulate, which takes usually a few months, the whole process, or it can be done in the United States. If you come in as a visitor and you do a change of status, then
Mhm.
and you can expedite it. So you can get an answer very quickly in 15 calendar days. So it works. I see a great future.
All right, that's great. Most of our
Yeah,
viewers were really worried, the Trump administration, because we are going to
yeah,
hear a lot of executive orders nowadays. So they were really worried. But I think, as
yeah.
per your expertise, they shouldn't be, right?
Look, they can worry if they want, but that's what our job is as immigration lawyers. We hold their hand. We try to make the most successful case we possibly can. We look at the regulations, we look at what they have, we try to make it work, and then we give them the confidence they need to go to the interview or before we file the case, we make sure everything's there. And then that's it, we file. So we don't take cases that we think have a very difficult shot of working. I really want this to work for them because this is everything. Sometimes this client, it's all the money they have. And
Yeah.
we know that. We feel that. And we work with them on that. And I'm telling you, it's like immigration is a little bit like social work because you're dealing with somebody that this is everything to them. And I literally have clients say to me, do you understand? This is all my life savings. I had one gentleman tell me, my house burned down in this location, my house burned down in that location. This is all the money in the world I have, and everything I do, nothing ever works out. And I'm like, we're going to make this work because this is important to you. Yeah, that's how we do it.
That's lovely. I'm sure you are filled up with so much positive energy when any client comes to you, they are just quickly becoming so happy, right?
We
Just by
try. I'll tell them the truth too. If they show me how we do it, usually is a business broker gets involved. And a lot of times, if they want to buy an existing business, and I have to see the paperwork, I have to see, what are the gross sales, the net income, the employees, are they legal? And I tell them, look, so far things look good. Let's keep going. But if I start to see red flags right at the beginning, I tell them, do you really want to commit to something that's probably not going to work. Because you don't want to be going to that interview at the consulate and asking for a favor that, like, sorry, my case isn't fit so well, but please give this to me. We want to have a solid case when we go. And then they don't have to be so worried about, oh, what Trump going to do, whatever. But we always ask them right from the beginning, is there something in your background that prevent you from getting an E2 visa? Because they do. We have to know anything criminal, any, bunch of DUIs, we have to know. So we don't get to that point where they need a waiver at the interview and we're like, why didn't you tell us that you smoked marijuana and were arrested for it and it's in your record? Like, we need to know these things up front.
All right. Okay,
Yeah.
that's great. And here's another question, Jessica, about the key requirements. So, what are the key requirements for obtaining an E2 visa, and how can investors ensure that they meet these criteria?
Okay, so key requirements are: number one, substantial investment. Okay, we discussed it a little bit. 150,000 roughly, can be less, can be more, but substantial investment. It could be gifted to you. It could be your parents want you to have this opportunity to come to this country and they gift you $200,000, but it has to be a gift. It cannot be a loan. So substantial investment, you want to make sure you hit that around that range. You have to play an active role. So if years ago a gentleman said to me, I bought a gym, it's a 24-hour gym, everyone just goes in with their key and I don't have to do anything. I said, that is not a need. You have to be there to run it on a regular basis. You don't have to be there 9 to 5, but you have to be there regularly and know what's going on with your business. Also, you want to buy something that you're not hiring your whole family. So I have clients to say, if I'm going to invest in an E2, I'm going to bring over my sister, my aunt, and everybody. I'm like, that's not going to work for an E2. You have to create jobs for people other than your family. So there's something out there called marginality. And if they deny your case because of marginality, it's because they feel that you do not make enough gross sales to cover the expenses to run the business properly. And they call it marginality, and you don't want that. You also have to have intent to depart. So I had a client once went to an interview and said, yeah, I sold everything off, my house, my business and everything, and I'm just waiting for my E2 to get approved. And I told him, you don't do that. You have to always show in the interview at the consulate that you have intent to return to your own country, that you have something to come back to. So it's important that you have that too. So these, and also that all taxes are paid and the money was received legally. That's another thing. I usually don't have this issue, but if you got it through drug sale or something, terrorism or something crazy, like, it's going to be a problem. We have to know really the legit source of that money. And then a strong business plan is key to these cases. They want to see over a period of time, over 6 months, 1, 3, and 5 years. They want to see, how are you going to build this business up? Who are you going to hire? What are your gross sales going to be? And then we do strong comparative market analysis in the business plan to show similar businesses and how yours is going to thrive like theirs. And we put all that together, and usually it's several hundred pages, and then we have to shrink it. If you file with the consulate, you have to shrink it to the amount of pages they require. And for example, Canada is 50 pages. So my clients are going to be like 200 pages, and I have to spend time just shrinking the case to like 50 critical pages. And then the rest they bring with them to the interview. So those are the keys. And when you hit them, that's it. You hit these requirements, you can have a great case. I also want to share, though, sometimes you see a case and it has potential to be a great case, but it's not a great case, meaning like the numbers aren't so great, but you're going to build it up. So immigration says, show us in a strong business plan. We want to see how you're going to build it up. So if your gross sales are good, but you have a negative net income, even if it's 10,000, 100,000 gets harder to justify. But let's say there's a lot of deductions on the tax returns or whatever. If we can explain what happened, what went wrong, and this is how you're going to turn it around, sometimes those cases can work nicely too. So I wouldn't say every case has to be really strong net income, really amazing gross sales. We look at each and see, can we turn this into an E2?
All right, that's great.
Yeah.
Also, here another question, Jessica, that have there been modification to the minimum investment amounts or the types of investments considered eligible for the E2 visa?
So there hasn't been changes to the minimum investment amount, but the types of investments considered eligible for an E2, I would say now with a lot of remote work taking place, they've opened up themselves a little bit more E2s to some more remote, like remote offices, but you still have to justify, why do you need to come to this country? So if you have a business that all runs remote, like it's a sales business, you sell a product online, maybe you have a factory in the US, and maybe we could show how you have to check on it regularly or something like that. But when they come to me and they say everything's remote and I just need, workers in this state and another one in that state, and I'm like, it doesn't work so well. Like I had a woman years ago that she had a facility in California that made facial products and for skin and stuff, but her headquarters were in New York. But I explained that she has to go back and forth, and she really lived in New York, but most of the activity of her business was California. But we explained she had to go back and forth regularly, so she needed to be in the United States. But with so much remote work, people try to say, well, it's just all remote. And I'm like, you got to create a little bit that's not remote to work for an E2. But other than that, the types of investments, well, the thing is, people always call me up and say, I bought a house and I want to flip it. And I'm like, E2s, you flipping houses does not work for E2s, but let's get creative. There are ways to do things with the house, a house business. For example, you could have joint like apartment complexes, several of them, and say, look, I need to hire a manager, renovation person, et cetera, and turn into an active business. When you buy one house and you flip it, it's not active. They don't like that. But there are a lot of ways to. I had one lady who she would buy the houses, she would create financial mechanisms for people to live in the houses, and then eventually they would buy the houses from her. So her business was the financial part of it. And that was the active part, even though she owned all the houses. But you can't just, one guy's like, I'll buy a house, that's my business. I'm taking care of the house. I'm like, no, that does not work for any two. It still doesn't work for any two. So
All right. Okay, that's really interesting. Also, Jessica, why is the E2 visa country specific? We know it's obviously a country specific, so we
yeah.
want to know the reason. And why is it available to citizens all countries like other visa types?
So the beauty of the E2 is we say to another country, you have so much trade and interaction with us at a business level. We want to continue that. And this is another way of continuing that by having E2 treaty that we have, and they have something similar in their country. For example, the country of Israel, we didn't have it for so long, and now we have it because there's a mutual agreement that they have an equivalent that if our American citizens want to go there and build businesses and hire workers, whatever, they have something equivalent to our E2. So that is why, because we have these ongoing relationships, and this just continues that relationship. But there are certain countries we don't have relationships with, like Iran. We have no relationship, no E2 with Iran, but there are other countries that who knows what'll happen maybe that will get it. I mean, New Zealand just came on board a few years ago, and there's a lot of talk about Greenland. We don't know what's going to happen with that. There are countries out there that are very interested in this relationship. So, but it's not with every country. That is true. And as I mentioned a little bit earlier, that it's very interesting the date that the treaty started can be 1850s, can be early 1900s. These relationships have gone on for a long, long time. So that's another reason why I don't think they're just going to go like that. There are changes that have come between the agreements that we have with countries, like France originally had an E2 visa, it was a 5-year one. Then they took it away and made it a 2-year visa they issue. Now we're back to 4 years. So sometimes the agreements that we have for the E2, there are adjustments that come about, but they give a lot of notice if it's going to happen usually.
All right.
So,
But Jessica, talking about the country's relationship, if we specifically talk about India, then India doesn't count in the E2 visa, right? But
right.
similarly, we have seen President Trump and Prime Minister Modi, they are having a very good relation. And not too in the second term, but also during the first term also. So, is there any chance that India can also count under the list of E2 visa, maybe after having good relations? Or what's your call?
Right. This is a good point that you make. The issue also becomes there are certain countries that the population is huge, like mainland China, India. If you look at the visa bulletin, where they're seeing, the certain amount that we issue of green cards to certain countries like Vietnam, India, Mexico, there are so many people wanting to come here. But I think there are a lot of factors that play into which countries we have the E2 treaty with. And I think India would be flooded with candidates if E2 visa came about. This is just my own personal thinking of this, or mainland China, we would be flooded with them. So part of it is the ongoing relationship we have. And part of it is we have to look at the numbers. What would this do to our country if we open the doors to certain very large countries? Look, we do have it with Mexico. Right, we have an E2 treaty with Mexico. That was a long time ago. It was established. Our relations are tenuous right now with the border and all the issues there, but it hasn't really been talked about that we would get rid of it. So there's probably a lot of factors that go into why do we have an E2 treaty. I'm only mentioning a few, but there could be behind the scenes things like, for example, with Israel, there was a lot of visa waiver overstays.
Yeah.
So that was delaying it. They were like, Israelis need to stop overstaying on their visas. They respect our laws. And then, they were working out all the little details. So I don't know what ones are in the on the burner, so to speak, right now. But I'm hopeful that there will be more countries that we do have it with.
Absolutely, because nowadays we are seeing that we don't know whether the relationship are being very friendly or not with USA, but at least with India, we
Mhm.
have been seeing a better relation, and as compared to Mexico, Canada, the other countries who have the E2 treaty. So I think let's hope, and if you are saying, then I'm sure our viewers would be hopeful, and they should also be positive about it because most of our viewers are really looking forward to the E2 visa. So
I hear you. And I love the E2 visa. I don't care what country it's from. I'm happy to help any country. I've done some very interesting countries, E2s, and all the requirements are very similar, usually all the countries except for the UK. UK requires that you have physically lived in that country for 1 year before you file for your E2. Yep. And now it looks like Grenada and Portugal. These two countries, there's a way to become a citizen, and then you have to wait a certain amount. If you got it through a financial investment and you became a citizen, you have to wait a certain amount of time before you can apply for the E2. It's sometimes a 2 year waiting period or a 3 year waiting period. But that's another path in. If certain countries do not have E2 visa and you become a citizen of these countries, within a matter of a few years, you can apply for the E2. That's what some people do if they don't have a country that has E2 treaty. It's an unusual way to do it. You want to be a citizen of those countries, then go for it. You know,
all right, that's great, and I'm loving that. But Jessica, I really don't want to take a break, but I think it's almost 30 minutes, and we didn't
oh,
even realize that. So, friends, we are just taking a short break. That will be 2 to 3 minutes break, not more than that. So don't worry, we are not going to keep your wait for long. But till then, you keep on posting questions, keep on commenting, and ask as many questions as possible. And we are here definitely, and we will try our best to ask and as I mean to answer all the questions as possible. Till then, you can also look for the contact detail of our today's attorney Jessica Ways. The contact number is 888 and the email ID is jessicaw at com, and the website is www.attorneyjessicaways.com. So please go ahead, and you can also contact her, and you can let her know about your immigration journey, about your concern, what process you are going through, or what complexities you have. And I'm sure she is going to give you the best advice. So, with that, friends, don't go anywhere. We'll be right back. So, keep watching Immigration Talk Show. Hello, everyone, and welcome back once again to Immigration Talk Show. And now we are going to have a second segment of this episode. Till now, we have been going through a great discussion with none other than, I would say, wonderful and great attorney Jessica Weiss. And today, the topic that we are discussing is very important. What should investors know about the E2 visa changes in 2025? So till now, we have gone through a lots of information. What will be the future under Trump's administration? Then, what are the key requirements? How the investor should invest? What are the key pointers? And also about minimum money. So till now, we have gone through a lots of information, and now I think let's pick up our viewers' question. But with that, Jessica, before diving into our comments, I would just like to ask one more question because I think that is very important to answer. And that is, what are some common problems that investors face when they apply for the E2 visa?
Okay, so some of the common problems I would say is that the investment amount is too small. You have to watch that. That they don't have the hired workers properly. So, meaning like if they have one full time worker, they don't have any plans to hire another worker. That's a problem. That there needs to be a role for them and need to clearly have a role, and it cannot be hands on. So, if you own an ice cream shop and you say, I'm going to be scooping the ice cream at the interview, that's a problem. They have to understand they are CEO, they're overseeing the operations, and they have to make that clear. In terms of, I would say during due diligence, the whole due diligence process while they're buying an existing business, a lot of them don't have the financial background. So they rely on a business lawyer to help them understand, but they have to make sure it's a legit company they're buying. On paper, everything can look legit. Some of my clients literally like park their car outside the business and see what the foot traffic is like and stuff. Because this is something I always tell them, buy a business you like and buy a business that you think is going to last, because we need this to last. Because as long as you're here in your E2, you've got to keep your business going. And they joke around, people say that E2 is like the retirement visa, because you could buy it, you could be 70, 80 years old, and you could buy an E2 business, but you know what? You still have to take care of it. But a 70-year-old can check on their business on a regular basis, and they do. And so it is like the retirement kind of E2 business, because snowbirds want to come here and eventually they love it here. And so I'm in Florida, so snowbirds. So eventually they love it here and they're like, how can we stay here longer? So that's my business, and they run it, for the rest of their lives, or they turn it into, they find it somehow switching into a green card. And I know we didn't talk about that really too much, but there are ways to go from E2 to green card and not just EB5. I do that. A lot of my clients, we go other ways to come here. It is possible. And I get that question a lot. Like, okay, now I'm here on an E2. How do I stay here long term? And I tell them, as soon as you get in here, let's talk, because let's set it up the right way so you can have, a long, long time in this country. So,
All right. Okay. So I think we have come across with lots of questions. And
great.
I can see, Jessica, we got really a great amount of engagement here. Vihan, Trizer, then Arpita, Vihan. I'm really confused whom to take first, but let's take up Vihan's question. Vihan is here asking, looking ahead to 2025, which industries or business sectors do you believe will be the most attractive for E2 visa investors, considering the potential changes? Yeah.
Restaurants are coming back. During COVID, it was very difficult. E2 companies really suffered, but they're back. Restaurants are back, salons are back. A lot of the services that people need to go into to get those services, they're all coming back. I find even a simple coffee shop does very well for an E2. You have two workers, a certain amount of income coming in. So that whole industry, restaurants, I think very nice for an E2, and can slide you sometimes very nicely into an EB5 too, a green card. I would say other areas, I think real estate will come back, not flipping houses, but could be all sorts of things related to real estate. It could be property management companies. It could be any kind of renovation business, like window wiping business. All those areas that are related to real estate can come back too nicely. And it could be something completely like, who would think like a dog grooming business? Well, there's never a shortage of dogs. So those kind of like narrow, even newspaper, like, I don't know, some people have newspaper routes and stuff, and that, like, we get creative. The point is, like, there are certain industries that, yes, I think will be more popular now, because now that COVID's long gone, they will be better. But we don't care what industry it is. Like, we'll try to help you. If you have a dream, I always tell people, if you have a dream and you want to make a business in the United States or buy, let's help you, because I want you to buy something you like. I have clients call me up, they're desperate, just find me anything, whatever. I'm like, no, you really should find something you like because you're going to spend your time building it. So,
Absolutely, that's very well said. Thank you so much, Jessica, for putting up this very interesting, I would say, information. And Vihan also, thank you so much for putting up this question. In case if you have any follow-up question or would like to know more from Jessica, then please go ahead and ask those questions. Santosh is here, and Santosh is asking, are there any expected changes to the process for renewing or extending an E2 visa? For example, will there be more leniency or stricter evaluation process after 2025?
so there's two ways, as you can see here, renewing or extending, you said. If you do what's called a renewal of your E2 in the United States, you get 2 years to stay here. Those cases, I believe, are scrutinized more, and you don't get a chance for an interview. But there are situations where people just want to renew here and they don't want to go to a consulate to get another E2 visa. So when you have that, they're going to scrutinize them, and they could scrutinize them more, meaning they're going to look at, tell me about your gross sales. Let me see your tax returns the last few years. Were they positive? Do you have a positive net income? Do you have two full-time employees? Did you have a gap and you didn't have two full-time employees? Why do you have a gap? So these things are going to get scrutinized, I believe, more if you do it as a renewal in the United States. In terms of going to a consulate, again, it's so based on what officer is interviewing you, right? So you could have an officer that knows their stuff and knows exactly what to ask you, and one that's clueless, and you're just like, why are they asking me this? My attorney prepared me, and it makes no sense, but they have the power. So they have the
Mhm.
power. They can ask you whatever within the requirements of an E2 to evaluate it for the strength of it. But I think the E2 visa interview is your chance to address any
Mhm.
questions, any concerns they have. And I think, will they scrutinize it more? I would say the general trend is right now that everything's getting scrutinized more, but I don't see it to the point that it makes it so difficult. E2 visas overall, it's very, it could be 80, 90%, like a huge number get approved. It's a very high number of the approval rate for E2 visas because we don't file them unless we think you have a very good shot at it. We're not going to waste everybody's time and everybody's money. So that's where I see. Will there be more leniency? I don't see leniency. No, I don't think we're going in that direction. But I don't see it's an impossible situation. But I do think consulate processing
Mhm.
still is a little bit easier than doing a chain extension of status in the US.
All right, all right. Okay. Thank you so much, Santosh, for putting that question out. And let's move ahead with Ananya's comment. Hi, Ananya. Thank you so much for being here and participating. Ananya is asking, with the potential changes in the E2 visa policy in 2025, do you anticipate that there will be variations in eligibility for investors from certain countries?
Hmm. So, as I work mostly with Canadians, or at least half my clients are Canadian, when I saw in the news all the things with the tariffs and restrictions, and I thought, oh, I wonder if they'd stop their treaty. I
Mhm.
still think they're very close, and I don't see that happening. I mean, don't quote me, whatever. But where do I anticipate any variations or changes? It's really the regulations are codified and there's certain set criteria. So if a consulate wants to be more specific, like the UK is like, okay, we have a 1 year physical presence requirement in the country, consulates can do that. But the overall requirements, I don't see. I don't see that there's going to be a lot of variation. Even in countries, I've done E2s in so many different countries, it's the same criteria and it hasn't changed. I could just see maybe like what happened in France. Like a country says, no, we don't want 5 year visa anymore, with America. So they change that. So some of the terms of the agreements, the amount of visa, also the filing fees can change. They could increase them. You could have a larger filing fee when you apply for an E2 visa in certain countries. So
Mhm.
some of that stuff, but not the basic criteria. No, I don't see that. I don't see changes in that.
All right. I think that's a good thing, if not the basic things are being changed.
It is because it's a great way to come here, and they think, oh, it's $1,050,000. It's not. They get confused because EB5 is the 1,050,000. E2 is tiny, it's way tinier, and even though $100,000 is a lot of money for people where they make so little per year, 100,000 is a very big figure.
Yeah,
So, but it's not. You don't have to hit the 100,000 for an E2. You just has to be. It makes sense. What you've invested makes sense for what you need to run your business.
absolutely. And that's the main important thing that everyone is noticing.
Yeah.
All right. And okay, so here's another question from Ananya, that are some countries expected to benefit more than others from these changes? All right. Okay.
Well, see, there aren't a lot of changes taking place, except some of these. to not have to have the interview for the E2 visa, that it was
Mhm.
waived. So certain countries, then things would process a lot faster. So now, if they have to have interviews all the time, every time you want another E2 visa, certain countries, the E2 visa is not 5 years. Sometimes it's 6 months.
Yeah.
Sometimes it's 1 year. So you have to, every time you want to come to America, you can come in, you get your 2 year stay, but when you leave, if your visa is finished, you got to go get another visa. So some of these countries, they don't qualify for a waiver of the interview for the E2, it's going to get backlogged. Do I know all the countries this is going to happen to? No, I don't know precisely which ones, but it could cause some delay in some of these countries. But there's always expedite request. If you need it, if there's a real emergency, you can try to approach the consulate and ask for an expedite, and it's up to them.
Absolutely, I'm sure. All right, the contact details are on the, I would say, the end of this bar you can see. And with that, thank you so much, Ananya, for putting up this very important question. And let's take up Raghav's comment here. So, Raghav is asking about can you explain how the revised E2 visa requirements will impact the duration of the visa and the possibility of renewal or extension for investors?
Well, there aren't a lot of revised E2 visa requirements other than the waiver interview has changed. That just changed. The impact of it, well, right now, some of these consulates, it's 2 or 3 months, right? They have to review the file. They take like 2 months to review it, and then they schedule you for the interview. So will it get worse? So then they could take longer. Some consulates could take 4 or 5 months, so it could cause a delay in that sense. In terms of it says extension. So extension's different because that's in the United States if you're extending the E2. So when you
Mhm.
extend the E2, what are any of the revised changes or anything? Well, again, if they're going to see that you have employees and there are very few Americans that you hired, they could come down tough and say, please explain your strategy for hiring more American workers. We'd like to hear it. So we don't know how that's going to filter in to the cases in the queue or the ones that are just going to get filed. What we do know is that if you have strong gross sales, usually if it's a small company, we see a couple $100,000 in gross sales. We see a net income with, even if it's 10,000, it's a positive net income. And we see over several, the financial statements look good. You should be okay. You should be okay for your extension. And we tell them, you got to work on it. I have clients that they have problems, that their financials don't look right, and it comes time for the E2 visa renewal. So what we tell them is, if you have a 5 year visa and you have, let's say, 6 months left on it, we tell them leave the country, re enter. That gives you another 2 years to stay here. Because every time you leave and re enter, you can stay another 2 years.
Yeah.
So the EU visa, although it's going to expire while you're in this country, you still
Mhm.
get to stay another 2 years, which gives you maybe another two tax returns possibly to fix the problem. Because if they can see that your most recent tax returns look good, then
Mhm.
that's what helps get you that extension or the renewal. And so that's what we tell them. We have to strategize sometimes so that they can have the strongest case. And sometimes we can't. Sometimes we just tell them it's a mess. Your E2 is a mess. You're not going to get a renewal or an extension. It's time to close up shop and do something else. And if we can transfer any of the assets and they start another E2, we try to help them with that too. Because we don't want to give them a dead end. We want to find a way for them to stay here. That's what they want. That's
Yeah.
our goal. The worst thing an immigration lawyer has to do is say, I'm sorry, there's nothing I can do. Please leave. You have to leave the country. That's the worst. If we have to say that, it's like, it's so sad. I spend all day because I do all different types of cases, marriage cases, telling people,
Mhm.
okay, you're getting married, congratulations. I have to tell a guy, fly to Vegas to get your marriage certificate faster than whatever. I tell people all the time, leave, stay, when are you getting married? Are you buying this business? These are critical things for people's lives, but we
Yeah.
do it because we want to make the best case for them. So,
Absolutely, that's beautiful. Thank you so much, Jessica. For putting these very important pointers, and that too in a very positive way. Our viewers are really filled with lots of positiveness, and because
it's
they
good.
learn about two visas, and
It's a
I'm
stressful time for me, so I'm glad that I can give that positive over because our field, I just attended an immigration conference last week. There were two classes on happiness. And I'm thinking, what do you need to give us happiness classes for? But our field is so stressful because we want to help everybody. And the Trump administration has so many laws and executive orders and things coming our way that we just have to digest it all and just try to do the best we can. We have
Mhm.
clients, yes, we have to tell them it's over. There's so many things going on right now in our field. But we try to give positive. Positive is that E2 is still a great way to come here. That's the positive.
That's great. All right. Thank you so much, Jessica, for putting that up. And Raghav, also, I hope you got your answer. In case if you still have any follow up question, then please go ahead, and we are definitely going to answer that. Arpita is here. Arpita has another very good question. That what is the potential for increased scrutiny in E2 visa application due to the 2025 changes, and how can investors navigate these challenges?
So we are like a surgeon. We go at the case like everything that there is a gap or something that doesn't seem right, we're like, fill that gap in. Okay. So we start with, where did the money come from? Tell us all the sources. One
Mhm.
guy says, "Oh, I didn't have to pay taxes on it." I said, "Give me an accountant letter explaining why there was no taxes required, because immigration doesn't know your tax laws and how they work." Then the money's transferred. We show the proof of that transfer. We explain where it came from. We have them sign a detailed statement of the source of the funds. We deal with every issue of the E2 case as precisely like a surgeon as we can, so we can leave no gaps. And that is what we're doing more than ever. That's one of our bigger changes, is that we always filed strong cases. We did our best. But based on my experience and what I know now, when my clients give me feedback after interviews and things, you know, this is what we have to do now. We have to make it even more precise. We don't want a client coming back and saying, "We hired you, you had all this experience, and what happened?" We're like, "No, we're covering." And even when a client pushes back and says, "I gave you enough stuff, why are you asking for more?" We tell them it's 2025. Trump's our president. We have to be even more precise. So that's what it's done. That's what 2025 will be more about. A lot more precision than what we do.
Right. All right. That's great. Okay, thank you, Arpita, for asking the question and participating in our webinar. Pooja is here with another question, that what are the most common challenges that investors face when applying for the E2 visa? And with the anticipated changes in 2025, do you foresee any new obstacles for applicants?
So obstacles is something that's negative. I want to say E2s are there's there's a path. There's a way to come here. There are great opportunities to come here. So I wouldn't say I foresee obstacles. I foresee opportunities. There really are opportunities. I mean, I have clients that search and search and search for businesses, can't find anything that exists, and they're like, "That's it, I'm creating my own." That's an opportunity. They're creating their own business. And then we talk about how being very precise of all the things that we need, and they have to get their funds in order, but sometimes they'll contact me like a year before they even start the R2, because they just want to make contact with an immigration lawyer before they start the whole process. They want to understand, what are the challenges, what are some things I need to be aware of. Like, I'll have a client call me up and say, "Well, I have $100,000 and I gave it to my friend in the United States and he's going to put it into the business." And I'm like, "That's not how you do it. It has to be in your name, and the transfer has to be from you. You can't just give it to a friend for an E2." So they'll call me if they made a mistake, and I'll be like, "You should have contacted me 6 months ago." I've had clients have to redo deals because they don't set them up right. I've
Mhm.
had a client that said, "Look, it's $1 million. I'm going to put 200,000 down. I'm going to do a seller carryback note for the other 800,000." I said, "Well, look, it's not really going to work, because substantial investment, they look at what it costs to run the business. But tell me about the business." So he says, "Well, it's really a building. I'm buying a building, and the active part of the business is really 200,000. 800,000 is the building." So I told him, "You know what? Break it up. Have a contract for the building, 800,000, and pay 200,000 and buy the active part of the business. That's your E2." And that's how we do it. Because otherwise it makes no sense. You can't really do not like you securing a loan from the business that you're buying, because they're afraid they give you the visa and then all of a sudden you're like, "Oh, company didn't work out, but oh, I still have the visa." They don't like that. So.
Absolutely. And I think those are, very important guidance that our viewers should really know about, because just for the sake of friendship, they are being into such a big obstacle. But I think that's not how it should work. So I'm sure that these pointers are really being going to helpful for them.
Sam,
So
I
yeah.
will just tell you one other thing also, that I feel like sometimes people are discouraged because they need it to fit into a precise box in order to work for an E2. But we don't do it that way. We look and we see what you've got and what you want to build and what's going on right now. We try to make it work if we can. We
Yeah.
try, because they bring us their dream businesses and we're like, if we can make it work, we'll try.
Mhm. All right. Okay. Let's move ahead with another question that I got from Vihan. Vihan is here asking, what are the specific legal and financial risks that investors need to consider with the revised E2 visa guidelines in 2025, especially if the investment does not meet expected returns?
So on your business plan, you have the projections. In 6 months, what you're hoping to get from the business, in 1 year, 3 and 5 years. They do not lock you into those projections. Those are just rough estimates. So if you can't bring in what you thought you'd bring in, they're not looking at your case every year. Only when you do your E2 visa renewal or you do your extension of E2 status. And then they're not going to say, by the way, you said in year 3 you were going to make this kind of money. So what happened? Case denied. It's not
Mhm.
like that. Those are just projections. What's really important is they want to see, do you have enough money to pay your bills? And let's say you don't. Let's say 1 year you don't have enough money. So let's say you're a wealthy individual and you're going to put more of your money in to help the business grow. Well, you're going to have to explain that. If it comes time for the renewal or the E2 extension, you're going to have to explain, look, I had difficulty. It could be an industry that suffered, or you could have been, let's say it was a hurricane or something happened and it's explainable why your business suffered. Then you can explain that when you file your case. And usually with a valid explanation and to show the potential for growth that you're coming out of that rut, you should
Mhm.
be okay. So it's just very case specific. If there's really financial loss or risk and what happened, we have to explain it.
All right. Okay. I think let's take Trizer question here. And Trizer is asking that, hi, I have a business partner. We are in the process of starting an offshore IT and production studio. Now, during the E2 application, which should we focus on as a company works on both aspects?
So I will just wonder where this business is located. Okay. Because if it's offshore, and they also have a production studio. So I'm
Mhm.
wondering if the production studio, I assume it's in the United States. So this is where we talk about how much time does the person physically as the investor need to be here. We want to make sure we build something here that they have to come and check on regularly. Otherwise, it becomes everything so remote it doesn't work. But the focus should be on the sales, the clients, the employees that they have. That's to build it up. That's what I would say, and make sure that there's enough activity going on in the U.S. It's not all offshore.
All right. Triza, you could let us know from which location you would like to have a business on, so that we can give you a better advice on that. Next, I would like to go with Srujit's comment. Okay, and Triza here also had a comment that your show popped up on my feed. Found it interesting.
I try.
Absolutely. It's really interesting. Okay, we are based in India.
Oh, India. Okay, yeah. So that's pretty far. Okay, so he just needs to the production studio. I assume it's in the U.S. That's why he's wanting to come here.
Mhm.
By the way, this is all about E2, but don't forget there's something called E1. So if he has a majority of the trade or services are between the US and their home country that they're providing, then that could be an E1. And majority means substantial means at least for 1 year, there's been trade or services. And substantial is usually 150, $200,000 in sales, but it could be anything. It could be services like IT services. It could
Mhm.
be trade, it could be a product that's made in, let's say, India, and they're selling it. Majority of their sales worldwide are with the United States, and they're substantial. That's E1. I didn't say anything about the amount of investment. There was no substantial investment. It is an easier way to come here actually than an E2, but you have to fit the box. It doesn't always fit for people. So it's out there though, E1. And we have to have a treaty, of course. So
That's right. All
yeah.
right, Trizer, I hope you got your answer. And in case if you still have any follow up, then please let us know. Meanwhile, Jessica, we also have some questions from our Facebook group as well, because there also we have a lots of viewers over there. So I think let's take some questions from there as well. So here's another question: that can we travel on B1, B2 if we have applied for EB2? Any issue in it?
Okay, so EB2, employment based, that's the second preference. um, so that's green card application. So B1, B2 is temporary. That's a way to come here as a business or a visitor. So the question is, what ties do you have in your home country? And when you're coming in as a visitor, there's a officer who's uh, seeing you when you enter America, does he, CBP, really believe you're going to return? So just having an application in the system doesn't mean you can't come in on a B1, B2. But if the officer sees it and feels you don't have enough ties to return to your home country, then they don't have to let you in. So we do entry packets. We put together a whole packet showing what your ties are there, what you're doing here, and then we prepare you. So hopefully you can get in because the process can take a lot of time. It can take several years before you actually get the green card.
Yeah, that's right. Okay, let's go ahead with the next question. Hi, I'm an E2 dependent spouse, currently pregnant, due on March. Will the birthright citizenship removal take effect that soon, or will it be on hold due to 22 state lawsuits contradicting it?
It's on hold. They're waiting right now. It's being litigated. So I don't know what's going to happen. We don't know if it'll take
Mhm.
effect. Yep, stay tuned. But anyway, March is pretty soon. So it's on hold. So having that baby in March, you know, it sounds like you'll be okay, but who knows what the, if the courts speed up the case or not. But yeah, we don't
Mhm.
know.
Absolutely. Let's see what comes at the end decision, and we all are hoping for the best. All right, let's move ahead with the next comment.
It's the same thing, the birthright issue, right? It's a problem. Non-immigrants who have kids born here, this
Mhm.
is what it's about. They don't want to give them citizenship. Trump doesn't want them to have automatic citizenship. So yes, they are affected by this if the rule goes into effect. And then there was going to be a procedure. There should be something in place of how they turn into an E2 dependent, right? Because if the kids were born here right now, they're probably not E2 dependents. So there has to
Mhm.
be some procedure in place to get them the proper paperwork.
That's right. Okay. I think we got this another question. And Control, if you could let us know about that question, please. Okay. I think we might have. Okay, I think Jessica, there might be some technical issue regarding the FB questions, but not to
Oh,
worry. We do have still a lot of questions, from our viewers. And okay, let's take up one or two questions lastly, and then okay, here we have Yash question. How will the 2025 E2 visa changes affect the ability of foreign investors to hire employees from abroad, especially from their home country? And are there additional steps they must take for this?
so I think that they're referring to the E2 qualifying employees, right? So you can be an essential worker, you can be a manager executive. So the criteria, again, everything will be scrutinized. We need to be more precise, but same criteria. You have to have the same citizenship as the E2 investor. You have to be coming here to work in a capacity as a manager executive or someone with specialized knowledge and skill. And you have to show that you have that experience to do that. So, and then they issue you the visa. And depending on our treaty, how long that visa is valid for, and the dependent spouse can work while you're on your E2 qualifying employee visa. So, yeah, that's the process.
All right. Okay, next up, let's take up Kunal's question. Kunal is here asking, are there any new pathways or benefits for investors looking to transition from an E2 visa to a different permanent visa or green card options following the changes in 2025? Yeah.
It's a very interesting question because right now, the EB5 is the most popular way. And it was not the most popular way because it was such a long process. It was like 4 or 5 years. Now it's a 2 year process because if you're an E2 and you file the first part of your EB5, you can file the second part, which is called adjustment of status together, which means you
Mhm.
can apply for a work permit and travel document. The whole thing can be filed together. Some of these other categories, you can't do that. EB2, EB3, you can't do it all together if your priority date's not current, which it's not for these categories, but EB5 is for certain categories. So this is becoming popular. And what's also becoming popular is the regional centers. So regional center says you need to invest $800,000, not $1,050,000, and put your business anywhere you want. You invest in a regional center. So I asked one of my peers, I said, what if you don't have $800,000? And he says, you would be surprised that people either take equity from their house, they have relatives that are wealthy, they are gifted money from friends or whatever, and they make it happen because they want that EB5. And this right now, we see that EB5 is getting very popular. And I used to say EB3 was the way to go, but it's backlogged. And EB5 really is, even though it's a 2 year conditional green card you get, if you've invested the money, the regional center helps you create the required jobs, and then you have to remove the conditional status after 2 years. But people are doing it. They're finding ways to get that money. But that's what I see for 2025. EB5 is very popular.
Absolutely.
Sure.
That too. Thank you so much, Jessica, for taking all these questions very patiently and answering them in a very detailed way. So, again, I would say thank you so much. It's really appreciating. And I think, Jessica, we already crossed 1 hour. So, with your
Sure.
permission, I would just like to know, would you like to answer more questions or should we put an end to it?
I think a lot of the questions are a little bit similar, like because they want to know in 2025 what are the changes, how will it impact them, and I think we addressed a lot of them. So I
Yeah.
think that's good. I just want to share one other thing that I offer a free brief consult so people know to anyone who is thinking about doing an E2. It's usually 10 minutes or so, but it gives them a little bit of direction because a lot of lawyers just they get on the, they're going to have a consult, charge right away. But a lot of people just want to get some of the foundation. And also my website is very helpful. I made charts talk about the E2 process along with other processes, and it shows the steps and stuff involved in the requirements. And I think that's really helpful too. So if people are thinking about, okay, this E2 sounds interesting, that's where I would start. And they can always reach out to me. But I think for now the questions, because they're all a lot similar questions, that I think we've addressed like what changes 2025 and how concerns and any financial concerns. And they just have to like find that right business and just call an immigration lawyer or me and you know just get started.
Of course, they will because I can see a lot of questions here, on our webinar, and because viewers are really loving this episode and they are having a lots of queries regarding that. But don't worry, friends, keep on posting as many questions as possible. We are definitely going to take them up, maybe if not in this session, in our next session. But with that, Jessica, thank you so much. We have come across 1 hour. We didn't even realize. So it was your first time with us, and it's not only me who enjoyed. I think everyone enjoyed this session a lot. So we are really honored that you are here. Thank you so much for taking up this time and investing it here. So we really enjoyed, and thank you so much for being here.
And thank you so much as well, because I love educating people. And without education, you cannot make the decisions. So that's what I do. I give you all the information, and the client makes the decision what's the best for their family and their lives. So thank you very much.
That's lovely. We love the energy that you bring us in this show, and also the insights were that too very helpful and wonderful, I would say. So again, thank you so much, Jessica, for being here, and we are looking forward to have more shows with you.
Thank you.
All right. Thank you so much, everyone, for being here and asking a lot of questions. I'm sure if you guys are not very much happy that we didn't take your question, but don't worry. We have asked all the questions, and in the next show we are definitely going to take them up. So till then, don't forget to like, share, and subscribe to Immigration Talk Show. We'll be coming up with very exciting webinar, and that will be lined up just for you. So make sure to press the bell icon also so that you can get notification whenever we come live. Until then, everyone, take care. Don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. It's me, Sam, signing off for now. Goodbye, everyone, and take care. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information shared, including user comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, We are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. And don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. With that, folks, today we are here with another very exciting and very important topic because H1B season is here. And if I'll ask you a question that are you fully prepared for the H1B lottery 2025, then I'm sure you're not confident enough to say yes. But after the show, I'm sure you will be. Because today we are going to explore a very timely topic that about H1B registration system that is recently a very new change has come up over there. What it is, how is it going to increase your chance for the lottery system in 2025, and also how is it going to impact everyone, the employer, the employee, and what will be the outcome for that. We are going to have a great discussion on this webinar, and to help me out and to make this session even a wonderful one, we have a very special guest with whom we have shows on every Wednesday at 12 p.m. A very well known expert in immigration law, attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. So, thank you so much, Prashanthi, for being here. And it's our first time that we are connecting together and having a show together. And I'm really excited. So, thank you so much for being here.
You're welcome, and I'm looking forward to this show.
Absolutely. It will be wonderful as your every shows go with. All right. So, Prashanthi, before diving into our questions, that we have prepared, I would also like you to let us know so that, our viewers can get a better understanding about the change that happened in the H1B registration system.
So, I guess just to give you a background about what to expect this year with the H1B registration system, the biggest change is that the registration is now $215. It was $10 earlier, so that's a big change. The registration fee has gone up. We were expecting that last year, but by the time the law was actually passed, it didn't come into effect last year, but we knew that it would come into effect this year. So that's the biggest change. The registration fee is now $215 as opposed to $10. In addition to that, we've seen some changes that took place last year as well, and that will continue to this year. Those changes are that we see a new account, an organizational account, which is in place for you to do your registrations. That organizational account is updated. It allows multiple people to log in at the same time. It allows you to prepare your registration seamlessly, allows you to check for duplicates. So this is a new system, the organizational system, which was not there the year before. It was there last year, but not the year before. In addition to that, last year we saw that a huge change, which was that they made the registration system beneficiary centric, which means that no matter how many registrations you file as a beneficiary, you will get only one pick in the lottery based on your passport ID. So even if you file duplicate registrations through different employers, you don't get a better chance of being picked in the lottery. You have the same chance of being picked because it's only one. You get only one entry into the lottery, no matter how many registrations you've done. So that's a huge change as well. And of course, this year, we will see changes in the H1B process itself. But I think with reference to the registration, these are the changes that we can expect.
All right. Okay. So I think this is the brief that our viewers are getting to know today about the latest changes that happened in H1B registration system. Also, Prashanthi, as you mentioned some changes, I would also like to know about this, I would say, the beneficiary centric topic. Because earlier, what used to happen if three companies have registered, three companies can register the same individual, right? And that same individual have more chances to get selected as compared to the others who only had one chance with a single registration. So don't you think the person who got chances, three companies getting registration from those three companies are better performing as compared to the other one? So don't you think this is, do you think is it really going to make the system fair enough?
I think so because what was happening is our people people tend to game the system. So the more leeway you give, the more opportunity you give, the more likely it is to be misused. And that's what happened last year.
Okay.
I mean, the year before, we saw 780 uh, thousand registrations, right?
Mm-hmm.
And there's only 85,000 H1B numbers. So, and that we saw like 400,000 of them were duplicate. Like more than half of the registrations were duplicate. And we also heard reports of one person filing 100 registrations,
Oh.
150 registrations
Mm-hmm.
to, so trying to game the system.
Yeah.
So it's not, I can't believe that one person had 150 job offers.
Absolutely.
So it's more likely that there was collusion,
Mm-hmm.
which means that, um, sister companies, so companies are colluding with each other to file the registration for the same person, um, resulting in, them getting one of the companies getting picked and then the company sharing the profits, etc. So this was called collusion. This is not allowed even now. It's not was not allowed earlier. But of
Mm-hmm.
course, when if it's an independent job offer, one beneficiary can file more than one registration
Okay.
as long as the job is different for each employer and
Mm-hmm.
there is no relationship or no collusion between the companies. But of course, now with the beneficiary centric system, there is no longer an incentive for the beneficiaries to file more than one registration. They're still doing it because they're not sure that that one company will, file their H1 even if they get picked. So they're just to make sure that they have a backup. Maybe, beneficiaries are still doing, more than one registration, but they're definitely not doing 100 registrations. So I think this was needed for the registration system to remain intact.
Mm-hmm.
Otherwise, they would have to remove the registration system because it was not working. So
Yeah.
to protect the integrity of the registration system, they came up with a beneficiary centric selection process, which I think was key if they wanted the registration system to work moving forward.
Mm-hmm.
So we didn't really have any choice because of how the system was being used. How will this impact companies that previously submitted multiple registrations for the same candidate? Um, so multiple registrations were not allowed at any point of time, right? So if you file multiple registrations for the same candidate, then most probably you were not picked in the lottery. You were not even included in the lottery process because they reject the registration as soon as they find the duplicate.
Oh.
So if you filed by mistake even for this beneficiary twice from the same company, then immediately your registration itself does not get submitted. It gets into a rejected status due to duplicates. So it will not even be put into the registration. So that's what happens if you file multiple registration for the same candidate. Now, on the other hand, if you collude with some other company, maybe USCIS will not come to know during the registration process, but I've seen RFEs even for last year's registration, even though it was beneficiary centric, people did still colluded. I don't know why, because there's no usefulness in it anymore. But maybe out of old habits or by mistake, there was still collusion, and USCIS still sent notice of intent to revoke and finally revoked those cases or sent an RFE asking for an explanation. So don't do it, even though there's no usefulness in doing it. I don't know why companies are persisting in continuing to do collusion.
All right. I think that's wonderfully explained. And I was about to ask how is it going to impact the different companies and different also how is it going to impact. But you already answered that. So thank you so much, Prashanthi, for making us understand this whole change and also the impact in a very simple way. And with that, I have another question for you, Prashanthi, that the new beneficiary centric selection process aimed to reduce the duplicate registration. That's what you said right now. So now I would like to know, how does this affect the candidates with multiple job offers?
So it shouldn't affect the candidates with multiple job offers. If they still want to file, several registrations, they can. And whichever registration, I mean, it'll only be one chance at the lottery. And then
Mhm.
if they get picked in the lottery, then they can decide which H1 that they want to go with, which company they want to go with. So that's how it works now. If you have filed for several companies, then you can choose which company that you want to file the H1 with. So it becomes up to the beneficiary to choose. Of course, you can't file more than, I mean, you can even file more than one H1 and then decide which H1 you finally want to take and withdraw the other one. But there's only one lottery, one number that goes into the lottery system. And if you get picked, if you have several job offers, you can choose to file the H1 with all of them, or you can choose which ones you want to file the H1 with. But finally, you're allowed, you obviously will work only for one company unless you're filing concurrent H1s. And then in which case, then it does not have to be, it's not subject to the cap because a concurrent H1 is cap exempt. So you would, under the cap, work for only one employer. And you choose which employer you want to work with.
All right. Okay. And here's another question, Prashanthi, that USCIS has indicated a stricter oversight on fraud and misuse in the H1B lottery. And so, what additional documentation should employers and applicants prepare to avoid these issues?
So, yeah, I mean, under the Trump administration, they are focused on combating fraud and abuse of the H-1B visa program, and even previous administrations did. But the present administration seems to be of the opinion that there's a shortage of qualified workers, that the H-1B is to, target the shortage of qualified
Mhm.
workers in the country. So if there is a shortage, then the H-1B program is useful. But they seem to think that there are a lot of American workers who are qualified, willing and deserving to work in these fields, but they're being ignored or unfairly disadvantaged
Mhm.
due to, because of the H-1B program. So to start off with, USCIS has come up with a statement that they think that the H-1B program is not important and is not as useful as it was meant to be. So starting off with that, if you start off with that angle, then obviously you see that they're going to discourage people from filing H1s, and they're going to uh, try not to approve cases, and there's going to be extreme vetting on H1s because their mindset itself has changed. The present administration's mindset has changed.
Mhm.
So what they're basically saying that employers who abuse this H1B visa program, they are negatively impacting the US workers. And so in order to combat fraud, they want, um, you know, anyone who reports this kind of H1B fraud. So if you're an employee and you report the fraud that your employer is doing, they want to make sure that there is some option for you to remain in status because your H1B will then be withdrawn by the employer. So they are trying to find some protections to help those H1B workers by allowing them to extend their H1 status or change to another immigrant status, uh, under the extraordinary circumstances rule, which was always been there. It's like a catch-all phrase which allows people to go back into status once they're out of status, provided USCIS agrees. So it's a nunc-pro-tunc petition that has to be filed under humanitarian grounds. Or extraordinary circumstances, they approve these cases. So what kind of H1B fraud and abuse indicators are they going to be looking at? And they've given some indicators in their latest press release.
Mhm.
H1B worker is not or will not be paid the wages certified in the LCA. So if you're not being paid the prevailing wage, there's a wage disparity between the H1B workers and other workers performing similar jobs to the detriment of the US workers, meaning the H1B worker is being paid more than your other, say, US citizen workers for the same job. That is abuse.
Yeah.
H1B worker is not performing the duties as listed in the H1B petition. Uh, and the H1B worker has less experience than a US worker that you're hiring for a similar position. So they're making sure that there is no unfair advantage to your US worker, and you're not giving any um, advantage to the H1B worker as opposed to the US worker. So, with reference to wage, with reference to hiring someone with less experience, and also the H1B worker is not working in the intended location where they're supposed to be working, then it's also abuse. So, they've, listed a few um, examples of where H1B fraud or abuse would be found. And they've increased H1B site visits. Starting, they said, as of January, they've increased those site visits. And so that is how they're also kind of preventing fraud or vetting, doing extreme vetting on H1B employers, especially consulting companies. So they're doing more vetting, or they have said that they're going to do more site visits for H1B dependent employers, that is your consulting companies who have a high ratio of H1B workers as compared to other US workers. Cases where they cannot validate the employer's basic business information through commercially available data. So if they can't find your company they can't find a website for you, they search and they can't find you on their Vibe database, then most probably they'll do a site visit. So important for employers to be part of the Dun and Bradstreet employer database, because that's where they get their Vibe information from. Also, employers petitioning H1B workers who work for other companies offsite. So we're talking about the consulting company scenario. So they're going to be increasing or expanding site visit for consulting companies as well. So this is what they're doing. They're targeting site visits for these kind of companies. They're, trying to. They're kind of giving you a list of who will be a H1B fraud or what will be a H1B fraud, and they're seeking to protect US workers in this way.
That's right. And I think that's a good step. They can only try these steps and these changes to protect the US workers. After all, we have been seeing a lot of misuse and lots of abuse that's happening in the system. But I think absolutely that's how they can make the system work fairer and also more flexible. So with that,
Which,
Prashant.
which Sam, would be a good thing if it was just being done for the purposes of being fairer and flexible. I agree with that, and everybody does, I think. But I think the reason that they're doing this is to prevent even companies that uh, do H1s properly, prevent them from filing H1s or creating a fear in their minds
Yeah.
in order to not to file H1s. So I think it also creates fear, uh, and prevents even those people who are actually doing using the system properly from using it and filing H1s,
Yeah.
in my opinion.
I think that's a wonderful opinion because that's what President Trump's administration has also come up with, by deporting so many people back to their home country. And that's how they are setting an example that they are not going to tolerate any illegal immigrants and any abusing things that may destroy the immigration system. So that's the main agenda, to create the fear in every illegal, I would say, not only immigrants, but also the frauds, the scammers, and especially the agents, those who are promoting these H1B, fraud things. So I think,
Which again, Sam, is fine if they are only targeting people who are not following the law. But I'm just hoping that they don't target people who also follow the law by
yeah,
making the law harder than it actually is. For example, if they're sending out RFEs and they're asking for contracts for all 3 years, if you're
yeah,
filing a H1 for 3 years and asking for contracts for 3 years, then that's not in the law. But there's still USCIS is still, if they still ask for it like they did under the previous administration, then that is not fair. Then you're shutting down the H1B system or finding ways of shutting down the H1B system. No one is complaining about uh, cracking down on fraud because that is extremely important. But in the guise of cracking down on fraud, don't shut down the entire H1B system or make it more difficult for people who qualify to apply for a H1. That's my point.
I'm loving your point. Yeah, absolutely. That's very well said. If we are seeing one side is growing, then another side is also bringing up more challenges. But I think, Prashanthi, that is why we are here to make our viewers aware about the new changes and how they can also protect themselves under, I would say, a very tough time that's happening right now in 2025. And the great thing is that our viewers are really engaging with us, and I can see a lot of viewers who have joined us. So let me take some comments. I can see Vishwanathan is here. So he's asking a question that got my L1 I 129 approved with work location as NJ office, but today got an additional client option from another city in TX. I will manage both, but which state can I reside? NJ as per petition or TX? Yeah.
Well, if it's an L1B petition, um, it's not like it's not the same criteria that they use for the H1, where the work site is mentioned in an LCA. There's no LCA, so it's not as important as in a H1 where your prevailing wage is based on your work location. The LCA mentions the work location. Your I-129 mentions the work location. So if you don't work at that work location, then you are violating your status. In the L1B scenario, which I think maybe that's what it is, because you just say L1, you don't say L1B or L1A. The work location is important in the sense that they want to make sure that you have a bona fide job offer, which you've mentioned in the L1. So you want to make sure that there's no fraud there, but that is the extent to which the work location is important. But I would say still stick to New Jersey location because that's what has been said in your L1.
All right. So I think Vishwanathan, thank you so much for being here and participating in this webinar. Let us know if you still have any follow-up question or would like to uh, know any other topic about today's webinar. We would love to hear from you. And let's take Prateek's question also. I got selected in last year's lottery, but my application was denied due to a specialty occupation issue. If my employer registers me again this year, will my denial from last year impact my chances?
No, but you have to learn from your mistakes, right? So if you used a particular job title last year and USCI said it was not a specialty occupation, it's likely that you'll have the same problem this year. But if it's with a different employer, um, but there's another problem there. If it's the same employer and now they're using a different job title, USCIS might question what the job title actually is and whether they're making that change just to circumvent the specialty occupation issue. But if you're filing through a completely different employer, then of course, the previous issue will not impact you as long as you're using a different job title.
All right. So Prateek, please let us know, is it the same employer or the different employer, so that we can have a more conversation into that and can really help you out in your problem. So thank you so much, Prashanthi, also for answering Prateek's comment. And let me take Kritika's question. I'm outside the US and my employer wants to register me for the lottery. If I get selected, how does my visa stamping process work? I am hearing delays in consulates. Could I get stuck for months waiting for an interview?
Well, if you're outside the country, you're already, you're not waiting for anything. You're just living your life, right? So if you do get picked for the lottery, which there's a 30% chance of that happening, um, I mean, yes, there could be a delay in visa processing. Your visa could get denied, H1 could get denied, anything can happen between the time that you file the registration and after that. So I would say don't give up your job right just yet. Wait to actually get the visa stamped. Then, if you're working somewhere, then you do the resignation, because there's so many things that can happen in between. And yes, you're absolutely right. There could be delays, and uh, the visa processing under Trump is also will you will experience again more vetting. They are asking for client letters, etc. So that could cause delays due to administrative processing um, happening. So yes, you couldn't, or nothing, or your visa might just get approved, very quickly. We can't say. So I'm just saying, be prepared for the worst, so that you will not be caught by surprise.
That's right. Okay, thank you, Kritika, for asking this question. And let's take Supriya's comment. I'm currently working on OPT, and my employer is sponsoring me for the H1B lottery this year. But I'm worried if I don't get selected, what are my options? Should I plan for day one CPT, or is there any other way to stay in status?
Unfortunately, no. A lot of students face the same predicament, as there's only a 30% or 25% chance of getting selected in the lottery, and there's no duplicate. And there's no point in filing duplicate registrations anymore, so you can't increase your chances. But your chances kind of are increased if you are a master's degree holder from the US. So that will improve your chances, because then you have two picks in the lottery, one under the master's cap and then the other under the bachelor's cap. So hope for the best, but if you don't get selected, then you have to continue your F1 student status, or you move to a different status. But there is no other work status that you can move to if you're an Indian national. You could file a green card, but again, the green card numbers are not available, so there's no purpose in doing that. So I don't see many options for you. You could try for a J1, but again, J1 is not available for all jobs, and it's complicated, and you might need a waiver, etc. So I think the best option would be an OPT if you're an Indian national, um, if you want to continue working.
All right. So, thank you, Prashanthi, for putting these very important pointers with us. And Supriya, if you still have any follow up question or would like to know more about it, then why don't you go ahead and contact Attorney Prashanthi Reddy directly to her contact number? And it's not only Supriya, I would say that everyone, the friends, those who are watching us, whether it is Vishwanathan, Kritika, or anyone, Prateek, please go ahead and give a call to Attorney Prashanthi Reddy, because it's really high time. And taking decisions, not relying in a very credible source, is really going to make your visa process more complicated. So, to smoothing it, I would suggest to take expert advice. And the contact details are on the screen. That is 212-354-1010, with the email ID prashanthi at reddyesq.com, and the website is www.reddyesq.com. So, with that, friends, we have completed our first session of this webinar. But, Prashanthi, I think now it's time for us to take a quick break so that we can get more engagement from our audience. So, friends, don't go anywhere. We'll be coming up with more insightful answers from Attorney Prashanthi Reddy. And go ahead, put up more questions as possible. And we are here for an half an hour more. So thank you everyone for joining us. Keep watching Immigration Talk Show. We'll be right back. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are having a great discussion on the topic H1B season is here. Are you fully prepared for 2025 lottery? And today we are having really wonderful insights from none other than attorney Prashanthi Reddy. And till now, we have covered a lot of different perspective into this conversation. But with that, Prashanthi, I would like to go ahead with my very next question. And this is about increased scrutiny on employer-employee relationship. So, how could employers structure contracts and work arrangements to align with USCIS expectations?
So actually, I hope that there will not be increased scrutiny on employer-employee relationship. As per the new H1B regulation, they're certainly moved away from the employer-employee relationship issue. The only thing that they want to see now is whether you have a bona fide job offer for the person that you're hiring or not. Um, so I don't think employer-employee relationship is an issue unless USCIS somehow makes it an issue by filing a new regulation. But as of now, it's not an issue. So the only thing we need to worry about with reference to contracts and work arrangements is whether they show that there's a bona fide job offer or not. And for that reason, we might have to submit them, but not for the employer-employee relationship issue.
All right. Okay. I think that's a good news. And also, Prashanti, my next question is that there are reports that USCIS may prioritize wage levels in future lotteries. So, while this hasn't been implemented yet, do you think that it will impact the fiscal year 2025 selection process?
No, because the registration process for 2025, um, for the 2026 fiscal year, is still based on the lottery system. It's a random selection process. It's not being based on wage levels. Of course, the Trump administration has said, in pending Judiciary Committee bill, that they want to use either an auction system or prioritize people who have higher wages for the lottery. But they haven't. That is only a proposal. We're waiting for the bill to be formalized, introduced. Nothing has happened yet. They've said that that might be introduced in March, but that's too late to affect this registration this year, because the registration is already starting on March 7th and ending on the 24th. So it's unlikely that that will affect this year's registration process.
Okay. All right. That's great. And also, Prashanti, if you let us know what are the key differences in how USCIS is assessing specialty occupation roles this year as compared to the previous year.
So there's a new H1B regulation in place which talks about a couple of things about specialty occupation. It's not a major change because the regulation basically says that it's reconfirming what USCIS has been practicing in the past few years. But what they've said is that, number one, the specialty occupation, the job should be directly related to the major. But they've also said that the job doesn't have to require just one major, it can require a range of majors as long as each major is related to the job. So, what is a specialty occupation? A specialty occupation is an occupation which requires a bachelor's degree in a specific field. And how do they know if a bachelor's degree in a specific field is required? Of course, they look at the industry, they look at Google, they look at a website called the Occupational Outlook Handbook, which is published by the Labor Department every year. And that has positions and it shows what is the educational qualification for the position. So usually USCIS will look at that and they'll say, okay, software engineer, as per the Occupational Outlook Handbook, requires a bachelor's degree in math, physics, computer science. So it's many majors, right? So we have to show that each of the majors is related to the position to show that it's a specialty occupation. So it has to be directly related, and if there's more than one major, you have to show that every major is somehow related to the job description. So it's useful to have a table to show, how it's related. So that's two things that have changed. I mean, which have not really changed, but they have clarified it. The third thing they're saying is that, and again, they're clarifying this, is that even if the, for example, Occupational Outlook Handbook says that mostly a bachelor's degree in computer science is required for this position, but some employers don't require a bachelor's degree. This can still be considered to be a specialty occupation because it doesn't have to be always, it has to be most of the time. So they have clarified that because in the past they were denying cases based on these points, based on there not being one major, based on the fact that all employers don't require it, only some employers require it. So this is in a way good for H1Bs, but it can be twisted and used in a different way by the present USCIS administration to also deny cases and make it stricter. So it all goes based on interpretation, right? How you interpret the regulation. So they can interpret it differently. So that's about specialty occupation and how things have been clarified in the present regulation.
All right. I think that's wonderfully explained the difference between the two. And with that, Prashanthi, we have another viewer. Vishwanathan is back again with another question. So I would like to take his comment. Vishwanathan is asking that L1A managerial role petition as NJ office work locations. Can I file amendment to the petition from NJ to remote?
I don't think it really matters whether you're working remote or in the office in a managerial role. I don't think for L1A that is really important. They don't care whether you're working in person or remote as long as you're working. But I think it's a good idea to live in New Jersey so that not too many questions are asked when you file your extension. But otherwise, I don't think it matters that you're working remote. It depends on what your office want you to do or what your office procedures are, processes are with reference to working remote.
That's right. I think this is the question that Prashanthi, most of our viewers have, regarding working from office or working from remote. But actually doesn't matter, right? For the
That's only
L1.
for L1. Only for the L1, it may not matter, but for a H1, it definitely matters.
All right, all right. Okay. Thanks for clarifying that. And I can see a similar question from Samuel's side. I work remotely for a US company while living in Canada. They want to sponsor my H1B this year so I can move to the US. If I get selected, will I need to be in the US for the petition approval or can I do everything from Canada?
You can do everything from Canada. You can apply for consular processing, and then once your H1 gets approved, selected and then approved, then you can go for a visa. You can go in Canada your closest U.S. consulate and get a visa, and then come into the U.S. on a H1 visa, and then start working in the U.S.
All right. Okay. Thank you, Prashanthi, for taking these questions up and also answering them in a very great way, in a very detailed way. Rekha is here, and Rekha is asking I work for a small startup, and they are sponsoring me for the H1B, but they don't have an in house immigration team, and I'm worried they might miss something. What are the biggest mistakes startups make in the process, and how can I make sure that everything goes smoothly?
Well, they don't need to have a in-house immigration team, but they do need to have an immigration attorney. So as long as they're using an immigration attorney, I don't think there is an issue. The attorney will take care of everything. But in general, for a startup, the problems that they face is maybe they don't have physical offices yet. So make sure they have a physical office. Make sure that they are able to show that they have a job available for you. Make sure they use the proper job title, proper job description, which shows that it's a specialty occupation, pay the prevailing wage, after the H1 gets approved, work from the location as mentioned in the LCA. So these are the things that have to be done,
Yeah.
before filing and also once your H1 gets approved.
That's right. Well, Rekha, we don't know whether they have the immigration attorney or not, but we definitely have. And we have one of the finest immigration attorneys. So please go ahead and reach out to attorney Prashanthi Reddy. The contact details are displayed on the screen. So go ahead, dial the number, call her. You can also email her and surely visit her website. So that would be great. And with that, I think I have covered all the comments that we got from our viewers. So now, Prashanti, I would like to shift our focus to our Facebook question. So, with your permission, I would like to reach out to Facebook question. Will that be okay?
Sure, go ahead.
All right. Before Facebook question, Prashanti, this is the comment that we got from our viewer on YouTube. So he's asking that my girlfriend has her B1 B2 visa appointments in 2 weeks from now. We have all documents completed except for the travel health insurance. Does she have a better chance of being approved for the visa having the insurance, or it makes no difference in the eyes of the embassy? Thank you.
I think everything makes a difference, and you have to prepare as much documentation as you can to get that B2 visa because, B2 visas are often rejected. So by showing that you have travel insurance, it shows that you will not be a burden on the systems in the US. So they're more likely to give you a visa if they see that, you're not going to be burdening the US economy. If you get sick and then, go to an emergency room there.
All right. Let's move ahead to our next question that we got from Facebook. I'll be traveling for H1B stamping to India. I'm working for ex employer but switching jobs and have my I-797 with the new employer. I would start with the new employer after coming back to the US. Would there be any issues? Also, should my DS-160 reflect the new employer as a current employer?
I'm traveling for H1 stamping to India, working for X, but switching jobs and have so so if you're traveling for stamping, then you obviously have to go with the employer that you want to work with. Unless you don't plan to work with that new employer as soon as you come into the country. You first plan to work with X, then after a while change to the new employer. But if you're planning to work with the new employer as soon as you come back, then you need to definitely go for a visa with the new employer and show the new I-797 when you're entering into the US.
All right. Thank you, Prashanti, for putting those answers. And let's move ahead with our next viewer's question. And this is a bit long. Hi, all. Could you please advise me on this situation? My H1B extension was filed on February 7th under regular processing. My perm date is November 30th, 2023, and I expect to receive approval soon. My current H1B is set to expire in May 2025. I'm debating whether to upgrade my H1B to premium processing since my company is not covering the cost. I assume they will also not OPT for premium processing, opt for premium processing for the I-140. Since I need to apply for an H4 EAD, I'm considering paying out of pocket for premium processing for my I-140. However, I'm unsure if upgrading my H1B is worth the expense or if it's better to wait. My main concern is ensuring that this does not delay the H4 EAD timeline. Yeah, Prashanti.
Well, there's a lot of information in there, but the question is very simple whether to do H1B premium processing or not. That is, of course, an individual choice. You have your H1B is expiring in May, so March, April, May. That's 3 months. I would say go for premium processing because, if you don't, then I don't know when you actually filed. You filed it in February, so only recently. I don't think
Yeah.
you'll get. Uh, you'll get a response by May, because that's only 3 months away. So, and then you might see that your I-94 is expired, and then if something happens, then you will be left without status. So in order to avoid that kind of a situation, I think you should go with premium processing, if you don't hear from them soon. And I don't think regular processing, you'll hear from them before 4 to 6 months. So yeah, premium processing is the way to go.
All right. I think a viewer, we don't know your name, but do let us know your name and go ahead with the premium processing. Let's move ahead with the next question that we got from our viewer. And it's about change of passports in middle of 221G process. Hello, my H1B petition was under 221G for last 6 months, and yesterday they asked to submit the passport here in India. It still shows refused as of now, but another concern is my current passport is within 6 months of expiration. I have already applied for a new one. I don't know if I can update my DS 160. Shall I take both my passports and explain them my situation?
Yes, that's a good idea. If you have a new passport as well, then you should submit the old passport and the new passport as well, showing that you received the extension. That's a good idea, because if your passport is expiring within 6 months, then they may want to see that new passport.
That's right. Okay, I think he got his answer. And with this, let's move ahead with the next one. Hello, I am on my fifth year of H1B through employer who is CAP exempt. I have my master's degree and work as a research assistant in psychology. I'm trying to see what my options are since my employer is not willing to sponsor because they only sponsor tenured professors. Any suggestion on what can I do? Trying to get into a PhD, would there be any paths there? Any help would be appreciated. Yeah.
So he's on his fifth year of the H1, which is CAP exempt, has a master's degree, working as a research assistant. Uh, if they're not willing to sponsor for the green card, then you are running out of options, because your H1 will only be for 6 years. Then yeah, you'd have to either change status, like you said, to an F1, and update your skills, and perhaps go into the academic field. Maybe then you'll qualify for an EB1, or find an employer who's willing to sponsor you, um, you know, for the green card. So that's the only two options you have: either change your status or find an employer quickly who's willing to sponsor you for a green card.
All right. So I think these two options are
I mean,
the
you
only.
could try to file for a change of status to an O1 if you qualify, based on your research. But, you know, I think it's important to file a green card at some point. And so if your present employer is not willing to do that, it's time to look for a new job.
Absolutely. Okay, I think this is a very understandable answer that we got from Prashanthi. Thank you, Prashanthi, for taking these questions. And I think these were the questions that we got from Facebook. With that, I would continue with my questions that I prepared from my end because we have already taken a lots of questions from our viewers. So let's also talk about the premium processing timelines and that have faced delays recently. So, should employers expect any slowdown in H1B adjudication for fiscal year 2025?
Well, if the present administration is hell-bent on kind of slowing down the H1B process, then the best way for them to do it would be by slowing down their processing times, which is what they did during the last Trump administration. The processing times really skyrocketed for a lot of cases. With premium processing, they are mandated to process within 30 days, but right now they don't even take 30 days. I mean, usually if you do premium processing, the case gets approved within a week. So if they want to delay premium processing, then they can certainly delay it by either sending out RFEs, which will automatically delay the process, because then there's no 30-day mandate,
Mm-hmm.
or they can wait for the 29th day and process it on the 30th day, thereby delaying premium processing, which was now taking about a week or 2 weeks to, using the full 30 days to, process the case.
All right. Okay. And with that, I have another question regarding RFEs issued. So, with more RFEs issued for third party worksite placements, what proactive measures should consulting firms take to strengthen their petitions?
Um, so, right now, as the H1B regulation, new H1B regulation has stated, USCIS will be looking to see if there is there's a bona fide job offer and there's bona fide specialty occupation work available for your employees. So if you happen to be a consulting company, then that would mean having to submit proof that the person will be consulted out to a third party worksite. And the proof would usually be a master services agreement, a purchase order, work order, letter from a vendor or a client. Those are the kind of documents that they're looking at. So if you don't have a job, then you should not be filing the H1. Only file the H1 if you do have a job available for that employee of yours. And this is consistent with what was being done in the previous years. Only recently, companies are filing H1s without POs and work orders, etc. But um, this has always been the case where they've needed it, for many years. So it's coming back to, square one where we're again submitting the contracts and work orders. The only difference is they're not requiring you to submit contracts and work orders between all the parties involved, number one. They're just seeing if there's some bona fide employment available, and if they're happy that if they're satisfied that the letter from a vendor or a PO from the vendor shows bona fide job availability, then they may not ask for letter from the client, contract between the vendor and the client, contract between all the parties. But they can certainly start doing that if they want to, because they can interpret it any way they want. But in the actual comments to the regulation, they said that they're not looking for that. So let's see if that changes. But as of now, yeah, what we're asking clients to submit is at least something, vendor letter or a PO, even if it's from the vendor, to show bona fide employment. Also, one thing I forgot to mention, that with reference to specialty occupation, they want to see that it is a specialty occupation based on the end client requirements. If you are a consulting company, not based on your requirements. So in that case, if there is a question about specialty occupation, if you are using a job title which might prompt an RFE asking whether it's a specialty occupation or not, you'll have to submit a letter from the end client saying that the job requires a bachelor's degree in computer science, for example, or maybe advertisements from the client website when they advertised for that position that the requirement was a bachelor's degree in computer science. So that's another thing to keep in mind, where an end client letter might be needed, or other information from the end client might be needed as to show that it's a specialty occupation position.
All right. Okay. And also another question, Prashanthi, that I would like to know it from you regarding what are the major takeaways from last year's H1B gap season that employers and applicants should learn from to improve their chances in fiscal year 2025?
What we noticed last year and the year before that, they're asking for evaluations for even if you have a foreign degree, even if it's like a basic computer science engineering degree, straightforward, they're still asking for evaluation. So I would prepare in advance, because if you prepare in the last minute, it's difficult to get evaluations from the evaluation companies. So as soon as you get picked, I would at least get the evaluations done for all the cases that you have,
Yeah.
so that you're sending them out with evaluations. Otherwise, by getting RFEs, just for evaluations, and that delays the case, increases the cost of the case. It makes no sense, and also increases the chances of denial. So evaluations are a must, and in order to do that, you need to prepare well in advance so that you can get the evaluation in advance. So you can't file the case in the last month, because in the last month of June, which is the last month to file, nobody's going to give you an evaluation. So keep that ready. And the other change is, of course, we've seen changes from last year to this year. Last year, we didn't really submit vendor letters or client letters or contracts. This year, I think you need to get those ready and submit that with your application to avoid an RFE. So that's the other major change that I see. Um, with reference to specialty occupation, use job titles if possible that are recognizable as specialty occupations, which USCIS is comfortable with, rather than using job titles that they're not comfortable with. Even though it's the job description that is important, not the title, the first thing that they look at is the title, and then they look at the job description. So and which leads me to the job description, which makes sure that the job description is detailed, the job description shows sufficient complexity, and sufficient details to show that a bachelor's degree is required in computer science or in any other specific field to show that it's a specialty occupation. So these are a few pointers that I have for this year.
All right, that's great. Okay, so friends, I can see more viewers have joined us right now, and let me take Pratap's comment here. So, thank you, Pratap, for being here and participating in this webinar. He's asking, I went to the US with H1B visa on September 4. After that, the project went on hold, and I came back to India on November 24. I was in US 50 days only but did not run the payroll. Will they ask pay stubs at immigration? What are the mandatory documents should I carry with me?
Carry for what? Are you going for a visa, or um, went to the US? You already have a visa. Are you returning back into the country? What is the context here? What are you planning to do next?
Yeah, I think Pratap, we are lacking some information. So please let us know what is the context here, so that Prashanthi can help you out regarding your question. And we are here for, okay, it's almost time, but don't worry. We are here for 5 more minutes. So please post your question as soon as possible before the live show ends. And Prashanthi, I have one more question for you about the Department of Labor has updated wage level data. So, how do these new prevailing wage figures impact the H1B salary compliance and petition approvals?
Let's take Pratap's question first. I think he's answered it, and then because this is a little long, so let's take Pratap's
Sure,
question first. Sam,
sure. Why not? I think he said that I'm planning to go to US now.
if he's planning to travel to the US now, are you planning to travel with the same employer, or you're filing with another employer? If you're going with the same employer, then it's definitely going to be questionable as to what you did in the US for 50 days, because that is pretty much shows that you're out of status unless um, you should have applied for a social security number and uh, gotten onto the payroll in that 50 days, or at least after you got the social security number, even if you came back, they should have given you back wages. So if you're planning to travel now, they're definitely going to ask you what your status was when you were in the US. So that payroll is important,
Yeah.
so that you don't get into trouble at the port of entry.
Okay. So I think Pratap, you got your answer, and thank you so much for participating here and for asking this question. I think Prashanthi, let's end our session with the question that I have, mentioned. This one, the Department of Labor has updated wage level data. So how do these new prevailing wage figures impact H1B salary compliance and petition approvals?
So yes, they have updated the wages, and they continue to update them every year. So every year they update wages and they increase a little bit. Um, But the important thing is, another important thing they did is last year in July, they switched from one system to another. So they decommissioned the FLCA data center and they switched to the flag system. So this has improved the way we search for wages, because now we can search for wages based on the ONET code and not based on SOC code. What this means is that there are many more positions opened up for us where we can search for the wages. Before, the positions were not there, and we had to basically look for the closest position available and use that position. So now a lot more positions have opened up because they're using ONET directly, and ONET has many more positions in their database. But with reference to increase in the wage levels, we've seen increases. Some changes that I wanted to point out, which
Mhm.
were unusual, is that, for example, software developers, the wage level went up by 21% in San Francisco, whereas in New York it just went up by 12%. That's something that I wanted to highlight. But otherwise, if I look at some common job titles, for example, software developer job title, for level 2, it's 123,000, and that's gone up from 2023, where it was actually, let me check. The wage levels for 2023 to 2024, it's gone up again by a few thousand. If I look at the hourly rate for level 1 and level 2 and level 3, and comparing the different years, for 2023, it was $40 an hour, and now it's become $45 an hour. So you see, it went up by $5 an hour. And in 2024, last year it was 42, so it went up by $3. So every year it goes up by $2 or $3 an hour, a few $1,000s a
Mhm.
year. And the same thing happened this year as well. So yeah, wage levels have been continuously going up. In some instances, it hasn't gone up, but that's unusual. Um, but usually it does go up. For managers, for example, it's been steady for all the users. In fact, it went down in 2023 and then went up slightly again in 2024. But in the IT positions, usually it goes up marginally or to a great extent, um, by 10, 20,000 every year. So overall increase, 2% increase in H1B jobs for all data, uh, in the for data for all data on all cases. Sorry, for example, data analyst cases, it went up by 19%. And as I said, software developer went up by 20%. So as you see, there has been an increase overall in the prevailing wages over the years, and you can expect that to continue.
All right. Thank you so much, Prashanthi, for taking that question up and explaining us in a very detailed way. I'm sure our viewers are really, getting a lot of new information about this topic. And with that, it's almost time. We have I come across 1 hour, and we didn't even realize. So thank you so much, Prashanthi, for being here. Any last message that you would like to share with our viewers?
Just that with the prevailing wages increasing every year, and I don't know how realistic that wage increase is, whether it is actually mirroring the actual wages that people are getting paid. People who are not on a H1 are getting paid. It should, but I don't think it is. I think the prevailing wages for H1 candidates are more than the wages that are usually being given in the market for non H1B candidates. So this, puts employers at a distinctly disadvantageous position, and they will, obviously hire less H1B workers. And then what will happen is, then the work, if there are no US citizens, permanent residents available for this job, the work, all these jobs will go out of the country. So
Yes.
I don't think what the present administration is saying is true, that uh, the jobs are not available for US citizens. I don't think there are enough permanent residents and US citizens available for these kind of senior IT position jobs. Maybe for entry level positions, they might be available given the year, because every year is different. But for senior positions, there's definitely still a dearth in talent in the US. So if they don't allow H1Bs to um, kind of make up for that dearth, then all these positions will go outside the country, and Microsofts and Amazons will hire people in India or in Mexico or Costa Rica, and then the economy of those countries will benefit as opposed to the US.
Absolutely. I think that's wonderfully explained and, putting up, I would say, such a different information to us also. I am sure our viewers are learning a lot of things from this webinar. And before starting the show, I asked a question that are they fully prepared for the H1B lottery 2025 or not? But I said that after the show, they are definitely going to be. At least they will have, more knowledge, they will have more data, how to prepare, they'll get the way. So I'm sure, Prashanthi, with your insights, with your expertise, they have filled themselves with lots of information. So again, I would say it was really wonderful having show with you. I really enjoyed that. Thank you so much for being here, and I'm really looking forward to have more shows with you.
Thank you, Sam. Take care.
All right, that's great. Friends, the great thing is that you can also contact Attorney Prashanthi Reddy on the given number. That is 212-354-1010. And the email ID is prashanthi at reddyesq.com. And visit our website, that is www.reddyesq.com. And with that, friends, I would like to take a leave now. Don't forget to like, share, and subscribe to Immigration Talk Show. Our handle is at Immigration Talk Show, and we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So follow us on these many platforms and ask as many questions as possible regarding your immigration journey. We come up here with very different topics on every week so that you guys can get a clear concept about your problems. So keep watching Immigration Talk Show. Meanwhile, I'm Sam signing off for now. Goodbye, everyone, and take care.
Hello, everyone, and welcome to Immigration Talk Show. I'm Napasa, your host for today, and I'm very happy to have you all join us. So, folks, before we have our guest of for today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, a very warm welcome once again to Immigration Talk Show. We have a very important discussion lined up for you. Yes, today we're going to discuss about the March 2025 visa bulletin, which released a couple of days back, and it's bringing updates and challenges for those in the U.S. immigration system. So we're going to discuss about that. And yes, to help us break it all down, I'm very, very happy to welcome back our very well known expert in immigration law, attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. Prashanthi, so good to have you back. How are you doing?
How are you?
I'm good too, Prashanthi. Thank you so much for joining us today. And how has it been lately for you? Otherwise, must be very busy with H1B season coming in, and also so many changes with the new administration as well.
Yeah, yeah, it is a challenge. And, I have, I'm on the phone most of the time because I have so many phone calls. People worried about their status, unsure about what the new laws mean to them. So it is a kind of a roller coaster kind of time. So, you know, we just take one day as it comes and hope for the best.
Absolutely. And well, it's been very amazing and very fascinating that. So sorry. Excuse me, my throat still hurts, but I was going to say I'm very excited to speak about the March 2025 visa bulletin. There are some changes and interesting ones as well. So definitely we have some questions. So I have this first one. How should Indian applicants, interpret the slow movement in the final action dates for family sponsored visas, and what strategies can they adopt, while waiting?
So maybe, Nipasa, we should first go through the visa bulletin for those who haven't had a chance to look at
Sure.
it.
Sure,
I was
Prashanti, you
thinking we
can go
should
ahead.
just, okay. So, I mean, to start off with, the visa bulletin for employment-based visas, um, USCIS has said that they look at the final action dates. So unless your priority date is, um, before that, the priority date in the final action date chart, you cannot file your 485. For the family-based cases, they're still looking at dates for filing charts, which is good news. That means there's still some scope for forward movement in the family-based case. So that's why they're still looking at dates for filing charts. Dates for filing charts. So with reference to final action chart for employment-based, let's go through the different categories and see how much movement there's been. So for EB2 and there's been a forward movement of 6 weeks. For India. For EB2 China, there's been a forward movement of 2 weeks. This is all for the final action date table, since we can't look at dates for filing. EB2 worldwide moved forward by 6 weeks. EB3 China advanced by a month, and EB3 other workers India also advanced by 6 weeks. And Philippines advanced by 5 weeks. All other countries for EB3 advanced by 2 months. So as you can see, there's been a good amount of forward movement of 6 weeks for EB2 and EB3 India, as well as EB3 other workers India. And there's also been some forward movement for China, forward movement for EB2 worldwide, and Philippines also has moved by 5 weeks. So that's in the nutshell what happened in the March visa bulletin. We can take up the first question, like you said, was
Yes.
the slow movement for the final action dates for family sponsored visas. Um, yeah, I mean, the family based visas, yes, there has been a slow forward movement, but some categories have shown some promise and a certain amount of forward movement. What strategies can you adopt? I would say stay prepared. Keep all your documents ready so that when your date does become current, you're ready to immediately file your 485, because it may not be current the following month. So you have to be ready to file your 485 in any given month. So make sure your birth certificates you have, your non-availability certificates you have. Make sure you're able to get your medicals on time. So scope out the places that will actually send medicals within, a week or two. And keep watching for your priority date. Look every month in travel.gov under the visa bulletins for your particular month and your particular date and country, so that you don't miss out if it does become available in a particular month.
Prashanthi, for giving us an intro to what we can expect. And folks, I would like to tell you that you can also participate in this discussion by calling us on this number 425-436-6335, and the access code is 988-888. Also, don't forget to hit the bell icon and follow us. Our channel is Immigration Talk Show. Subscribe to us at Immigration Talk Show and get in touch with us, friends. Hi, Asim. Thank you so much for joining us on comment. We are going to take your comment very, very soon. But for now, Prashanthi, I have my next question to you. And that is, with the F2A category, which is now marked as a current for filing, what does this mean for spouses and children of permanent residents, and how soon can they expect to move forward with their applications?
Well, current for whom? It's not current though for Indian nationals, but it's close to current. It's June, I think June 2024. So pretty good. Very close to being current. You saying it's current for worldwide? I haven't checked, and I will check. But with reference to the visa bulletin in general, when once it becomes current, it's important, as I said, for you to file as soon as possible, right? Because it may not be current the following year. So you want to make sure that you file it ASAP. And in order to do that, you obviously have to be prepared. Unless you're prepared with all your documentation, you will not be able to file. So while I was talking to you, I'm looking at the dates for F2A. Even for the dates for filing, it's July 2024 for everyone, for India, China, and all chargeability, all countries. For final action dates, it's actually 2022. But the good thing is, since we can use dates for filing, a lot of you should be able to file your case as long as, you filed your I-130 in July, on July 15th or before July 15th of 2024. So let's presume that your date is current, then I would say that you're able to file, you're able to get your application ready in the month of February, whatever is left of February. So you have, about 10 days in February to get your application ready, and you should be filing your application in the first week of March. In order to do that, obviously, you would need to get your medicals done quickly. You should, if you have not done them already, you should have your birth certificates ready. If you don't have birth certificates, then you should get secondary evidence, such as the non-availability certificate from your hometown, and also you should be getting, your secondary evidence for birth, which is affidavits of support or school leaving certificate, a letter from the priest, etc. Whatever you have to show to prove your date of birth. This is great news for spouses and children of permanent residents, which is what F2A is, because they'll be able to file 485. They'll be able to, whether you're outside the country or you're in the country. If you're outside the country, you can at least start the process. By hopefully your visa number will continue to be available and you'll be called for your interview. If you're in the country, you can actually file adjustment, which is a 485. And of course, you need all these documents that I just mentioned to file your 485. How soon can they expect to move forward with the application? As I said, if your date is current in March, you can file your application on March 1st. So the sooner the better.
Thank you so much, Prashanthi, for taking that up. And I would like to say hi to Yashwant. Thank you so much for joining us. We'll take up your question. And if possible, folks, why don't you join us on call? Our number is 425-436-6335, and the access code is 988-888. And folks, you can also call Attorney Prashanthi Reddy on her number 212-354 1010, and you can email Prashanthi at reddyesq.com, and go visit www.reddyesq.com to get to know more about Prashanthi Reddy. So, Prashanthi, I have another question, and that is with regard to the F4 category. So, siblings of U.S. citizens. So, has also seen significant delays, and what are the main reasons for this backlog? And do you foresee any improvements in the processing times for F4 category?
No, because there is a huge backlog and there continues to be a backlog for siblings of US categories for all countries, including India and China. And I don't foresee any improvements in processing time because there is so much demand and there's only certain number of visa numbers available every year. So, as I said, the main reason for the backlog is the high demand and the limited number of visa numbers. So, unless there is some change, and there may be less numbers used up in other categories and they fall down to F4, which seems unlikely, or if there's some legislative new law passed where they increase the number of green card numbers for family based, I don't think we'll be seeing a significant change in the backlog for F4s.
Hello, everyone, and welcome back after the short break on Immigration Talk Show. I'm your host, Nipasa, and with us today we have our guest, none other than Attorney Prashanthi Reddy from the Law Offices of Prashanthi Reddy. So, Prashanthi, it's been a great discussion discussing about the March 2025 visa bulletin so far. And yes, we've taken up some questions. We also have more people join us. So, this is on your channel, actually, Prashanthi. Melly Caldito has joined us, and I think we should take it up. So, how about the F3 category, ma'am? They file August 25th, 2015. My room is City. Hello, ma'am. About the F3 category, please, we file August 20th, 2025. My mom is a US citizen. How long to wait, please?
It's difficult to actually say how long the wait will be. So if you're looking at F3, and even if you look at dates for, I mean, if you look at the final action date for India, it's July 2010. And for dates for filing, it's a little better, but not so much. It's July 2012. And for those who don't know, F3 is basically married sons and daughters of US citizens. Um, so it's hard to tell. Sorry, we can't predict exactly how long it'll take. Um, and if it's 2015, then they're working, as you saw, in 2012. Um, and it doesn't move every month. So it's not like every month it moves a month. Yeah, so sometimes there's no movement at all, if you might have been noticing, for 6 months, and sometimes there's a movement, sudden movement of 6 weeks, or 5 weeks, or a few months. So it's very sporadic, and it all depends on demand. And USCIS has said that they have a high demand for this year as well, um, just as previous years. And they've also said that we will not have as many visa numbers available um, as last year. So last year we had 160 something thousand visa numbers available, because the basic number is 140 that's available, and then they add unused visa numbers from other categories. So they don't think there'll be much of the unused visa numbers from other categories. So you'll have a minimum of 140,000, but maybe more, depending on how many are unused. And so with the family-based category, it's the same. Um, you know, you we're not expecting a large surplus of visas, so I think the movement forward will be slow and sporadic, unfortunately. Um, and not much you can do other than, hope that there'll be some change in the law, which will then speed up the processing time.
Okay. Thank you so much, Melly Caldito, for joining us with your question. If you could call us also, it would be great. And we have RK also. Hi, RK. Thank you for joining us. RK is asking, why can't DOS can't tell us in February, for example, that between October and January, X amount of green card was issued between USCIS and DOS. They have this information because they used to make the VB, visa bulletin.
Right, I don't know exactly why they don't give us that information. They do give us, for example, they have given us the information for 2024, as to, how many numbers were actually available.
Mhm.
But for 2025, they have simply said that what they've said, and I quote, the employment-based annual limit for fiscal year 2025 will be higher than was typical before the pandemic, though lower than in FY 2021 to 2024. We are dedicated to using as many available employment-based visa numbers as possible in FY 2025, which ends on September 30th, 2025. So they always tend to give the information for the previous year, but we don't yet have information for the present year. And I think even with reference to moving the visa numbers, they move them slowly, um, based on every month what the usage is. So I think they're able to, give us a number only towards the end of the fiscal year, because they are waiting to see how many 485s are filed every month, because that makes a difference as to, what the visa numbers will ultimately be. And I can discuss that a little bit more in detail. I do have some numbers with reference to the 485s, that the number of 485s that are pending and have been filed, because that makes a huge difference with reference to what the visa bulletin will look like. So basically, every quarter they release these. USCIS releases these numbers. The last time they've released them is in September of 2024. They've released it for that quarter, and they've basically said for visa numbers that are current, the 485 spending for EB2 are range from 13,000 to 36,000 for last year. And EB3, the pending 485s for priority dates that are available were between 9 and 51,000. So you see, even for available cases, there is a backlog. That's 13 to 36,000 for EB2 and about 9 to 51,000 for EB3 cases. So this shows that even if your visa number is available for that particular month, you can still expect there'll be some delay in processing because there are so many cases that are in the backlog. They seem to be, on the whole, slightly less number of pending cases for EB3 when compared to EB2. So if your visa number is available only, say, for a month, you may not get the green card that month if it becomes unavailable the next month, because as you see, there is a backlog that they have to go through. Now, to your point with reference to visa numbers that are pending right now, priority dates that are awaiting availability, there is a huge backlog. For EB2, it's about 900,000 to 1.3 million for EB2. For EB3, it's about 500,000. So you see EB3 again, the number of cases is less when compared to EB2. So you can expect there'll be more rapid forward movement in EB3 when compared to EB2 from just based on the pending cases from last year. Of course, this changes every month, right? But this is, gives you an idea as to what to expect or what the average numbers are,
Yeah.
for any particular month. So you see that there is a huge backlog, continues to be a backlog. So, that's why we're seeing slow forward movement.
Yeah, and he was also saying, RK was also mentioning our monthly just published of the 140K green cards, how much is remaining, just so they can announce. But of course, we don't know why
Yeah,
don't they inform.
right, right. I don't know either. Maybe it's more complicated than it seems.
Maybe.
I don't know.
Yes, RK, thank you so much for joining us once again. It's always good to have you. So if you can also join us, and Melly Caldito says, thank you, ma'am, Prashanthi. So let's move on now to our next question, Prashanthi, and this is with regard to the same F category only, but F1 and F3. So for applicants filing under the F1 and F3 categories, how do the dates for filing impact their overall timeline? And, what key steps should they take while waiting for final action?
I think we kind of discussed the F3 category through a question.
Yes.
Um, what can they expect? I think we kind of discussed this, Nipasa, so we can move on to
Okay,
maybe the
let's move
next
to the
one.
E category, the EB2 and EB3 categories. For India, they continue to experience significant retrogression. So, what factors are causing this delay, and what are the best options, for affected applicants?
As I said, the huge backlog. I just read out a few numbers with pending 485 cases that were published last year, about 900 to 1.3 million for EB2, about 500,000 for EB3. These are cases that don't have priority dates available. And for cases that do have priority dates available, there is still a backlog of about 13 to 36,000 each month for EB2 and about 9 to 51,000. I think for a particular month they had very high backlog. So that's why that 51,000. But about, a few thousands for both EB2 and EB3, even for cases that are pending. So as you continue to see 485s being filed, you will see that the backlog just gets worse because the demand is so high, and the number of the priority date is not available because there's only 140,000, as RK pointed out, every year for them to work with. And if there are 1 million cases being filed, or there's a backlog of 1 million cases, there might be more cases being filed every year, every month. 1 million versus 140,000, you can do the math and figure out why there is a backlog, right? And also in previous years, we had some cases not being like EB1 worldwide, or maybe EB5 or some family-based cases. The numbers were not being used for worldwide, so they were trickling down to India and China. So for last year, we had 160,000 available. That means that 20,000 more than the 140,000. That was because of the trickle down effect from the other numbers. And for 2023, we had 197,000 numbers available. So, that's like 50,000 above the normal level of 140,000. This was again due to, because about 6,000 EB5 visas were carried over from 2022 to 2023. Just giving you an example of what usually happens. And about 10,000 EB5 visas that Congress allowed to carry over for the next fiscal year for EB5. So, these are the reasons why there were more visas available. There was also trickle down from the other visa categories. And so, we had more numbers available in 2023. 2024, we had, as I said, 160,000 available. I think 2024, there'll be less than 160,000 available because they have said that there won't be as many numbers available as they were from 2020 to 2024. So you see, because of the high demand, there is a definite backlog, and we don't expect to see any changes unless the demand reduces for some reason, and we don't see that happening, or there is some legislative action taken. For example, there have been bills in the past, the Eagle Act, where they have asked for, various things. They've asked for the visa number limitations to be removed completely. They've asked for visa numbers from previous used years to be, that were, not used and went to waste, to be put into the present so that the availability becomes more. So there have been various things that have been proposed, but nothing has happened so far. So that's why we continue to see backlogs for EB2 and EB3 as well.
Right. Right, Prashanthi. Thank you so much for updating us about EB categories as well. I think we should take up more comments from our audience since
Yes,
they are very actively participating. So
yes,
this next
definitely.
one is from Sagar and Manisha. Hello, ma'am. My name is Manisha and I'm from Nepal. I've got my PD February 26, 2024, EB3 skilled worker. What's your prediction? How long do I have to wait more? Thank you.
So EB3 skilled worker, and the good thing for you, you're not from India. Um, so if we look at let's go to the EB3 and look at employment-based category 3, all other workers, it's 2021 for final action dates, and for dates for filing, it's 2023. Actually, no, it's 2021 as well. So there's not much difference between the two, final action date and dates for filing table. For all other workers, we're not talking about regular EB3, we're talking about all other workers, which is EB3s for jobs which don't require a bachelor's degree. Uh, difficult again to predict when the numbers will become available. Obviously, we're not going to see a jump of 4 years this year unless something drastic happens. And again, we don't see a jump every month of a month, so it's difficult. I can't say that it'll be available in 4 years or 5 years. Um, but something could happen where suddenly there becomes an availability of numbers. I mean, COVID was the last thing that happened, which really drove the dates forward, but we don't want another thing like COVID to happen. So I'm hoping that some legislature, some change in the law happens, which will make the numbers jump forward. Otherwise, I don't see any change in the demand. I think the demand is going to be as it has been in the last 5 years.
Right. All the best to Manisha. Thank you for joining us. Folks, let me remind you that you can also join us on call, and the number is displayed on top of the screen. So please join us 425-436-6335. And when they ask for the access code, dial in 988-888. And also, I mean, Manisha, RK, Meli Caldito, and all you folks out there who've joined us, especially whose questions Prashanthi has already taken up, please do not forget to subscribe to us, hit the bell icon, and thank you, everyone. Next up, we have Nikki G. I have an EB1 with priority date 12 2024. My old EB2 is 12 2018. Now, when I did I-485, USCIS rejected, saying dates are not current. How to fix this?
I have an EB1 priority date of December 2024. My old EB2 is 2018. Now, when I did 485, well, if your visa number is current, then you should be able to file. But again, we have to look at the visa bulletin. I don't know which country you're from. If you are from India, then obviously it's not current. EB1 is still in 2022 for both dates for filing as well as final action dates. But I see what you're saying, that you have a previously approved I-140 and you're trying to port your priority date, in which case then you should inform USCIS. When you got the I-140 for EB1, your old priority date should be reflected in that. If it's not being reflected, then you cannot file a 485. So in order for it to get reflected, you have to file an amended I-140 and ask USCIS to correct the priority date to 2018, that you want to port the old priority date. And that's the way to do it. You have to have an I-140 with the 2018, I-140 with EB1 2018 priority date, and then you file the 485.
Okay. She's currently in India, she says. So does it make a difference?
If you're in India, then you basically are asking for the I-140 to be ported. And then once it's current, then you file an immigrant visa petition through NVC. But for that, you have to show that you have a current I-140.
Okay. All right. Thank you so much, Prashanthi, for taking this up. And Nikki G, thank you for participating. This next one is from Shriva. This is also on your channel, Prashanthi. Can site visits happen for people on GCEAD?
GCEAD, which means 485. You have a 485 pending and you have an EAD based on that. If you're presently on a H1, that's when site visits happen. If you're on the EAD based on a 485, site visits shouldn't happen, because it really doesn't matter whether you're working or even not working. Because if you have a pending 485, you can choose whether you want to work or not. There's no constraints on where you should work, how you should work, terms and conditions, or even if you should work. But if you have a 485 from company A, and if you're not working for that company, then there could be an issue at maybe the 485 interview, where they're asking you if they're questioning whether the job offer in the 485J is valid or not because you haven't started working for that company. But other than that, the site visits that you usually see for H1s should not be there for GCEADs.
All right, right. So, do you see EB2 or EB3 PD January 2014 to be current soon?
Uh, January 2014 is a long way off. I don't think it's going to be current soon. I
Thank you
mean,
so much.
in the
Yeah.
sense that I know they are working on 2012, but still, I don't think that EB2 and EB3 will move that quickly.
Mhm.
Let's maybe by in the next couple of years. It's difficult to say, really. I'm just, putting it out there, but it's difficult to say.
Speculating,
For
yes.
dates for filing, it's closer because it's 2013, so you're 2014, but it is January 2013, so there is a long move. For EB3, it's June 2013. So it's about, depending on which month you are, it could be a wait.
Okay. Shriva, thank you for joining us. This next question is from Abha. What are the predictions for F4 PD July to 2006 for India?
Everybody's asking me for predictions. I don't have, I'm not a soothsayer. I don't have a bowl which I can look into and predict uh, what the dates are likely to be. And for those people who, I know people release videos with predictions and they get a lot of likes, but that is, really, I mean, you can't take it seriously because you don't know. Bottom line is, F4 is of course um, the most retrogressed. That's brothers and sisters, and they're working on 2019 cases for India right now, and 2006, in fact, for dates for filing. And yeah, so it's not 22. Sorry, it's 2006 for F4. Uh, that's a long wait. And your priority date is July 2006. Yeah, so you're closer. Let's see. So July 2006, they're working on August 2006. So we've not yet reached, maybe a few months. What are the predictions? I haven't seen a huge amount of forward movement for F4. I know it's only a month, but wait and see. Maybe towards the end of the year, you'll see some more forward movement if they see that not many cases have been filed. Then you see like a jump sometimes towards the end of the year. That is, end of the year is September. So wait and see because it's only a month. I'm hoping that the date will become current. But again, we don't know for sure.
I'm sure many folks out there are hoping that. But yes, we got some more questions from our Facebook group. So let's take them up quickly, Prashanthi. So this first one is from Sagnik. My previous visa was F1. Have scheduled a Dropbox for H1B visa first time stamping at Chennai for March 7th, 2025. Do I need to cancel and schedule OFC and interview? My hometown is in Kolkata. Can I schedule for both offices and interview OFC and interview in my hometown? Can I reschedule the appointments now or do I need to wait till March 7th?
So first time stamping. Why? Okay. Why, if you have a Dropbox, why do you want to cancel and schedule for an interview? Um, I don't know why he wants to schedule for an interview, but it could be that sometimes with Dropbox, since you can't submit a lot of documents, at the Dropbox. They are, sending out administrative processing 221G notices to Dropboxes, and then asking questions or asking for documents. So in order to avoid that, if you go for a personal interview, then you can submit documents, on demand. You go with the proper documents and submit them. Mostly they're asking for end-client letters or contracts, etc. at the consulate. They're also calling the clients to find out whether the job is actually available. They're contacting the employers to find out if the job is still available. So we're seeing a lot of 221Gs. You'd have to cancel one. You have to cancel one visa before you schedule for another visa appointment. So I think that was the only question that they had.
Yes. Thank you, Prashanthi, for taking that up. Now,
And you
this
can
next
schedule
question.
it. You can schedule for an interview anywhere. It doesn't have to be hometown. It could be any other consulate that's close to you.
Okay. Thank you so much, Prashanthi, for taking that up. Control, if you can tell us what's the next question, please. I dropped my passport on January 31st, 2025, and mine is H1 renewal. On 11th February, status changed to refused. Waiting for passport to be returned. Is that due to the new rule? What will be my next step? Usually, how many days it will take to get my passport back? Any suggestions, please?
Uh, well, as I said, there have been a lot of 221Gs issued. Refused basically could just mean that it's gone into administrative processing and they're not immediately giving you the visa. But it's possible that they can give you the visa upon conducting their investigation, and doing their background checks, to see if the job is available, client is available, etc. So it's possible that they can still give you a visa. It's just that immediately, they've refused it, at least temporarily. That's what usually refused means, unless the 221G was refused, in which case then the refusal is permanent, and then they might send back the H1 to USCIS, and USCIS might send a notice of intent to revoke, at which point then the employer will be able to respond. They usually have 30 days to respond.
Okay. Thank you so much for taking that up as well. The next question, please control if you can display it. Okay. I am reaching out to seek assistance regarding and I have encountered while to start a new application. It appears that my profile details match existing record and preventing me from proceeding further with the application process. Since I have no longer access to my old email ID and profile, what are options open in this situation? Any guidance?
I think what they're asking here is, I'm not sure what exactly they're asking, but are they asking for filing a new application? They want to get access to my USCIS website.
I think yes,
Maybe
it's
that's what it is.
Mhm.
You can use a new email address to open a new account. If you already have an existing account with an old email address, you need a new email address to open a new account, which you can certainly do.
Right. All right. So the next question, please, control. This is from Darsh. Hello, I had H1B Dropbox for 13th February today, and when went there for Dropbox, they denied and told there are changes in regulations on 10th February, and not I would need fingerprints and interview. Is anyone familiar to this scenario? I think he's talking about biometrics. Is it
Yeah, they
necessary now?
denied and told me that there are changes. Uh, I would need fingerprints. Yeah, I've heard this as well. Uh, and I've heard that, Dropbox, Dropbox is still available. I've not heard otherwise that Dropbox is not available. But even with Dropbox, the officer has the right to call you for an in-person interview. And I'm seeing more of that happen. So that's what must have happened.
Okay. All right. Next question, please. Or okay, I think that's done. So this is Sarmat. This is on from our viewers. I'm going to submit my perm. Currently, they are processing October 2023. Do you anticipate the process time to increase?
The problem is under the Trump administration, they don't care about, how well they process it. They don't care about adding resources. They're basically against any kind of immigration. And in his last term, we saw processing times really skyrocket because they really cut down the staff. They did not hire new people. This is at USCIS, and the same thing might happen. We're seeing a lot of federal employees being laid off as well.
Mhm.
So from that point of view, yes, I think processing times for labor certs could increase. For that reason, also, DOL usually becomes more strict under certain
Mhm.
administrations, and also they become more strict when there are more layoffs. And when that happens, then audits increase, denials increase, and that also, causes your processing time to go up.
Mhm.
So yes, you can expect in the future that processing times, might go up.
Yes, plus there's so much vetting processes also going on. I think
Right.
themed things will be held on for quite some time. So, Prashanthi, before we go, if you still have some more time for one more or a couple more questions, I wanted to ask about the religious worker category. It is set to expire in March this year, 2025. So, what would happen to pending applications if no legislative action is taken? And are there alternative visas for religious workers?
Um, I mean, you could use the visas that exist, which is the H1B, provided that it's a specialty occupation, which it may not be. So that's why religious workers are a niche category because they are very unique in what they do. So they might not be other visas that unless um, the particular job requires a bachelor's degree in a particular field, and if it's something like that, then it could be a be you could possibly file a H1. If you belong to a different country like Australia or Canada, you could possibly file a TN. Again, if you meet those requirements, which may not be for a lot of religious worker um, jobs. So let's hope that they extend it again because uh, it is religious worker is always for a set period of time and then it is extended. So let's hope that it gets extended again.
About the DV visas, the diversity visas category, which remains current for all regions right now. So, what advice would you give the applicants who have been selected in the DV 2025 lottery and, but maybe they are unfamiliar of what to do in the next steps? So, any tips for them?
Um, File for adjustment as soon as you can if you've been selected. That's the only advice I have.
Thank you so much, Prashant. Also, what policy changes or legislative actions could help address the ongoing backlog for Indian applicants, maybe across both family and employment based categories? So, are there any potential reforms in the horizon?
We are waiting to see what happens this year. There have been many bills that have been introduced previously, but didn't see the light of day. So let's just wait and see what happens this year.
Yes, we'll really have to wait and watch because there are a lot of changes happening. And also, I mean, you must have heard about the 20 judges who were, fired just recently. Well, how do you think this is also going to impact the immigration scenario? Is it going to add to more backlogs, or you think it's, I don't know.
Well, immigration judges, luckily, they don't process USCIS cases. So it will increase the backlog for asylum cases, removal cases, those kind of cases, but not cases that are processed by USCIS.
Okay. All right. Thank you so much, Prashanthi, for your time today, and it was great to have you. So, maybe any end notes for folks out there, especially with regard to the visa bulletin for March 2025.
If your dates are current, please file your 485 immediately. Make sure that you file with your medicals because you can no longer file without. USCIS has said that they will reject all applications that are filed without medicals. So make sure you have all your documentation before you file.
There you go, friends. All the best. And Prashanthi, I hope that I'll see you soon again with another very interesting topic to discuss.
Sure. See you next week.
See you, Prashanthi. Have a great day ahead. And folks out there, thank you so much for joining us. In fact, you can also contact Attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. And every case is different, so it's best you email her directly about yourself and ask your questions. So her email address is prashanthi@reddyesq.com. And her phone number, by the way, is 212-354-1010. And you can also go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy. Also, friends, don't forget to subscribe to us at Immigration Talk Show. We are on YouTube, and also hit that bell icon so that whenever we have discussions, you're also notified. Also, check us out on LinkedIn, Facebook, X, and on Instagram. We are there as Immigration Talk Show. Follow us, connect with us, and stay in touch with us. This is it for now. Have a great day ahead and stay tuned on Immigration Talk Show because we will be back with more. Bye for now.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam, and today we are back again with another very exciting and very timely topic. I'm sure most of the H1B workers are really looking towards the changes that's going to happen in 2025, especially under Trump's administration. So, before going ahead and before inviting our today's guest, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information is at your own risk. All right, friends, after this very important disclaimer, thank you so much, everyone, for being here and being a part of this session. We are live on YouTube, LinkedIn, Facebook, and on X as well. So let us know from which platform you guys have joined us and do participate in this session by commenting. And we are here for an hour, so make sure to participate and ask as many questions as possible. Well, without any further ado, let me welcome our today's very special guest and who will be joining us for the fourth time, who is none other than attorney Karen Lee Pollak, who is a managing attorney of Pollak PLLC, a top immigration law firm which is based in Dallas, Texas, and also in Florida. The firm provides a full range of immigration services to businesses, families, and also individuals. So, welcome, Karen. I'm really happy that you are here, and we are really honored to have a show with you. Thank you so much, and we are really, really grateful that you're back here again.
Thank you, Sam. It's wonderful to be back on the show again. Thank you for having me. It's my honor and privilege to be joining you today.
All right, that's really great. I'm sure our viewers are also really eager for your next show because I think last show was really great and we really had a very great interaction regarding the H1B modernization rule. And today we are back again with another H1B very exciting topic like what changes can we expect in 2025. So, Karen, I would like to know before jumping into my questions, I mean, what can you say how 2025 will be for the H1B workers? Will it be very challenging or will it be okay or what it will be?
I think it will be okay as long as you are prepared in advance. The
Mhm.
lottery registration USCIS has announced begins on March the 7th through March 2024. So as long as you've registered your account before then and you have your key documents, you've consulted with an attorney regarding any issues, I think you should be fine. I know we've talked about it before, but the H1B modernization rule changes a lot of things. So
Mhm.
it's not actually the Trump administration that's changing things in 2025. It's the Biden administration that released, Department of Homeland Security, the H1B modernization rule on January the 17th, 2025, and that has significant changes for the H1B program.
That's
So
right.
some
That's
of
right.
the So some of those changes to the H1B modernization program include a significant increase in fees for registration. Registration has gone up in fees from a $10 registration fee to $215 per registration. There is also a change in specialty occupation definition to now require a bachelor's degree in a directly related specific specialty or its equivalent. So now USCIS is going to look not only at the job title and degree title, but also at the course of study. So these are some of the major changes with the H1B modernization rule. Also, one of the significant changes includes owner beneficiaries can petition for themselves now, which is great. However, these H1B visas will only be valid for 18 months.
That's right. Okay, so I think we got a gist like how this year is going to be for the H1B applicants, and it shouldn't be a lot of challenging, but I think by being updated and staying connected, with all the news and the changes that's happening, that's how you can save and you can protect yourself. So, Karen, I think let's start with my very first question to this topic. That what major policy changes are expected for H1B visas under the Trump administration in 2025?
I don't expect any changes under the Trump administration. They've all been outlaid in this modernization rule, the H1B modernization rule, which I said was released on January 17th, 2024. I've already outlaid some of the major changes. Other changes include USCIS will evaluate third-party job requirements for specialty occupation classifications. For example, if the beneficiary will be performing staffing services and will be part of the staff at a third-party work site, USCIS is now going to look at the third party's job requirements rather than the petitioner's job requirements. If they'll only be providing services such as a management consultant, then they will look at the petitioner's job requirements. That's also one of the modernization rule changes. Also, cap gap extensions now run until April 1 of the fiscal year, or the approved petition start date, whichever is earlier. So those are some of the more significant changes that we can see under the H1B modernization rule. I don't expect President Trump to be making any further changes to the H1B program for fiscal year 2026.
All right. I think that's a point of relief because most of the H1B workers were really concerned about, how their time will be, especially under Trump's administration. But I think, Karen, if you're explaining and if you're saying that it will be okay, and that's not going to be much difficult. So I think that's a point of relief. And also moving ahead, Karen, I would like to ask
Yes.
another question that how will the Trump administration's immigration policies will impact the H1B visa cap in 2025?
I don't think it will impact anything at all. As I said, everything that's related to changes is laid out in the H1B modernization rule. So I don't think the Trump administration is going to make any changes to this year's H1B cap subject petitions.
Okay. I think that's again another point of relief. But Karen, I would like to know it from you because in news and in most of the press conference also, we have been hearing from Trump's side that he is not very much into H1B workers, or he may, I mean, the process may be scrutinized, or there will be more challenges. So we mostly come across with those statements, what Trump has been saying regarding the H1B workers. But now, as you're saying that we are not going to see much changes. So what do you want to say? That do you think that Trump is favoring or is going to favor the H1B workers?
I think he's actually said in press that he does favor the H1B program. He has the air of Elon Musk. Elon Musk
Yeah.
came in on an H1B petition. So he really understands the whole program, not only from what he's read, but going through it personally. And I think, as I said, he has air, and President Trump has come out and said that he is in favor of the H1B program, and we know H1B beneficiaries in his own businesses. So I think for now he is in favor of it. I do believe that there will be greater scrutiny of H1B applications. Part of the H1B modernization rule expands site inspection authority. I think we can expect greater site inspections. I think we can expect USCIS to ask for documents to show that there's a bona fide job offer, such as statements of work, contracts, and other documents which show employee-employer relationships. So I think there'll be a greater scrutiny of H1B applications and more requests for evidence, just like we saw in the first Trump administration.
That's right. I think that's absolutely done. And also, Karen, I would like to move ahead with my next question that's regarding the lottery system. So, I would like to know your views. I mean, do you think the lottery system regarding the H1B visa process is okay? Because it mostly depends upon the luck, not on the skills. So, what's your call on that? Do you think or do you
That is
favor the
correct.
H1B visa lottery system? Yeah.
I don't personally favor the H1B lottery system. I think we should leave it to market forces. And if there's a demand for H1Bs in bona fide specialty occupations, we should give those H1Bs and let the market dictate how many H1Bs should be issued. So I think the lottery system is a very unfair way for employers to conduct their businesses. And it's actually led to a lot of jobs going offshore because businesses can't rely on luck to establish
Yeah.
their workforce.
That's right. And I think Trump has also mentioned somewhere that he is not going to keep the lottery system, right? I mean, he hasn't put up any statement yet, but we can see because somewhere he said that he's not very much in favor of lottery system. So let's see what happens.
That
But
that may be a good thing.
Mm-hmm. Yeah, yeah, please go ahead.
I think that may be a good thing that he's not in favor of the lottery system as long as we continue with the H1B program. And maybe he will agree and let market forces dictate it rather than just some random lottery. Um, as I said, I'm not in favor of the lottery system, but as of now, we don't know of any changes that will take place, and they certainly will not take place for this year's H1B cap.
All right. So I think you already answered this question that I was about to ask regarding the changes to the lottery system. So thank you so much, Karen, for making us aware and also letting us know what the lottery system can we expect in this year. Let's move ahead with my next question. And Karen, here I would like to know regarding visa frauds because most of the time, there's a lot of frauds that happening. So how will the Trump administration address these H1B visa fraud and abuse concerns in 2025?
So I think I've touched on this already, but under the H1B modernization rule, the USCIS has expanded site inspection authority. So now inspections may occur at petitioners' work sites, at third-party locations, or even private residence if remote work is going to be performed there. Non-cooperation during inspections can lead to denial or revocation of petitions. This is particularly significant for staffing companies that face H1B denials or revocations if anyone in the employment chain fails to cooperate in a site visit or in providing documents that are requested by USCIS in response to a request for evidence.
Yeah, yeah, yeah. Of course, of course. Okay, so I think that was a really great answer from your end, Karen. And moving ahead, I would also like to know regarding that can we expect some modification regarding the wage requirements for the H1B visa holders in this year?
I don't believe there'll be any modifications to wage requirements for H1B visa holders this year.
Okay, I think let's hope for that thing as well. And what about the diplomatic engagements? Because if we specifically talk about India, then we have seen that Narendra Modi have been visiting not only Narendra Modi but during Trump's inauguration time also. We have been seeing different prime ministers also. They have been coming to Trump's inauguration ceremony, praising them and having a very good connection. So, what's your call on that? I mean, do you think that in 2025, Trump's administration is going to have a better international relations with the other countries?
I think he'll have better relations with some countries. I think he's going to have much worse relationships with other countries. In regard to President Modi, I think he has a good relationship with him. So I don't believe that any relations between India and US will impact this year's fiscal cap. I know India is hoping the Trump administration will safeguard legal migration pathways for Indian citizens, including student visas and H1B visas for skilled workers. I know that there's worry that the US will cut the number of permits for Indians, but I do not believe that that will happen for this H1B cap or for visas in general. The Trump administration has not come out and stated that it will cut any non-immigrant or immigrant visas in relation to Indian citizens.
That's right. That's absolutely correct. And I think my next question was also about the international relation. But Karen, I would like to know it from you. Like, if Trump is putting any changes or any policies for the H1B visa workers in any country, maybe in Canada, Mexico, or India, or whatsoever the country is. So, do you think that I would say, the foreign talent recruitment strategy is going to affect the international relations if there will be any changes regarding the H1B visa policies?
So I don't believe for this year's H1B fiscal cap there'll be any influence or any changes. So I don't think international relations, good or bad, will impact this year's H1B fiscal cap. But we can see next year, I mean, there are countries that President Trump has tenuous or strenuous relationships with, and in the future that may make a change to those countries. But for now, I don't believe there'll be any changes.
Okay, all right. And what can you say about the backlogs? I mean, how might the Trump administration address the backlog of H1B visa applications in 2025?
There are no H1B visa backlogs at all for any countries, so we don't expect backlogs for 2025. There may be delays in, but there are no backlogs, and traditionally there have been no backlogs in the H1B visa category.
Okay. Let's hope so that there wouldn't be any backlog because most of our viewers are really concerned about the backlogs, and especially in India there are, like, I would say, millions of people who are already in backlog and they are willing for that. But let's see what happens. And as Karen, you are saying a very positive thing, so I hope our viewers are really filled with this. So thank you so much for making us full of positiveness and letting us know about these things. With that, I would also like to know my next question to you, Karen, that could you elaborate on which employers are considered cap exempt and how working for such employers affect the H1B application process?
I'm sorry, you were up. I couldn't hear your question.
Okay. All right, no worries. I'll repeat again. The question is that could you elaborate on which employers are considered cap exempt and how working for such employers affects the H1B application process?
Sure, absolutely. So cap exempt employers include higher education institutions such as university and colleges, non-profit research organizations such as entities engaged in research benefiting the public, and government research organizations such as federal, state, or local government entities conducting research. They also include some non-profit organizations associated with higher education institutions. Those also sometimes qualify as cap exempt. The difference between cap exempt and cap subject petitions is that if you qualify for a cap exempt petition, you can apply at any time of the year and there's no lottery system.
All right. Okay, and here's another question, Karen, that I would like to know it from you. That what changes can we expect in the employer sponsorship requirement for H1B visas in 2025?
I think we've addressed most of those changes with the H1B modernization rule, but I think that the government is going to put closer scrutiny on the bona fides of a job offer and what the actual requirements are of the job. Again, I think that if the beneficiary will be part of the staff at a particular company, if it's a third party kind of situation, the USCIS will look at the third party's job requirements rather than the petitioner's job requirements.
Yeah, I think that's very well said. Okay, so Karen, here's another question from my end that for applicants who may not secure an H1B visa, what alternative visa options are available for working in the US?
Well, the first option is an F1 student visa, either with day one CPT, which is curricular practical training that will allow them to work. So either an F1 with or without CPT. There's also F1 OPT, optional practical training. There is an E2 non-immigrant investor visa for people, for citizens of certain countries, if you can invest $100,000 into your own business. There is also the EB5 immigrant visa if you can invest 800,150,000 into your own business or 800,000 into a regional center. There are also O1 non-immigrant visas for aliens of extraordinary ability, and there is the EB1 green card for aliens of extraordinary ability. So those are some of the other options that are available. but people should definitely have a game plan in place and not wait to be selected or hear that they are not selected in the lottery system.
Absolutely, absolutely. That's correct. All right. So, Karen, I think I have these questions, and with that, I also got one question from our viewer who was an Indian applicant. So, controller, can you please? Yeah, this is the question that we got on Facebook. So, he's asking that my full family, 4 persons, applied for US B1 B2 in Kuwait. So, can we use this interview waiver from India or Saudi Arabia?
No, you cannot unless you actually have residency in Saudi Arabia or India. I don't believe that you can apply for an interview waiver.
All right. Okay. I hope he got his answer. And I would say that in case if you still have any question or any follow up query that you want to know from Karen, then you can also contact her. And the contact details are on the screen, and that will be the best thing because there are lots of things that's going. So let her know about your problem, and please reach out to her on the given contact detail. That is 214 You can also email her on the email ID that is KarenLP at pollakimmigration.com. And you can also visit her website that is www.pollakimmigration.com. So, yeah, I think that's all for the first half. And Karen, I think let's take a short break so that after that we can continue with our Facebook questions and also have some more questions for you. So, with your permission, I
Sure.
would just like to take a quick break so that our viewers can also prepare the questions. So, thank you so much, Karen. Till here, we really got a lot of information regarding our today's topic and to our friends also. Stay connected, stay tuned, watch the session till the end. We'll be right back. So don't go anywhere. You're watching Immigration Talk Show.
Thank
Hello and welcome everyone to Immigration Talk Show. I'm your host Sam, and today I have been joined by my, I would say, very special attorney Karen Lee Pollak. And today we have been discussing, and today we are having a very great discussion, a very insightful session on what changes could you expect for the H1B visas in 2025 under Trump's administration. So we got to know a lot of things regarding our today's topic. What changes can you expect, and how the future will be, or how Trump's administration is going to modify or look towards the H1B workers. So I think friends really got to know a lot of things in today's webinar, and thanks to Karen because you have really explained everything in a very good way. And Karen, with that, I would also like to ask some questions from the Facebook group as well. So, control,
Sure.
please let us go through those Facebook questions. Yeah. Okay. So, here's the first question that we got from Hannah. And she's asking that my spouse had H4 interview at Hyderabad consulate and his passport was returned. After 4 days, he received a mail stating his passport or visa is ready to be picked up, and the visa status check website says issued. So, what does that mean? Now he has to submit passport, and visa is really issued. Yeah,
Well, congratulations. It means what it says, that the visa has been issued and granted to him, and he should return with his passport so that they can place the visa in his passport.
all right. So, I think let's move ahead with our next viewer. And Hannah, thank you so much for asking this question. In case if you still have any question or follow up, then please go ahead and put up in the group. Okay, so here's a Sanket, and Sanket is asking that, hello, I'm looking for some information regarding the conversion of H4 to F1 visa. I would appreciate any input on this. So, firstly, he's asking, is it better to travel to home country for changing the status, or changing the status in US is feasible? I think let's take this one first. Yeah.
Um, it's feasible to either go home to your home country to change your status to F1 and to get an F1 visa, or to change your status in the United States. They have also, USCIS now has premium processing for F1 student visas in the United States. So you can get approval in 15 business days if you pay an additional fee to the government for expedited processing. So it's really a personal choice which go. You sure that you have a valid form I-20 from your school that you can show how you're going to support yourself while in college, who is going to pay for your studies, and that you have ties to your home you will return to. Either options are good options.
That's right. And also, Karen, here's the second part of this question that how long does it take to convert from H4 to F1 in US?
It could take a couple of months, or it can take 15 business days if you pay the expedited processing fee.
All right, all right, okay. And let's move ahead with next question. So thank you so much. I think you got your answer. In case if you still have any follow up, then please go ahead and let me know. I'll definitely ask that question. Next is Surya. So Surya is asking that, hi, I have my passport expired on September 2024 and renewed new passport in January 2025. There is a gap on passport renewal, but my H1B visa was renewed in July 2024 and it's good for 2026. I have got my stamp yet for my renewed H1B. So, will this be a problem at immigration when I come back on new stamp on H1B renewal? Yeah.
It should not be a problem if you have a new H1B stamp placed in your new passport, if that's what you're asking. I'm not entirely clear about your question, but if you get a new H1B stamp, you should be fine. And if you still have a copy of your old passport, I would carry both passports just in case.
Yeah. All right. So I think those were some of the questions, and also I would say Surya. Yeah, Surya. Thank you so much, Surya, for your question. And if you still have any follow up, or if you still want to know anything else, then please go ahead and let us know about what you think about today's topic, or any concern that you have regarding the H1B visa. All right. So, Karen, now I would like to know it from you, because, most of the people are in favor of the H1B workers, as what Trump's administration are doing, and about the Biden's administration as well. So, I would like to know it from you that was Biden administration little lenient towards the H1B workers, or is it Trump's administration?
Sorry, Sam, you were breaking up. Oh, I couldn't hear you.
All right, no worries. I think now you can hear me better.
Yes, now I can hear you. Thank you.
Okay, all right. So, yeah, I was asking about that we have been seeing how the Trump administration is handling H1B workers, and also Biden administration, how they have been handling the H1B workers. So, according to you, I would like to know it from your end, from an attorney end, because you all know things better, you all know the clients and everything. So, according to you, what do you think that who is favoring, or H1B workers will favored by which administration, mostly by Trump or by Biden? What do you think about it?
I think it was easier, or I think it was easier under the Biden administration. I think there will be greater scrutiny of applications under the Trump administration. There will be more site visits. There will be more attention to job offers, bona fides of the offer. Now that they've changed the definition, there will be a closer look at applications, the courses of study that the beneficiary did, to make sure that it's related to the job. So those are some of the changes. I think they'll be much stricter under the Trump administration.
Right, right. But Karen, as you said that Trump has never said anything about against the H1B workers, and he is mostly in favor. So why is it that we can see scrutiny under Trump's administration for the H1B workers? I mean, how can you explain these things to us?
I think I'm basing my, it's just, first of all, it's just my opinion, but I'm basing my opinion on the first Trump administration in the
Okay.
first 4 years where he was in power, where we saw a greater scrutiny of H1B petitions and more requests for evidence that we saw under the Biden administration.
Absolutely. And there he was, I think during his first term, he was not in favor of the H1B workers. And most of the time, he has said that he doesn't like them. But now he is in favor. Maybe he got the influence of Elon Musk, his very close friend. That's what we have been seeing right now. So I think that's okay. And Karen, our viewers are really, I would say, curious to know your point of view regarding Trump's administration. So that's why these questions were really important to us. And with that, Karen, I would also like to know regarding, as currently there has been a very hot topic regarding banning the income tax and putting tariffs on. So, what do you think? I mean, do you think Trump's administration has taken a right step to ban the income tax, or do you think that this is not a correct one?
I don't know. It's a very complicated topic. And I think in some cases, we do need to increase tariffs with some countries. And in other cases, I don't think it's a right move. It will just decrease trade and make goods more expensive. So it's a very difficult topic, but not one that's related to immigration per se.
That's absolutely correct. All right. So, Karen, I would like to know another question from you that we have been talking about the H1B workers, right? Now, I would also like to know regarding the international students that how will the proposed changes, or the changes that we can see in this year, how is it going to affect the international students in the US who are trying to, or who are hoping to have a transition to the H1B status?
I think it's going to impact them based on what job offer they've got and how their degree relates to that job requirement. there's going to be more focus on that. So I think that beneficiaries need to be very careful or selective about the jobs that they take to make sure that the job position is related to the courses of study that they took.
Absolutely. But Karen, what do you think? I mean, can you suggest some jobs that will be beneficial for the H1B workers? Any options regarding what jobs will it be?
Well, I think it depends on what their course of study is. If they have just a general business degree with no computer courses and they've got a job offer as a software developer, that's going to be problematic if they haven't taken any computer courses during the course of their study. So I would say that they would have to have a degree in information technology, computer science, or a related degree, or at least have done some courses in their degree that relate to software development.
Right. But also, Karen, regarding the H1B modernization rule, there has to be a word to word, I would say, worker, right? So, don't you think the H1B modernization rule will make the H1B workers process little difficult or challenging?
I just think there'll be greater scrutiny. I think if you have a well prepared petition, you should be fine, where it outlines how your courses of study relate to the job.
That's right. That's absolutely right. Okay. Also, Karen, I would like to know some questions regarding the spouses and the family immigrants as well, because it's not only the H1B workers, but it's also their family and their children. So, firstly, I would like to know regarding the spouse that are spouses of H1B visa holders, especially the H4 visa, are they likely to face any changes to their work authorization in this year?
Sorry, you were breaking up. I didn't understand the last part of your question. I didn't hear it properly.
All right, no worries. Okay, so I think now I am a bit clear, right? Okay, Karen, can you hear me now?
Now I can, yes.
Okay, okay, all right. So, yeah, Karen, I would like to know it from you that are spouses of H1B visa holders likely to face any changes on their work authorization?
I don't believe so. I mean, I don't know. I'm just guessing, but I don't think that there will be changes for spouses of H1B workers. Generally, spouses on H4 visas cannot work in the United States
Mhm.
unless the H1B holder has an approved I-140 petition. And I don't expect that to change under the Trump administration.
All right. Okay, so I would like to know it again regarding the proposed or maybe the changes that we could see. So, Karen, how do you see that? How might the proposed changes is going to impact the U.S. economy and its global competitiveness?
Well, I think that the H1B allows some of the best and brightest talent to come to this country. And that's why I think market forces should dictate whether H1Bs, how many H1Bs there should be.
Mhm.
So I think that impacts the United States competitiveness in the global market. And if we can have the best and brightest educated in the United
Yeah.
States, which indirect US taxpayer dollars, it makes no sense that after they have studied here, learned or everything about our education system, that they should not have a job here and they have to go back to their home country. That makes no sense because all we are doing is educating some of the best and brightest and then exporting them overseas. So again, I
Mhm.
believe that market forces should dictate how many H1Bs there are.
I think, yeah, that's very well explained. All right, so thank you so much, Karen, for letting us know about these things. And we do have our viewers' question, but this time, it's a little different because most of our viewers are watching us on Facebook. and on LinkedIn as well. And I think so. Let's take up our Facebook questions because their viewers are watching us. So, yeah, Control, I think we got our viewers' question, and this is we got from anonymous member. So, here's a question that I have unstamped H1B visa. Can I visit Puerto Rico as it's part of US? Yeah.
Yes, you can visit Puerto Rico because it's part of the United States.
All right. Okay. Can we have the next question, please? Okay, so I think this is the question that we got from Indian applicant, and he is saying, "Admin, please approve the post." Okay, can't we schedule H1B visa interview first time in Chennai? My agent is saying first time H1B interview in person can be scheduled only at Hyderabad. Please let me know. Thanks. I think this is something. What else we can say on this, right, Karen?
Can only be scheduled in. Sorry?
Yeah, yeah. Please go ahead. Please go ahead.
It's my understanding that it needs to be scheduled in Hyderabad, but I'm not sure. I need to research that for you.
Absolutely. It's a little different question, but that's okay because our viewers are mostly from India, so they have been taking these questions more into their concern or where the interview must happen or where the scheduling part happens. All right, let's move ahead with our next question. And this we got from Priya. So Priya is asking, this is my first time H1B and I traveled to the USA, but no luck. I did not get any job offer. My visa expires by March 2025. I am planning for transfer and extension through different employer. During my extension process, can I come back to India and then go back? Yeah.
You would need to consular process your application, and then go for an interview in India and come back. You can't travel during a transfer unless you consular processing.
Okay. All right. All right. Also, Priya, I think here's a Priya's question that we took. But Okay, let's take the other one. And here's a question that we got from anonymous participant, and it is that I have received email to submit my passport yesterday. However, I am out of country and will take 2 months to go back to India. Meanwhile, can I submit my passport from current location through courier service to India? Yeah.
I guess you could. It's risky, but you can try do it that way. Generally, you should be in the country when a visa is issued to you. So it's risky, but you could try it.
Okay.
My advice to you would be to go home and be in the country when the visa is issued.
Absolutely. All right. Thank you so much, viewer, for answering this question and putting up this in Karen's show. Next, we have from Vasu Rana, and he is asking that did anyone get their H1B stamping done after 20th January 2025? I'm skeptical after knowing about the recalcitrant country ban imposed by the new administration. Anyone tried stamping in other countries apart from India? Yeah, need to know about your experience for both India and other country. Yeah, Karen.
First of all, I don't know of, or I'm unaware of any recalcitrant ban imposed by the new administration. I'm not sure what the view is talking about. As far as I'm aware, there is no ban. We have had success with both with India and other countries in H1B stamping. There hasn't been an issue at all.
All right. Okay. Thank you so much, Vasu, for your question. And in case if you have any follow-up question or any different question that you would like to know regarding our today's topic, then please go ahead and let us know. Okay, so this is another viewer. Puneet is here, and Puneet is asking that my H1B extension was filed with USCIS on January 27, 2025 in premium processing. We bundled H4 for my spouse and one kid and H4 EAD petition in premium processing for my wife with my H1B extension petition. So on February 4th, we received approval for H1B extension, but H4 and H4 EAD petition status shows that moved to a different office online on USCIS website. So he's currently very confused, Karen, and he is saying that if they moved H4 and H4 EAD cases to a different office under normal processing, not premium, then he checked with his employer's attorney, but they said that they are not sure at this time since the rule changed after January 18th, 2025. So he thinks that most of us may be aware about this thing. So yeah, Karen.
Typically, premium processing, you're paying for premium processing for the H1. So USCIS is entitled to process the H4 under normal processing. The fact that they've moved it to another office is just because there's probably more staff in that office, and the H4 will be processed under regular processing.
Okay. Thank you, Karen, and thank you, Puneet, for putting up this question. And let's move ahead with the next one. Brittany is here. And hi, Brittany. Thank you so much for joining us. And she's asking, hello, everyone. I got my OPT for 1 year and it expires tomorrow. Is there any way that I can stay without problem in my status couple days more in the US?
Well, I mean, I have to advise you that you should probably leave the country, but because you don't want any overstay on your record. Any overstay is going to cause consequences for you when you apply for a visa. Again, you'll have to disclose that you overstayed the visa, and that may impact successful application. However, there are bans on applying for visas for 3 or 10 years. If you overstay by 180 days, then you will incur a 3-year ban to applying for any visa. If you overstay by 181 days or longer, you will incur a 10-year ban. So you need to be careful of incurring any bans, but even if you overstay by a few days, that has to be disclosed in your application, and then you may be denied a visa in the future because they'll think you'll overstay that visa. I would leave as soon as possible.
That's right. Okay, Brittany, thank you so much for putting up this question, and I hope you got your answer. In case if you still want to contact attorney Karen V. Pollak, then please go ahead and we'll share the contact details with you as well. And the contact details are on the screen, and let me read out her phone number. That is 214-504-1227. And her email ID is karenlp@pollakimmigration.com. And you can also visit her website, that is www.pollakimmigration.com. So, friends, I think you can call her or email her or also visit her website to know more about her so that you can understand what different visa applicants, you guys can ask those questions towards any problem or any complexities that you are having in your immigration journey. So with that, I would also like to know, Karen, that we have almost reached to the end of our episode, and we covered a lot of questions. Those questions that I have also prepared and questions that we also got from our viewers. So, any last message that you would like to share with our viewers? Anything regarding how they can be staying updated, or any message regarding our today's episode?
Well, you can always follow our blog at www.pollakimmigration.com, where we're always posting updates on various current topics. If you are entering the H1B lottery this year, get with your attorney, get with your entering those accounts with USCIS as soon as possible, and to register your account right now. Start getting all your documents together. The lottery begins on March 7th through March the 24th. So it's very important that you get key documents and information to your employer, attorney as soon as possible. Good luck. Good luck with the lottery this year.
Let's see what happens. Maybe we can't find lottery system this year because Trump is so much, I would say, aggressively. He's putting up those executive orders. So maybe he can remove those different system that
Okay.
he doesn't like at all. We can't say anything, but
I
that's
don't
okay.
think we've
Karen,
got
thank you.
enough time to do that.
Oh,
Oh,
okay.
you're very
But
welcome.
mhm.
Thank you for having me.
All right. All right. Okay. Thank you so much, Karen, for being here. It was really lovely having you. And as always, it has been really productive and very insightful because we didn't cover only one aspect of today's topic, but everywhere, how international students will be, how international relations will be, the future, how the future will look like, how the past experience also. So we have covered a lot of different subtopics in today's episode, and that was really insightful as always. So thank you so much, Karen. We really enjoyed this session, and we hope to see you soon again.
Okay, take care. Good luck, everyone.
Absolutely. All right. So thank you so much, everyone, for being here. It was really lovely having a very great conversation with attorney Karen Lee Pollak. And we'll come back again with another very exciting webinar. So put up all your questions and let us know also what topics you would like to cover in our next webinar. And we'll make sure that we are definitely going to talk about those topics because I know most of our viewers are really concerned about how the future will be, or what should you expect, or how you can keep yourself secure and protect yourself, especially your immigration status. So don't worry at all because we are here to make you guys updated regarding the immigration policies and also the global politics around the world. So make sure to like, share, and subscribe to Immigration Talk Show. I'm Sam signing off for now. Goodbye, everyone, and take care. Thanks for joining.
Bye bye.
Happy to be back here. And thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also Twitter. And I'm happy to tell you that you can also participate in this webinar with us. But before we move ahead, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, thank you so much for joining us today. And we've got a great session lined up for you. And today we are diving into a topic that's vital for many businesses and workers across the United States, the H2 visa program. And so, whether you are a business owner seeking to sponsor seasonal or temporary workers, or a worker instead in learning more about your options, this webinar will be invaluable. And I'm really thrilled to be welcoming our guest for the first time on Immigration and Jobs Talk Show, none other than Megan Kirkner, who is the founder of Kirkner Law PLLC. With nearly a decade of experience in immigration law, Megan has become an expert in H2A and H2B immigration matters, and she'll be walking us through everything today you need to know about legally sponsoring workers and also exploring the processes of working as a seasonal temporary worker in the United States. So yes, I think you can go grab a pen or paper if you're still old school, or maybe even note down some pointers in your tab or your phone or your iPad. Thank you so much for joining us, and let's get ready to really learn some key highlights today and these insights that Megan is going to, share with us. So, Megan, thank you so much for joining us today. Really happy to have you here.
Hi, great to be here. Thanks for having me.
Yes, Megan. I don't know if the introduction was enough, but we would love to know you much better. Please tell us about yourself and how busy you are these days.
Sure, like many immigration practitioners, it's a hot time. There's with unemployment where it is, everybody is just looking for people to fill empty slots. The H2B and H2A realm is just extremely busy. I service employers all around the U.S. In both H2A, which is agricultural, and H2B, which is non-agricultural workers, in the seasonal temporary visa process. Been doing immigration for over 10 years now, and you know, it is a hot segment right now, and we're all on pins and needles with the U.S. political climate, and just hoping we stay busy.
We are. I already feel it is, and especially with the elections just over just some time back, and everything
Yes.
changing right now. And in the next coming months, we're going to see a lot more
Mhm.
changes. I think there's a lot
Yeah,
on our plates, on everyone's plate. So,
very much so. A whole another segment for that.
for sure, Megan, for sure. And today's topic. So, what can folks out there expect from today's webinar from us?
Sure. So today's focus is really going to be on the H2B side of the seasonal worker program. The agricultural H2A side, it would have to be a whole nother show. But what you should learn, how an employer would get involved in the program, whether or not they would qualify, how the process looks, what the risks are. Um, what compliance components they need to be aware of, what workers should know and what they should know their rights are in the process so that they are not taken advantage of. So really just trying to focus on giving a little background knowledge from start to end, on the employer side, and touch on the, employer rights side as much as we can.
We will. And I'm sure folks out there are very excited as well. So happy to tell you that you can participate wherever you're watching us. And if you have any questions, especially regarding the topic, please feel free to drop them in the comments. And Megan is definitely going to be very happy to take them up later in the show. So I'm excited too, Megan. Thank you so much for doing this today. And
Sure,
without further
absolutely.
ado, I have a few questions lined up. So let's go ahead with the first one.
Sure.
So, what are the key steps an employer must take to obtain a temporary labor certification from the Department of Labor for H2B workers, and what documentation is required?
So, just as a little bit more background, the H2B is a full-time temporary non-immigrant visa. It is seasonal. So unlike many other visa types, it's something you have to apply for every year. Unless you're doing a one-time need, that's a separate category for like a nanny or a caregiver. That would be for up to 3 years. The rest of the visas, the bulk of the H2B process, for your hospitality, landscaping, seafood industries, construction industries, those are seasonal or peak load, meaning it's an annual application. It involves 3 separate government agencies. That's Department of Labor first. We'll get into what that entails in a minute. The USCIS, U.S. Immigration Services, is the second agency, and the third would be Department of State. That's the consular processing. So that's where the worker would come in, and that's at the point that they would go get their visa. The first step in the process is critical. One of the key compliance components of this program is that all workers are paid at least a prevailing wage, which is mandated by the government. It's to ensure that they're receiving a fair wage based on the type of position they're working in, and the location and experience required for that position. So, it just really ensures that the program maintains its integrity and no one's being paid something that's too low for what they're working on. That's the first step in the process.
Mhm.
All of these steps in this process can be time intensive. So it is very much sensitive to what part of the year you're applying for, what your dates of need are. So this prevailing wage step takes up to 60 days sometimes. So you really have, for all parts of this process, you need to allocate at least 6 months. You need to know at least 6 months ahead of time in order to ensure you have enough time to file with each agency. The way the program is set up is that there's 2 halves of the fiscal year. So that if you're based on your start date of need. So if your start date of need is in October, you'd really start prevailing wages more than likely in April, so that you can file in July. You file your H2B application, which is an ETA 9142B. That's the second step in the process. Once you have prevailing wage, you can start that process. And again, if you're at April 1st start date or later in the second half of the year, it goes by the government fiscal year, which starts in October. My apologies. You will need to start that process probably in August of the preceding year. If you're looking for instance, starting an H2B worker April 1st, 2025, you're going to need to have already started that process. It may be too late at this point to get a prevailing wage back in time to start the process for next spring. That being said, once you've gotten that prevailing wage and you file the second step in the process also with Department of Labor, that actual H2B temporary labor certification, that would require you to set forth with the government whether you're filing for one-time needs, seasonal, or peak load. So that would entail documentation if you're a new filer, a new employer, establishing your seasonality, establishing your season and your need for the number of workers you're requesting. Typical documentation would be a statement of need, which again explains your business, your season, your industry. Taxes for the company, could be revenue charts, payroll showing when you have workers. Those are very common documents, as well as contracts. Really what you're showing at this stage is that your business operates either seasonally, meaning you only operate during the season, the times that you're telling the government you operate, or that you're peak load, meaning you operate year round, but there's a peak, there's an objective increase in your business or revenue during particular months of the year. That would be your season. So all of those kinds of business documents can prove that seasonality, prove that temporary need. Now, that application gets lodged with the government on one of 2 time periods, depending again on your start date of need. It's either July 3rd for October 1st filings or January 1st for April 1st filings. There's technically a 3-day filing window that you have at the beginning, but it starts on January 1st and July 3rd, unless it's a leap year. So that's when you file that application. The next step after you actually lodge the application with your supporting documentation is your company will be, this is what they talk about when they talk about the H2B lottery. All of the employers are put into a pot in a computer and randomized. Your company will be assigned a group letter, A, B, C, D, and so on and so forth. And while that letter or that group doesn't truly dictate whether or not you get workers, it's more nuanced than that. It does impact the timelines, and more so for the spring visa half than the winter. That letter will determine whether you beat the cap from in all cases for the most part for the spring. It's there's enough employers or applications for the number of workers in Group A, for instance, in the spring to encompass the entire cap. So if you don't get it, that's not to say that if you don't get Group A, you're not going to get workers. We'll get into it later in the program over what the cap is, if there's other ways to get in under the cap or other mechanisms to file with supplemental visas. We'll talk about that in a little bit. But assuming you get in and there are still visas available to file the next step is filing with Immigration Services. You take your certification from Department of Labor and you file it with the USCIS. If you're approved, then you can move on to Department of State and file for the actual visas. There are more steps, such as recruitment, involved in the Department of Labor step before you get your certification, but we'll kind of delve into that a little bit later when we talk about recruitment and things like that. So there are a few more steps involved with Department of Labor before you get to USCIS, but that's kind of in a nutshell, the general steps.
Thank you so much, Megan. Those are really good points to keep in mind, and thank you so much for highlighting, especially the documents required. So, thank you so much, folks out there. I know you are excited as well. Thank you so much for joining us. I'll quickly say hello to Tanya and Nishtha, who have commented with their questions. Please stay with us. We are going to take them up a little later. So, right now, another question I have for you, Megan, and that is, how does an employer demonstrate that
Mhm.
there are not enough US workers who are able or willing or, qualified and available to perform the temporary work as required by the H2B program?
Sure. So that is what I alluded to a little bit ago with the
Yes.
additional steps that are really happen between filing your temporary labor certification application with Department of Labor before you get certified. There's something called recruitment. Um, at this point, the recruitment, every employer, once they get a notice of acceptance, they will, meaning that the government hasn't asked for any additional documentation. The government could issue what's called a notice of deficiency asking for more information. But if they don't do that, you get a notice of acceptance and then starts recruitment. The recruitment process is how the government essentially asks each employer to test the US labor market to ensure there are no qualified US applicants who can fill these roles. Um, there, the recruitment period lasts 15 business days for most of these steps. However, every employer still beyond this recruitment period, at the close of which, at the end of the 15 calendar days, the employer will file a recruitment report which details every US applicant, how they applied, whether or not they were hired, the outcome of that interview, if there was one, if they're able to reach them. Um, Based on that recruitment report, the government will then certify the employer for either the full complement of H2B workers requested, or they will reduce that number based on how many US hires they make. So if you're asking for 10 H2B workers and you are able to hire 2 US workers, then you've proven to the government that there are 2 qualified US workers. So your true need is only 8 workers. But in order to get to that process, there are a number of recruitment steps that every employer must take. The first of which is an internal posting notice in their job at the job site. So whether that is a break room or an HR office or a primary office, at least 2 spots at the place of employment must post this H2B job order. So that would have the terms and conditions of the H2B position, any job description, title, location, deductions, benefits, all of that information is required in this job order that gets posted at the work site. Now, in addition, that same posting, the same content at least, is posted on the state workforce agency. Every state has a different process for posting jobs that are available to local candidates. Think of it as like Indeed, but it's run by a state. So these postings get put online with the state workforce agency, and every employer must field applicants that are interested in the position. Another required recruitment step is, which again protects U.S. workers, is every prior U.S. worker that employer has had in the past year must get a copy of that job order so that they know they're hiring for that position again. The only exclusion would be workers that were terminated for cause or workers that quit or abandoned the job. So those workers would not get a letter, but other U.S. workers that may have worked seasonally in the past year would be entitled to know that this job is open again. Another item that could be by phone or certified mail is the best way. So the employer is protected and you can prove you've sent it to them, the last known address. Another less common recruitment step is if the employer participates in a collective bargaining agreement, they must publish that job with the CBA representative so that it's advertised across the organization. If the employer has a website or somewhere else internally, an intranet, they normally post jobs, that would also be somewhere that would need to have the job posted. If they have one. If they don't have one, it's not something that they need to create for the purposes of H2B. It's only if it's normal course of business for them to post jobs in that manner. The last part of recruitment is performed by Department of Labor. Department of Labor will post the job order on seasonaljobs.gov and make it available nationally so that anybody who's looking for H-2B jobs or anybody that's looking for a job it'll come up on a search. So if someone searched landscaping in Richmond, Virginia, it may come up. It would be available on that website. So the last component that is important for U.S. workers is to know is that this job rec, even once that 15 calendar or business days have passed, while it won't impact the number of workers the employer is able to get with H-2B, they do need to continue to accept U.S.-based applicants up until 21 days before the start date. So it's not going to impact their H-2B worker count, but they do still need to field U.S. applicants. They are obligated to do so. Again, the purpose of that is just to ensure that there's no additional opportunity afforded to foreign workers over U.S. workers.
All right. Thank you so much, Megan, for for the detailed explanation and helping us with the answer for that. Thank you so much. I have this next question for you.
Mm-hmm.
So, what is the current cap on H-2B visas for fiscal year 2025, and how can an employer access the additional supplemental visas announced by DHS?
Sure. The annual quota for H-2B has been 66,000 since the 90s. And it's divided into two halves. The first half of the government fiscal year on October 1st, is allotted 33,000. The second half of the government fiscal year, which opens on April 1st, is also allotted 33,000. The demand far outpaces supply for those initial visas year over year and has for a decade. So in 2017, they started issuing what are called supplemental visas. They are not in the regulations. They're not guaranteed, but the government does have the ability to issue additional visas if they elect to do so, if they can agree to do so. This year, they did announce that they will issue almost 65,000 additional visas for this fiscal year. However, the text is not yet available for the 2025 fiscal year, but if we assume it's the same as the past two fiscal years, which it has been largely the same as far as eligibility and compliance, then we can expect it to be broken down such that a portion of those additional visas will be allocated to the first half of the fiscal year and what would they call returning workers. So if you've never had an H-2B, you're not going to qualify for the supplemental visas under returning worker exemption. Those are workers that have had an H-2B at least one time with any employer in the past 3 government fiscal years. So if you had worked for anybody, you would be eligible if your employer wants to file for supplemental visas. So again, that is just a little bit of a security net for employers that miss the initial cap, that they have a second opportunity to try and take advantage of the H-2B visas for this year. There's also an allotment similar to that for the spring. In other words, if you miss the cap for April 1st in the spring, again, if you have workers or know of workers that have had an H-2B at least once in the past 3 years, they would qualify as returning workers. And there will be visas in the spring as well in that same category. Additionally, the spring has another category of returning workers. Typically, that is reserved for late season H-2B employers. So if your start date of need is not April 1st, if it's May 15th or later in the year, there's a separate carve out for supplemental visas in that for returning workers for those dates for those employers. The last option for supplemental visas is what used to be called Northern Triangle. Now it's called country-specific allocation. It is open to workers from a specific set of countries that have never held an H-2B visa, but employers, there's a brand new cap from these supplementals. So if the employer will take recruits from this subset of countries, then there's a whole extra 20,000 visas available to employers who will recruit from these separate countries. Those are Haiti, Honduras, El Salvador, Guatemala. They just added Costa Rica, Ecuador, and Colombia last year. And so I think I might have missed one. Honduras, I think I'm not sure I've said that already, but those countries are a great option for employers who don't have returning workers and have missed the cap. Because the nice thing about that part of the supplemental visas is in the years that they've been offering those, that cap has not been hit to date. As, you know, this first year for everything, but those are a more reliable and a little less risky pool of visas to pull from because they have been more open.
All right. So, yes, thank you so much, Megan, for saying that for us also and for the detailed explanation. Well, maybe you could highlight also, how the H2B is different from the other employment visas,
Oh, sure.
for folks out there who want to know where can they categorize themselves.
Right. So, as we know, there's an alphabet soup of non-immigrant visas available. All of them have their own eligibility requirements and stipulations. H2A, those who are going to qualify for H2B probably will qualify for H2A. From the worker standpoint, employer standpoint, that's reserved for agricultural companies, employers that work in the agriculture section. It may be farms that do produce. It just depends. There's a lot of agricultural employers that take advantage of H2A. There are other visas, that so H2A and H2B generally don't require degrees. That's not necessarily true across the board, but it is the only category that's going to have people, without any required specific training. There may be experience or training requirements employer to employer, but as overall, if you're from a country that's on the eligible country list, which you can find online, there will be ways for you to get seasonal employment if you don't have a degree. Those are what H2A and H2B are really good for, as far from a worker standpoint or from a prospective visa holder standpoint. There's TN visas if you have a degree that, if you're from Canada or Mexico, there's a whole list of occupations and there's no cap for TN. So if you have a degree and you're from one of those countries, or if you're, an employer looking for a particular occupation that falls on the TN list, that's a great way to, have workers come in that way. TN, there can be some crossover for some of the occupations that are very similar to the kinds of roles that you may want for H2B. For instance, a landscape architect would fall under a TN, or veterinarian or an animal breeder or something like that. That's related to farms, but maybe you need someone with more skills, more training.
Right.
So something like that. And there's a whole host of other visas I could go over. I don't know how many of them you'd like me to talk about.
But yes, thank you so much. Thank you so much for highlighting those differences of the H2B and other employment visas. Thank you, Megan.
Sure.
And Megan, we have a viewer who has joined us. So nice of him. This is George from Nigeria. We're really happy that you have joined us. So we would love to take a couple of questions from George if he has any. So Control, if you could just let him in. Yeah, please ask your question. George, are you there?
Yeah, can you hear me?
Yes.
Yes, we can hear you now. Great.
Okay. Um, the question I was gonna ask had to do with um, you loosening up a little bit regarding your policies. Um, like I said yesterday, everyone does not have to come to America. Okay.
Mhm.
If the government actually loosen up a little bit, let's say, just like what you're talking about, they have quarters they're giving for H2B visas. So if you have search for remote, you tell the companies, look, you can get anyone outside of this country. They don't have to come to America, but they're going to be working on the remote basis, right? And before you have to pay their salaries, then do what they call tax deduction from the salaries before you pay out, right? So I think if that would be looked at, it will be a very good idea, because one of the reasons why you have the Americans coming up with several immigration policies is because you have a lot of people
Can you hear it? I can't hear.
I think, yeah.
papers or documents are being expired, and then they also want to continue the work. Can you still hear me?
I
Yes.
missed that middle part.
Yeah.
I heard that if their documents are expired, but I missed a part.
Hi,
of
can you
that.
hear me?
Yes, we can hear you. Could you just repeat the part where just some time back you were saying? George, are you there?
Yeah, I'm
I
here.
think
So
okay.
did you get what I said?
No, we didn't hear the question part. I'm sorry.
Could you just repeat your question, please? The question you just asked some time back. George, if you're still there.
Yeah, I'm here.
Uh, so sorry, we couldn't get your question. Could you just tell us what your question was?
Okay, the question is, can American government look at, loosening up a little bit and allowing companies, independent companies, actually employ people from other countries without they coming to America, and the American government providing some sort of tax identification number for remote workers. I think if you encourage that, that would actually strengthen the job quality you have over there, and also
The government here in the U.S. has been very apprehensive about changing policy. I mean, like I said, just in my experience with H2B, the quotas have not changed since the 90s. So while there may be many ideas that would be beneficial to both the U.S. economy and workers abroad, I would not expect there to be any meaningful change or positive additions to immigration, particularly with the upcoming administration change. I would not expect that to happen right now. That's not to say it would never happen, but I wouldn't expect a tremendous amount of change, at this point. There are many other countries that allow, such as things like digital nomad visas, where they can come work remotely from their home country in the U.S. and do things like that. We don't have anything like that here. Our immigration categories have been fairly static for quite a long time. We have not had comprehensive immigration reform since the 90s. And with the polarization of this topic overall, from an employment and family-based side, I just would not expect there to be any change. There may be many great ideas that people could bring to the table, but adoption or passage of that would be very difficult in this climate.
Thank you so much for taking that up. And George, do you have any other questions? George, are you still there? All right. Thank you so much, Megan, for taking that up for George. I think there might be some network issue, but I hope George got the answer he was looking for.
Sure.
And if he has any further questions, I'm sure George will drop them in the comments or maybe rejoin us soon. Meanwhile, I think let's take up Tanya's question. I run a small landscaping business and want to hire workers for our busiest season. How do I start the process of sponsoring workers under the H2B visa? And are there specific forms or steps I need to prioritize? I think we touched on this earlier already, but if you could just
Yes.
highlight, yeah, anything.
Yes. If it's landscaping, I would assume your busiest season would fall in the spring. So at this point, the first step is starting to file a prevailing wage application with Department of Labor. That's the very first step required, no matter where you're filing, what position you're filing. So you just need to know what position you're filing for and get that application lodged with the government. You can't move on to any other step if you don't do that first. So you should find someone that can file that for you. I have a great number of landscaping clients. So I'm very familiar with that process from start to finish. At this point being mid to late November, it would be very tight to try and get that filed for next spring. Unfortunately, it's not impossible, but timing would really have to work out in your favor. That's the first thing you need to prioritize. And if the only other thing I can say that is if you have workers you want from a particular country, make sure they're on the country list. I get a lot of questions that say they know somebody from X country and that country is not eligible for H2B at all. So if you're wedded to one particular person, make sure that they qualify before you bother starting the process.
Great. Thank you so much for taking that up for Tanya, Megan. Thank you so much, Tanya, for participating with your question. And well, I have more questions lined up, but let's take up Nishta's question first. I've worked under an H2A visa before. Can I apply for H2B visa next, or do I need to wait for a certain period of time before reapplying? Uh, And how soon can I reapply for an H2 visa after my current one expires? Is there a limit or on how many times I can apply?
Mm-hmm. Okay. So the answer is it depends. For part of that. So if you have been on an H2A visa, whether or not you can apply for the H2B visa, it just depends on how long you were here on the H2A visa. So one of the eligibility requirements for H2 workers, whether that's H2B or A, you have up to 3 years of H eligibility, at which point if you enter, say, January 1st, 2020, then your H authorization would have expired in January 2023. So if you have 3 full years of eligibility, you can reset that by, if you've been outside the US for 3 consecutive months, then you reset your H time and you get another 3 years. So there's no limit to the number of times you can be on an H2 visa, A or B, but there are time limits for each stay. So if you were to come in, like I said, say April 1st, and you change employers, so you're never out of the country for more than 3 months, then you're going to be limited to 3 years. And at some point during that 3 years, you need to reset. You need to be outside of the US for 3 months to get more H time. And that, you can certainly have an H2A visa, go home, get an H2B visa, and come back. That's fine. You can do both. There's nothing to preclude you from participating in both programs. You just need to make sure you're aware of what your limit is and make sure that you've been out to reset that clock at least for 3 months if you're here for that long.
Okay. Okay. Thank you so much for taking that up for Nishta and for the detailed explanation, Megan. And now we have Samuel. Samuel is on YouTube. He also has a question asking administrative processing in H1B visa for 9 months. What can be the cause?
There is not very much transparency for administrative processing. For instance, if I, as the attorney, email the consulate and ask, why is this administrative processing? What do you need from me? What do you need for the worker? They will give me a canned response that just says it's an administrative processing and we'll contact you if we need anything. There could be a whole host of reasons why you might be in administrative processing. Your name, it could be something as simple as your name is similar to someone who has some overstay issues or a travel issue or is on a list somewhere, flagged in the system. It could be that you've overstayed. It could be that they're unsure of your intent to return home. That's called, immigrant intent. They could be questioning whether or not you will stay permanently if you're issued the visa. There's a whole number of reasons that we'll probably never know the answer to, unfortunately. You know, for instance, I just had someone try to process in South Korea, and she has no red flags. You know, she's no criminal history, no prior one prior U.S. visit. There's nothing on paper that should have precluded her from being issued a visa, but she was put in administrative processing briefly, and then, you know, certainly not 9 months. But the reason they gave ultimately for being refused was that they questioned whether or not she would return to her home country at the end of the visa. You know, there's the consular officers are given a great bit of discretion to review the applications, and they don't give us a lot of transparency. I said South Korea for that process. So, you know, there can be any, and this would come up from any country, anybody from any country on the eligible list. And sometimes there's a surprise like that. For instance, that client, it was a surprise to have that happen. There were no indications prior to going to that interview that there would be any issues. So I wish there was some way to find out why you're in administrative processing.
Right.
But there's not very many good ways to do it.
All right. Thank you so much. Thank you so much for taking that up for Samuel. Samuel, if you have any further questions, you can keep commenting and we'll be addressing them very, very soon. Thank you. And now let's take up Mukesh's question. This is also on YouTube. He asks, if our company hires an H2 worker who doesn't show up, what are our obligations and potential liabilities? And what happens if an H2 worker gets injured on the job? Are we liable?
So I'll take up the first part of the question first. So if you have H2 workers and someone disappears, you know, they abscond. If they have, that's typically if they haven't reported to work for 5 days, they have been non-responsive, they're AWOL, they've been absent without leave for at least 5 days. You can report them as an abscondment. So, and you are required to report them if you know they're not coming back. For instance, if they've quit or left in some way, and you know they're not coming back, and you haven't given them permission to leave. You know, people leave all the time, but your obligation as an employer is within 2 days of knowing that they're not coming back. So they told you they weren't coming back, or it's been 5 or more days, and they haven't reported to work. No one knows where they are. You can assume that they've absconded. You have to report the departure to the government. You have to report it to Department of Labor, and you have to report it to Immigration Services. That will insulate the company from being on the hook for the 3/4 guarantee when the worker's not there. So that's one of the compliance requirements. We didn't get a chance to get into those today. But on the employer side, one of the requirements is the 3/4 guarantee, meaning that it's a full-time position, 35 hours or more. Mm-hmm. You have to, as an employer, offer them at least 3/4 of those hours offered, whether you say it's 35 hours or 40 hours. If you have to report them as missing or absconded, or if you fire them, you still have to report them as an early departure. It's one of the compliance requirements is to report a missing worker. As far as workplace injury, that falls outside of the scope of immigration, and it's going to be based on your state law, whatever your state workman's comp is. You would be liable in the same fashion as you would a U.S. worker. So if would be liable for workman's comp for a U.S. worker, it's going to apply for an H2 worker. Now, on the worker side of that, if they're injured on the job and need surgery and can't travel and the end of their visa is coming, they need to look at changing it from an H2 visa to a B visa, a visitor visa, and do a change of status so that they're not here unlawfully on the H2 because they're no longer working. So it comes up in rare cases, but yes, if someone's injured, they need to make sure, and they can't travel home for treatment, we have to be able to make sure they stay in status.
Right. Thank you so much, Megan, for highlighting and for giving us such important points today. And thank you for also taking up Mukesh's questions at the same time. Thank you, Mukesh, and you can keep commenting if you have more questions. Now, coming back to our questions, Megan, I have another question, and that is, what are the robust protections in place for both American and foreign workers, under the H2B program, and how must employers ensure that these protections are met?
Right. So there's many protections for both U.S. and foreign workers. On the U.S. side, there's some, basically it boils down to making sure that a possible U.S. worker is not treated in any less fairly or afforded any fewer opportunities or no more requirements than would be required of a U.S. worker. For instance, if you're filing a landscaping position, a corresponding worker couldn't be required in the U.S. to have 5 years experience when you require 0 experience for a foreign worker. So, each business, when they file the application with the Department of Labor, has to sign an attestation with all these compliance requirements listed, noting that they understand what those requirements are and that they will abide by them while they're participating in the program. Now, workers, to start out with, for corresponding workers or foreign workers, they should get before they start, or if they're a corresponding worker and they already be working, because that could be a worker that's worked for a year or less with the same employer. So again, corresponding worker means it's a U.S. worker either present, already working, or one that you hire during the recruitment process that performs substantially similar duties, same job. That would not be your secretary or your landscape manager if you're coming in as a groundskeeper. If you're just doing a landscape laborer job, corresponding workers on the U.S. side would be the same position, not something that's unrelated. So again, the employer can't impose any requirements or obligations they wouldn't impose on the H-2B worker, and they also, have to pay them at least the same as they're paying the H-2 worker. Now, anyone in the H-2B process, which is going to apply to corresponding workers as well as H-2B, because if you have H-2B, then you have corresponding workers more than likely. A big component is prevailing wage. That prevailing wage is the first step. I talked about the employer process, but it's important for the workers because when you get the terms and conditions of employment before you start, which tells you what kind of job you're applying for, where it is, who you're working for, what the wages are, whether or not there's overtime, what benefits are included, all of that is given to you. So you can track it. You can make sure you're being paid what you should be. And that includes the prevailing wage. Every position is set by the government. And you have to at least make the H-2B prevailing wage. So you get that protection. Also in H-2B, you're going to need to be paid at least every 2 weeks. They can't pay you once a month. There has to be regular paychecks. It's another requirement. On that same note, every employer is required to provide you with a pay stub, which provides you with the hours offered and the hours worked, the pay rate, overtime rate for every pay period. So that should be something that you get. Also, deductions. Unlike H-2A, which does not have to have with tax withholdings on it, H-2B does have tax withholding. So your federal taxes and Social Security withholdings are withheld from your paycheck as required by law. But any other deduction aside from those lawful, required deductions, the employer has to have your approval to deduct it. So if you, one difference between H-2A and H-2B is that H-2A housing is provided, H-2B, the worker is responsible for their own housing. That being said, some employers will give workers the option to stay in employer housing, which means you pay fair market rent and utilities. If you are opting into that as a worker, you have to either pay the employer directly or you can have it withheld from your paycheck. So things like that, health insurance, rent, utilities. Let's see, what's another common one? Loans, things like that could be a deduction on your paycheck need to be approved by you. And they need to be on your pay stub so that you can see what the deduction is. So, you just need to know what's coming out of your check and you're entitled to know that. I talked a little bit earlier about the 3-quarter guarantee on the employer side. It's another thing for employees is that H-2B is a full-time role. If you are offered 35 hours on your contract, you are entitled to at least 3/4 of those. If you're offered 40 hours, you need to be offered at least 32 hours, so you've got some minimum protections to make sure you're not doing nothing. You're getting paid for the work that you expected to be here to perform. And if they don't have enough work, there's still required to pay you for it if it's rained, and it goes for every 12-week period. So that there's a calculation for that you can look up. The employer should be aware of. That's an important guarantee to make sure you're paid as the contract says. Another important item that comes up is tools and equipment. There's no reason you should be charged for tools and equipment. That the employer provides all tools and equipment to perform the job. So that should not be something that happens. Another important note for protection for workers is visa fees. There's under no circumstance should the worker be paying for visa fees. You may pay them at the consulate. Some employers will do that, but you have to be reimbursed the first work week when you get here. Inbound travel, also something that is covered by the employer as part of the H2B program. That one is most employers will prepay it for you. Some may pay it when you get here. The regulatory requirement is that as long as you stay, you have to stay for half the employment contract to get the inbound transportation. But with federal wage requirements, a lot of times they just pay that with your visa fees up front because they can't take you below the federally mandated minimum wage by virtue of withholding that, by not having you reimbursing that travel. So the bulk of you will have your travel reimbursed when you get here, if not prepaid. Same thing. If you complete your contract, you do not leave early. You're not terminate. You're entitled to have the employer cover your return transportation. So you finish the work contract at the end of the season, your employer is responsible for sending you back to your point of origin. So that wherever country you came from, you get travel reimbursement back to your home. Very important. Same thing if you're terminated, you still get return transportation. The only time you don't get return transportation is if you quit early, or if you transfer to another H2 employer, then that new employer is responsible for paying your travel to the new employment site. So those are very important. Another very important thing that workers should know, and this comes up not in the employer context, it is an employer compliance requirement. Employers should sign something if they're using a recruiter, the employer should have something signed that the recruiter says that they're not going to charge workers a fee. No H2B worker should pay an employer or a recruiter a fee to be referred to H2B. Very important. It's not something that you should be responsible for. And violations for this, there are audits from Department of Labor, there are site visits, inspections. Employers are required to maintain an audit file with all of this documentation, copies of your pay stubs, copies of reimbursements. The employer should have copies of all of this. And workers also, there should be an H2B rights poster that the employer posts in the work site. That also will have details on how you can whistleblow, how you can report it. There's anti-retaliation components as well, so that the employer can't retaliate if you report wrongdoing or mistreatment.
Wow. Those are, a great number of protection rights and laws and rules and regulations you highlighted. And thank you so much, Megan. I think once you have the passion to work and you have the right documents and you're on the right path, I think nothing can stop you.
Right.
So thank you, Megan. And we have Samuel who's back with another question. I think we should take that up. He's asking, can my spouse, who is my dependent on an H1B visa that is in administrative processing, apply for a visiting visa?
There's nothing to preclude her from doing so. But again, there's very little transparency into that application process. So, it's possible for a spouse to also be put in administrative processing for anybody can be put in administrative processing for any visa, for them to review it. But there's nothing, just because you have a visa pending, that also doesn't mean she couldn't apply for her own H1B, her own visitor visa. There's nothing to preclude, again, assuming she's eligible or can qualify. Your being in administrative processing isn't going to prevent her from doing something else. Even if she's on an H4, she could still theoretically apply for a visitor visa. Whether or not it's approved, is anybody's guess.
That's cool. Thank you so much for taking that up. And Samuel, I hope you've got your answer. Thank you for participating. I have another question, Megan, and that is, how does the H2B program ensure that foreign workers are not exploited by the employers?
Right. So that a lot of the same things will apply from the compliance requirements. All of those compliance requirements are in place so that workers are not exploited. You have a prevailing wage to ensure the worker is not paid too little. There's, again, reporting opportunities with Department of Labor to report employers that are, misusing the program, so that your protections are remain in place. There's also, depending on your state, there may be nonprofit or volunteer groups that can also provide services to help if you are, being subject to mistreatment. So, all of these protections and compliance requirements that you should be entitled to, they can be enforced in the same way. Though you can report them and they can be subject to penalties for that. And I don't know if we'll get to the penalty question or whether I should cover that here, but there are penalties that the employer can suffer based on that, depending on what the violation is. Again, the anti-retaliation requirements are important for that. Workers can file a complaint with the Wage and Hour Division with Department of Labor for any of those violations, for being charged a fee, not making your hours, not being paid the correct wage, being denied. Again, another thing that it doesn't come up often, but when there's severe negligence or mistreatment of workers, another thing you should report absolutely is if your employer is holding your passport. Your employer should not have your passport or visa. You should have free autonomy to leave at any time. Be aware of as a worker, the terms and conditions of your visa, and make sure you're not, by leaving, having an issue with your status because you're no longer at the employer. So, there are things to consider for that, but it shouldn't deter you from reporting mistreatment.
Right.
I don't know if you want to jump ahead to the repercussions for employers. I know that's another question, or if I should just get to that later.
Yes, we could get to that a little later, or maybe in our next episode as well, because there's so much to talk about H2B. But
Sure.
I would also like to tell our folks out there, that it's always best to consult an attorney and be guided with your case, because every case is different and needs proper attention. And I would say, why not contact attorney Megan Kirkner in her number, and her number is 434 226 0586. You can note it down. You can also email Megan. Her email address is megan@kirkerimmigration.com. You can check out the spelling on the screen and go visit www.kirknerimmigration.com to get to know more about Megan. Thank you so much, Megan. It was really great. But of course, so much to talk about this. I
A
think
lot
we
to talk
should
about.
definitely do another episode on H2A and H2B visas again.
Sure. Be happy to have
Yeah.
it.
But before we go, what do you have to say about Trump and, starting 2025? What can we expect, maybe, or what do you think the immigration scene is going to look like?
I was just at a conference in DC with other immigration attorneys on Friday, and we're all just ready to buckle up for the ride. H2 in particular was a little more insulated from some of the trials and tribulations that came from the administration last time. A lot of the other employment visas, family-based visas, are going to have much tighter scrutiny. Requirements may change. It's going to be more difficult. If, again, I know you mentioned a lot of people file on their own, but particularly with this administration change, having an attorney navigate the process will be more important than ever, because it's going to change, and it will change quickly, and more than likely not in any way that makes it easier.
I know everybody is so anxious, and I really hope that things fall in place as soon as possible, or at least folks out there get to know what can happen or what may happen with their case. So thank you so
Right.
much, Megan, once again. It was great having you, and I really hope to see you in the coming week.
Nice to be here, and thank you for having me. And best of luck to everyone watching, and reach out if they have any questions.
Yes, absolutely. Thank you so much. And also Samuel, and then we had George who had joined us. Unfortunately, the line was a little disturbing, but I still hope that George, if you have any further questions, you can comment, because after the stream has ended, this is going to be published, and it'll be really nice to have you comment with your question. And I'm sure Megan, you can address that. I will. I will put that up to you.
Yeah,
You too.
sure.
Yeah. Anything else you want to say to the folks out there with regard to the topic before we leave them? Because I feel like we're just ending it so abruptly right now.
Yes, where this is just the tip of the iceberg for the H2 world. I wasn't really able to dive in at a really granular level as far as what employers need to do, how long it takes. So
Yes.
I really just want everybody to know that it can be a long process, but with the right help, and starting at the right time, it doesn't have to be a painful process, as long as you start. But their timelines are critical for this program.
Right. Right. Thank you so much for that hopeful note and an end note. Thank you, Megan. And you have a splendid week ahead, and I'll see you soon.
You as well. Thank you.
Thank you. And folks out there, thank you so much for joining us on YouTube, LinkedIn, Facebook, and Twitter. It was really nice having you, and especially with your questions in the comments. So feel free to like, share, and also subscribe to our channel. Hit that bell icon so that whenever we have discussions like these, you are notified. And really, I'm also looking forward for Megan to join us again in the coming week, because there's so much to discuss about H2 visa, and I'm sure you too have a lot more questions. So thank you so much for doing this today, and don't go anywhere, because we have more webinars and discussions lined up on Immigration and Jobs Talk Show. Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Nipasa. And before we head on with today's discussion and request our guest to join us, I have this very important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks out there, once again, a very warm welcome to Immigration Talk Show, and I'm really happy to be here. So, yes, this is where we break down, all the immigration trends, the latest ones, especially the policies and opportunities with the experts who know them best. And today, we are going to dive into this very interesting topic, EB3 Perm and L1A in 2025. And these are two critical pathways that could shape the future of skilled workers out there, even multinational executives and aspiring professionals looking to build their career in the United States. So, to tackle this hot topic, we have two legal heavyweights in the house who are going to join us shortly. First up, we are going to have Rob Melvin, a 26-year veteran in the legal field and a licensed attorney by the Texas Supreme Court. Rob's career has spanned the courtroom, diplomacy, and high stakes immigration cases. He served as a Foreign Service Officer of the United States Department of State, adjudicating over 9,000 visas, managing security for top diplomats like Hillary Clinton and Mike Pompeo, and mastering the complexities of employment and investment based immigration. And joining him is none other than Philip Rodriguez, uh, an immigration powerhouse in his own right, a partner at Doss and Rodriguez PLLC. Philip has 13 years of experience navigating, everything from family-based petitions to removal defense, armed with a Juris Doctor from St. Mary's University. He delivers customized legal strategies that change lives. So, without further ado, Rob and Philip, welcome to the show once again, and it's really great to have you with us today.
Sure. Well, thank you very much for having us, and thanks for that great intro.
Yeah, thank you, Napas. It's a pleasure to be here, and hopefully we'll have some useful information for your viewers today.
I'm already looking forward. So, as you already know the topic of discussion for today: EB3 perm and L1A in 2025. So, what can folks out there, look for this year?
Yeah, I mean, the EB3 perm is kind of a similar unfortunate circumstance as far as the retrogression goes. The For India, it's currently at a 3-year delay in the availability of the visas and in the ability to change status. However, it can be used in conjunction with some other statuses that you may have in country, if as long as you have an employer that's willing to kind of go the distance with you. So we'll kind of develop that later, but they are very retrogressed for India. So that's the unfortunate news. But we will talk about how, in conjunction with maybe some H1B status and some STEM OPT and other statuses, you can have the EB3 perm working in the background and still have an ability to be here in the U.S. While the EB3 perm whole process is pending. And we'll talk about some of the delays. The biggest delay really is besides the retrogression is with the Department of Labor and their labor certification process right now. So again, we can discuss that in more detail later if you want, but they're very, very, very far behind, and it's a critical component of this particular visa category.
Yeah. And then don't forget about the L1A visa, which we're going to get into today, which is also another way, a viable way for multinational managers and executives to obtain a visa to come to the U.S. Now, it's a little different in that it's a non-immigrant visa, but we're going to get into it a little bit later today about how you can apply or how you can, that can lead into a possible immigrant visa permanent resident route. But those two options, they're still very viable. As Rob has just discussed, EB3 perm for India, it's a little bit bigger hill to climb, but we'll be happy to get into that as we go on.
Absolutely, and we hear a lot of changes. So, what's changed? What is changing this year? 2025 in for EB3 and L1A, and also, how can applicants be prepared for this change, and maybe what can they really do to maximize their chances of success? In short,
Well,
just for now.
the short summation is going to be higher scrutiny, which is kind of ironic because they are so far behind. USCIS is so far behind in keeping up with their workload. Yet at the same time, they're going to have much more extensive documentation and detailed analysis requirements. So that's going to take them that much longer to adjudicate cases or send out RFEs for more information. But the biggest takeaway I would say is submit a super complete package. There's no more, just one or two liner, descriptions of jobs. Everything has to be laid out in extensive detail, and that includes like the financial capabilities of the companies involved, both the foreign and the domestic company, or the non-U.S. and the U.S. company. They are very much going to scrutinize the financials of those companies, particularly in the L1A arena, but then also in the EB3 perm ability, basically to pay for the employee that they're petitioning. So
Right,
higher
that's what I hear.
scrutiny.
It's sorry for interrupting.
Oh, you did it. Higher scrutiny, extremely more detailed.
That's what I hear. That's what I hear. I mean, they say like it's going to be like a 2 to 3 years to 5 years or even more. So you need to have a real explanation of what is your job description really about. What are you going to do in these next 3 years or 5 years, right? So we will definitely get into all those details. Folks out there, stay with us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. Please feel free to join us by participating, and that you can do by commenting. And also another good thing is that you can call us up in case you want to ask the questions yourself to the attorneys who are present here, Rob and Philip. So what you need to do is call us on this number for 435 436. Sorry, if we can have the number, please. So the access code is 425 436 6335, and the access code is 988888. So you can note down this number and call us up. The number, once again, I repeat, is 425 436 6335, and the access code is 988888. Please feel free to join us. And yes, so I think my next question will go out to Philip. So Philip, if you can tell us, the September 2024 visa bulletin, indicated, a significant retrogression in the EB3 category. So priority dates moving back by a year for several regions. And how do you think is this going to affect applicants from countries like India? And what are the implications for those countries who are currently, I mean, for those people who are currently in the process?
Sure. Well, that's the bad news that Rob was referring to a moment ago. Unfortunately, with the retrogression, the bottom line up front is, in our opinion, for India, applicants from India are looking at a 12 to 12 and a half year wait for EB3 visas. So not good news. I think that's kind of what we're seeing pretty much across the board with these employment-based visas. Now there's been a much higher demand for these types of visas. It's kind of a wait and see. But unfortunately, when it comes to India, specifically to India, it's a long wait right now.
It is. And I think for most of the categories for India is bad. I mean, I think EB2 is where they're not even accepted anymore, right?
Yeah,
Right.
there's one particular category, and we're going to talk a little bit later when we get to, you know, further down the list of questions that you all have for us. But the EB1C, which is basically the immigrant visa route, analogous to the L1A, and can be used in conjunction with the L1A. As a multinational executive or manager, and that one is only 3 years retrogressed, essentially more or less 3 years retrogressed. So used in conjunction with an L1A, a proper L1A that's approved, really that is, in my opinion, the quickest route. It may be the quickest route for India overall.
Yeah.
Yeah. In my opinion.
Yeah.
Okay.
I
Thank
echo
you.
that.
Thank you so much. Yeah.
Yeah. It essentially what it comes down to is it's time to start looking at other options. It's time to be creative in the avenues of pursuit for any applicants from India, any applicants from China, anyone that has these extremely long wait times. It's essentially time to get creative and start thinking about other ways that, of course, that they qualify for, and that would allow them to come to the U.S. to participate with an employer. The L1A, it's multinational managers and executives. Like Rob mentioned, that's one way to get someone into the U.S. to do their job, to help facilitate international growth, and seamless operations for whatever company they're with. And
Okay.
the L1A can lead to permanent residency in the U.S.
Right.
through
When you use it, a double play basically.
Right.
L1A and EB1C used in conjunction. So then in that case, you'd be looking at about a 2-year Department of Labor process, and then the 3-year retrogression. So, which is good because on your L1A you'll still have 7-year, a 7-year limit to be in that status. So you could complete it time, but you have to have the relationship with the companies, that are willing to go the distance with you, if you will.
Right, right. Well, that conjunction sounds interesting. We would love to know more about that. But also, just another thought, with Trump hitting the office right now, and it's just been about 2 weeks. Do you think the relations that he's having with these countries, which are changing, by the way, with the United States, are going to affect these categories of visas by any chance?
Go ahead. I have my opinions. I think that to the extent that they are STEM related companies and fields, he's going to have a lot of people putting pressure around him, his inner circle, if you will, in order to draw more, hopefully, from overseas. Quite frankly, I think we just have a lack of talent within the United States. It sounds strange coming from a U.S. citizen, but the more talent that I see, and I think we see in our practice in the STEM type related fields, is all from overseas. We have qualified people here in the United States, but I just don't think we have enough to fulfill the very ambitious goals of this president for the short and long term over his, which will be his last, time in office. He really wants to accomplish a lot, and I think that with his relationships with the companies, he's a businessman. He's going to want to see exponential business growth within the U.S., and the only way to have that is to have good talent. So, if we don't have that talent pool, I don't see how you can get around it. We need folks from overseas, and especially from countries like India that are extremely intelligent, extremely hardworking, capable and qualified for these kind of jobs.
Yeah,
Well, that's a
and
really nice point of view. Yeah, Philip, go ahead, please.
I was just going to add to that, and is that of course, the current president's policymakers, I'm sure, are thinking about what's going on that's making the news. How is that going to affect that talent pool that Rob is referring to? And they have to consider whether or not this is going to scare people away from wanting to come to the U.S. and bring their talent. We need to, policymakers, again, I know they're taking this into account, and I just hope that we start seeing that we need to attract those types of workers. We need to bring them in. We don't necessarily want to, and that we don't want what's going on right now in the immigration landscape for irregular immigration. We don't necessarily want to see that affect our business and employment-based immigration, because, again, I'll reiterate what Rob said, and we can't say it enough. I mean, a lot of this international talent, they want to come to the U.S., and we need that talent.
And they're two different worlds. What, like the mainstream media, and you watch these shows, and we're getting the calls. I mean, quite frankly, we're getting waves and waves, tsunamis, if you will, of inquiries and calls, and people very scared, very concerned, and quite frankly, just freaking out. But it's two different worlds: the business world of immigration and the people that are being spotlighted in the mainstream media. They don't. One has like very little to nothing to do with the other. I don't see even, just like even deportations and stuff. Now, granted, if you were here in one status and it expired and you overstayed, well, guess what? You just switched over to to the mainstream news kind of scare tactics propaganda that's going on right now, the hysteria, if you will, understandable. But that world does not touch the employment-based visa categories at all. And I mean, if you want to get into, there's allegations of xenophobia and that kind of thing. Again, to the extent that's true, if it's true at all, it has more to do with irregular immigration than with qualified professionals coming in for these jobs, for the L1As, the EB3 perms, the EB2 NIWs, the EB1Cs, all these categories that bring a drained brain into the United States. I still think there's going to be a high demand, and hopefully we'll see some change in the high availability with Congress now, because the new Trump has got a lot of sway with Congress. Everybody seems to be wanting to please him. So if his advisors are telling him, hey, we need these workers, then he's going to be working Congress, and having his confidants working in Congress to try to improve the situation.
Absolutely. Well, those were very well put thoughts and perspectives. Thank you so much for sharing them with us. And, it's somewhat similar to what Dung Habe wants to know. So I would like to take this up. First off, hi to Sneha, Dung, and also Ajay for joining us with your comments. We will take them up. But since it's Dung's comment is a little almost similar to what we are speaking right now. Plus, we are almost in the second week of February where the visa bulletin is going to be out for March very soon. So, do you have any thoughts on the visa bulletin progressing faster under Trump? He's asking.
Can I take that one?
It's tough to say. I mean, that's our hope. That's everyone's hope. But really, I don't know what I guess the true question is, what influence does Trump have on helping the visa bulletin progress a little further along? I mean, that's based on how USCIS is processing these applications. That's based on the visa numbers available. Sure, if Trump comes out and allows certain categories to either recapture visas from another time period or somehow miraculously broadens the amount, increases the number of visas available. I don't know, and my opinion is that I don't see much change to the visa bulletin with Trump in office, and that's not because it's Trump in office. To me, what I've seen in my experience, a new president doesn't necessarily have an effect on the visa bulletin timelines.
And I would just add, to the extent they do, if they have any, it's not an immediate deal. So I know everybody really tracks these month to month, and because they have a vested interest, there's not going to be a 1 month significant jump. I don't think. If anything, it will be gradual. And hopefully, what my hope personally is to see substantial improvement by the end of the year. Month to month, it can change a year or two or a couple of years, but I don't see dramatic changes between each visa bulletin publication. I could be wrong.
So true. So true. Well, thank you for that. And thank you, Dung, for joining us. Tell us where you're from and you can keep commenting. And we will take up more questions. But we were speaking about retrogression earlier, even for India. So maybe if you give out a few tips, maybe, or what steps can Indian applicants take to mitigate the effects of this retrogression?
Well, I mean, what we do with our clients is we try to look for alternate routes of status that they can, if they want to be in country, and which is mostly the case, right? They want to stay in country until a visa is available, so they can adjust status from within. That's usually the play that everybody wants to make. So what we do is we look for any, maximize any STEM OPT options that are available. If they have an employer and they're able to get into H1B status, especially for the non-capped categories, the universities and schools and those types of deals, something where they can stay in status for an extended period of time. Those are lovely. And the L1A is another beautiful one because we don't have the prohibition on dual intent. So if they can maximize their 7 years, get in an L1A status and maximize their 7 years, then they have just like, they're getting closer to the finish line, So that's what our strategy is. We look for alternate viable routes for people to be able to maintain status while they are awaiting these lengthier processes, these lengthier categories for visas to become available.
All right. So my next question would go to Philip right now. And Philip, if you could tell us, especially that reports suggest that all available EB3 visas for fiscal year 2024 have been issued, rendering the category unavailable until the new fiscal year, which is this coming October. So how does the impact pending applications, and what should applicants anticipate as we move in fiscal year 2025?
Sure. Well, and that's a good question. I understand that's a major concern for a lot of people. Unfortunately, because the cap has been reached, there's going to be a pause. Those visas won't be processed up until the new visas commence for the next fiscal year, which begins on October 1st.
Okay. Well, thank you for that. And yes, ZQ also has a few questions. We will take them up, ZQ, if you don't mind waiting a bit. But coming back to our questions, also like this is another challenges which EB3 visa availability has given out, because the current challenges with EB3 is the availability. And what alternative immigration pathways might these applicants consider, to achieve their employment and residency goals in the United States?
Yeah, that's a great question, and that's what Rob was referring to a moment ago.
H1B.
With our clients, we take a holistic approach. We consider every option available, and so as far as alternative immigration paths, you could look at something like the EB2 NIW. We've had a lot of success with those applications lately. You can also look at what Rob was referring to earlier, the EB1 visas. That's a much shorter wait. I think by our estimates, we were talking like a 3-year wait for under the EB1 category. So those are two of the alternative paths that someone can consider. When they look at the EB3 perm and look at this very long wait, and they think, well, what else is available? Those are two options that are available.
And I kind of misspoke earlier when I talked about labor certification in the context of the EB1. There's several different types of EB1s, and for I think 3 of the 4, there's no labor cert required. I'd have to go back and review. But that is important because that helps cut off, which is the other big hindrance in the EB3 category, is this whole labor certification process. So anytime you can get to a visa that avoids the labor certification process, you're gaining ground. And any type of alternate non-immigrant status that doesn't prohibit dual intention, those are great options, like the L1A.
Very interesting. Thank you so much. Because I'm sure, folks out there are just looking out for their options. Well, if it's not this, then what is the other way to be in the US, right? And from what news has it, most people, most immigrants, or people who are, on the verge of coming to America, they're kind of scared, as in like whether they should or they should not, at this point at least, to come to America. So what do you suggest?
I mean, go ahead.
Well,
Should they be
as
scared? I
we
mean,
Yeah.
yes, Philip.
We understand the uncertainty and possibly a little bit of fear and anxiety, but generally speaking, for the most part, it's always best to apply as soon as you can.
Yeah.
Regarding of when is the best time is now. Well, the best time was yesterday. The next best time is today.
Is now.
Uh,
Okay.
and that I will say is that can apply to almost 99% of our cases. Certainly, business employment based cases. I don't know if Rob has anything to add to that.
Well, and there's another thing too that we really don't talk. We kind of like silo our conversations, but they really shouldn't be. Like we're talking about employment based today. A lot of what we encounter are young professionals, recently graduated from college, or just in the time of the beginning part of their professional life, right? Well, a lot of them, if they come over and they're single, oftentimes end up getting married. If they end up getting married to a U.S. citizen, that absolutely is the fastest path because that category is always available, and you can do what we call a one-step, which is a petition along with an adjustment of status. You can have your work permit in a matter of a few months. You can get your green card in a matter of a few months to a year. So for this single crowd, if you will, I mean, often as their life develops while they're here in another category, they may end up changing over to a family-based immigration, which if the spouse is an American citizen or U.S. citizen, they're really fast-tracked, quite frankly.
Very nice. So, single folks out there, I think yes. So why not? So learn to fall in love with America and maybe an American too. Cool. So nice. Well, we have Dung who's come back. So I think we should quickly take his one since he's here. Let's follow it up quickly. Do you think EB3 row will hit 2023 PDs by end of fiscal year? Currently at December 22, with a 14 plus day movement in 5 FBs. There's so many short forms in this with fiscal year and PD of 13 January 23. Greetings from UK, he says.
I'll, I didn't
Yeah,
catch it all. I actually didn't catch it all, so I was going to refer it to Rob.
yeah, that got pretty down into the weeds. I didn't.
Same here,
Is he talking?
because there are so many short forms he used, but okay, I could go slow. So, do
Yeah.
you think EB3 row will hit 2023 PDs by end of fiscal year?
From 23.
Will hit 23 because it is currently at December 2022.
I I hope so. Is all I can say. I mean,
Yes, I mean, yes, Visa Bulletin. We all hope for the best. We really hope that there are more movements faster and quicker. And I mean, statuses become current as soon as possible,
yeah,
priority dates. But we will just have to wait up. Yes. And actually, I would appeal to Dung to call us. You can call us up on this number, maybe connect with us. It'll be easier. So the question is
yeah,
more clearer, maybe. So the number is
yeah.
425-436-6335, and the access code when they ask for it is 988888. And yeah, please feel free to join us on call. All right, coming back to our questions, this is regarding L1A. So maybe I could ask Philip to answer this. Are there any recent or upcoming policy changes affecting the L1A visa category that applicants and employers should be aware of this year?
Yes, great question. The most significant change is going to be the revised Form I-129. It's significant because that's going to require or will require stricter documentation requirements. As Rob mentioned, the theme here going forward that we're going to see is more scrutiny, more scrutiny, more scrutiny. And the revised I-129 reflects that. They're asking for much more comprehensive information regarding the employee roles, detailed proof of control over the employee and their work responsibilities, and just an overall stricter criteria for executive and managerial roles. So I would say that to me, in my opinion, is the most significant change thus far, affecting the L1A visa category.
Thank you so much, Philip. And folks out there, whenever you are applying for any category, please make sure that you are using the latest forms, whichever category you are applying for, because there has been updates and, updates keep happening. So even the January 17 changes has occurred. So just keep all that in mind. And best of all, consult an expert, consult an attorney. Why not call Rob or Philip? Their details are scrolling on the screen as well. So control, if you can display them, please, it'll be great, so that folks
Yeah,
out there can note the numbers down.
I'm sorry.
Or
You,
yeah.
we've seen several forms change multiple times within 1 year. So it's
There you go.
I can't emphasize that enough or support your statement enough that like the day that you're shipping that file off overnight, you better make sure that form's good or it's going to get kicked back and it's just going to cost you more time, potentially more money, or a fight with USCIS over a premium processing fee refund. We've seen
Mhm.
those fights.
I mean,
And
has
then
it
on top
happened
of
that you sent something today and it changed maybe just that same day?
they usually give you, like a couple week or usually a couple month buffer.
Okay.
But I forget which one it was, but it was a very short time frame and was almost an immediate change this last year. So it's critical to make sure at least the day you're sending it in, uh, um, that you go to USCIS's website. It's very easy to do. You just get your category and you go to the bottom and they have drop downs and it'll say current edition. And then it'll talk about we accept this edition until this period of time. After that period
Mhm.
of time, we will accept this new edition that was published rather on a date certain.
Hmm. Yeah, we can't stress
Right.
that enough, especially for those applicants who, makes me cringe to think about it. But those applicants that are trying to do this on their own, certain applications that don't require an employer, um, we see it all the time, that people try to do something on their own. They submit the wrong form. They submit a fee, an older fee rather than the updated fee, and then they come to us after the fact. And in some situations, that fee's gone, the form done. We have to redo everything all over again, and it just, as Rob mentioned, it delays the process. It's an
Definitely.
unnecessary expenditure of time and resources. So it's always best to use an immigration attorney.
And
Absolutely.
if you're talking like forms of like an extension of stay or change of status, it can be a deal killer
Hmm.
because if you're filing those at the last minute, but you're using the wrong form and it gets there, by the time you find out you used the wrong form, you may have passed your exit date, uh, and so you're out of luck. You won't be able to extend your time or change your status. So
Yes.
just avoid, especially in time critical pieces like those
Yes.
situations.
Absolutely. So, folks, don't wait up till the last moment. At least have a little buffer time for yourself. Play safe, I would say. And yes, we should take up more questions from our audience as well. So, let's take up ZQ's. All right. How does the recent comments by President Trump about DEI individuals work in core areas of administration and in transportation, like the FAA, affect the professional scenario? Will it hamper workplaces like air travel, hospitals, medicals, etc., where people's lives are at stake? And are they in the correct mindset? Are they worthy to be hired? JD Vance called it a joke, says. Any
I mean,
comments?
I think it's more benefit. I have a very personal opinion that there's an extremely qualified. So what we're really talking about is moving from social promotion to merit based decision making in these jobs. If we do that, I see nothing but benefit for the Indian population because as far as merit based goes, the level of education, the level of professional accomplishment and capability are going to put people in that category, the merit-based approach to filling these jobs, in a much better well position than if we're looking at we need X of this type of person, Y of this type of person, Z of this type of person. I think that works to the detriment of people's of a people group like from India or even China or wherever that have extremely qualified people and will come in stronger on a merit-based. I think they have a better shot at it outside of the DEI context. That's personal opinions.
Well, and then let's not forget the current employment-based process. It is currently merit-based. It's so I don't necessarily know. I appreciate the question and I appreciate the viewpoint, but I don't necessarily see how the two, the DEI conversation affects what's currently in place or with regard to employment-based visas, right? It is we're trying to draw top talent, and for the EB3 perm, we're dealing with labor shortages, right? So we need people that can do those jobs. I don't necessarily think that the DEI conversation, as controversial as it may be, has a direct influence on employment-based visas.
Right.
Yeah, I almost
And you very sorry, yes.
Oh, yeah.
Sorry. I'm sorry.
No, Rob, please go ahead, please. I'm sorry.
More as a domestic conversation of people that are already here, within the U.S., filling specific people categories, and I even hate to even say that, into a certain percentage of each job. I don't see that as applying in the international immigration and visa, especially in employment context, like Philip just said. I mean, it's just kind of, it's not a fit.
Right. But with that said, it's still merit based, and I think this is a little positive thing that it is creating, the spirit of competition, you can say, to be best at what they do, so that they could go to America and live their dream, right? So, and I mean, so also for the Americans out there who would want to prove that they are better. So this, I think, the spirit of competitiveness is a little healthy, so to say. All right. So great point of views, and thank you, ZQ, for your question. Please keep commenting. It's very interesting. All right. So let's go on to our next question. What are the current best practices for L1A visa holders? Who are aiming to transition to permanent residency, considering the prevailing immigration landscape. Maybe Rob can take this.
Yeah, I mean, like I said, we've said a couple times now, I think the best play is if you already are in the L1A category, the best move is the EB1C. It's almost, entirely congruous with the L1A. It's an easy slide right in there. And you have the premium processing available, and you have a 3-year wait versus these 12 and 13-year waits on visa availability under the visa bulletin. So, you stay in your L1A status for 3 years while you're waiting for the EB1C process to complete, and then you are good to go. Then you get your I-485 filed once your priority date is current, and you're in your period of authorized stay, and we are we're golden, as they say.
All right. So my next question is for you, Philip. If you can tell us, in January, of course, 2025, this year, President Trump issued several executive orders affecting immigration, including enhanced vetting procedures and changes to birthright citizenship, which is, still yet to be confirmed, by the way. So how might these orders influence the EB3 perm process and the L1A visa applications?
The theme of the day: higher scrutiny, more scrutiny, and I think more extensive documentation requirements. Just to put a nice bow on it. That's what we can expect to see, and we don't know what's coming either. We don't know what other tightening there may be on employment-based visas. We don't know if there's going to be loosening on employment-based visas. But as far as the executive orders taken in isolation, their effect on EB3 and PERM, I would say more scrutiny.
And if I can just add in, because I used to work for the Great Oz and I've seen behind the curtain, I think what you're going to see is a lot more administrative processing for specific countries, right? So what they're worried about basically is somebody maybe coming under a ruse of a employment-based visa for intelligence gathering purposes. So if you have some of our major, we have diplomatic ties, but I wouldn't exactly call us the best of friends with China, for example. You're going to probably see a lot longer vetting periods, which just means in the front facing to the layperson, the administrative processing cycle. And what they're doing is they're running extensive databases through all the agencies you can imagine, and all law enforcement, and through Interpol, and any background information that they have, even on open source, to determine whether this person is indeed a security risk. And I think you're going to see those admin processing times much longer, let's say, for maybe potentially a Chinese applicant than you would for India. Definitely for Iran. A lot of Middle Eastern people we see get caught up in a very lengthy administrative processing process. Was it the 213G?
Mm-hmm. I think that, yeah.
Yeah. So, as far as the heightened scrutiny or security by Trump as declared as part of his policy, that's going to translate into perhaps lengthier admin processing, which was really what they're doing is vetting any applicants or petitioners.
Right, Rob. Very well put. And, I think I will say to do your research properly and see what you need to do, make sure your documents are right, and you will have to be patient for sure, not giving up, even though how intense this vetting process might get. So I would say all the best to all you folks out there. And Rob and Philip, we have a few more questions, but we will address them. We also have some questions in our Facebook group. So, Control has put it up.
Okay.
And if you don't mind, just let's address them quickly. Let's take this first one. Philip, if you can go with this. How long does it take for a green card in EB3 skilled?
Well, what we've seen in the past, I mean, of course, that depends on a variety of factors. But what we've seen in the past, I think we've seen probably about 2 years?
2.5 right now, 2 to 2.5 years. But remember, the first year of that is the Department of labor certification process. Once you get past that and you have your labor cert, you can file the petition and you can utilize premium processing to get an answer very quickly. Then, then you can adjust status or file your I-45 to adjust status. And you're probably looking at, we'd have to pull up their processing times, but you're probably looking at another year or two, maybe a little more over a year and a half at most, to receive the green card once you get to that point. The thing about their processing times, their published processing times, some are pretty scary, and they're scarier. But we haven't seen a correlation to reality in a lot of the categories that we file. In fact, we've seen a great discrepancy and what they're publishing being, for instance, 50 months on one specific category, but yet we're getting the green cards in less than a year. So I'm not quite sure where the disconnect is at USCIS, or if they're just trying to CYA, by publishing these lengthy times. But I would say once for the entire EB3 perm process, again, this is not accounting for retrogression. It's about a 2 to 2.5 year process.
Okay. Thank you for taking that up. Control, if you can display the next question, please. So, how long it will take for EB3 skilled PD March 2024?
Priority date 2024. 12 years. 12 years to adjust status.
Whoa. That
Yeah.
is insane.
Yeah, and 11.
I think you will just have
11
to look
years.
out for another option if you want to get into America quickly.
Yeah, it's a long time. Very long
Dozen
time.
years. And that's just for the first process. It could be longer, right, Rob?
Yeah, the problem is then, so you got to tack on some time if you're going to consular process. NVC probably take a month to 2 months, you think, Philip, to get documentarily qualified. Then it's up to post, and this can be crazy because depending on the post's performance, quite frankly, in relation to the workload, the demand they have their own little retrogression. For instance, when I arrived at one post, there were 5,000 visas in the hole to NVC as far as scheduling appointments. So we strategized, we got that corrected, and actually we got up 2,500. So we had 2,500 visa interview, more capacity than NVC could supply for us. That's very unusual. Usually, Post is way behind on being able to schedule an interview if you're going to go that route. And you could be looking at, we have one particular case, they've been documentarily qualified waiting for an interview for a year and 4 months now, or a year and 5 months. It's awful. So if there's ever a way to adjust status, it's really the preferred route from within the U.S. Over consular processing, but it's just not always available to everybody in every circumstance.
Well, thank you for taking that up. It's crazy, though. Let's go to the next question. This is from an anonymous participant. I have already done the EB3 probably visa. So if I process the F1 visa now, my EB3 visa will be held. In the futures, in the future, issues may or may not occur. Okay. He's asking maybe if there will be any issues in the future.
Problem with that.
Well, yeah, we don't. As far as particular specified information, we obviously cannot give specific response or specific advice. As you know, there's no attorney-client relationship created here. But I think Rob just brought up a good point, and that might possibly be an intent issue.
Mm-hmm. There might be under circumstances where you have a pending immigrant visa petition. If you're seeking any other non-immigrant visa category that prohibits dual intention, they're not going to issue you that non-immigrant visa because they already see you have immigrant intent. So your knees will be knocked out from underneath you right away. So that's really not a strategy that we use for our clients because we know how it's going to end up at the end of the day.
Right, right. So, folks, I would suggest you write to Rob or Philip. You can do so by emailing them because every case is different and they would need proper details to really get to be able to help you, so why not email Rob, and you can email Rob at robmelvin@melvinlawgroup.com. It's there on the screen. You can note down the email address. And for Philip, if you want to email Philip, you can email him at philip@dosrodlaw.com. And you can also call on this number, 979 and definitely go visit www.dosrodlaw.com to get to know more about Philip, for sure. And yes, let's come back and take up another question. This is another anonymous participant. If a visitor visa is refused, can one apply for an EB3 visa? How would there be any difficulty? Also, if a child is 19 years old at the time of application and the EB3 process takes 3 to 4 years to complete, would the child also receive a visa since they were under 21 at the time of application? Please provide guidance.
There's a lot of moving parts to that question. Um, what we can tell you, and Rob has firsthand experience of this, being a vice consul, is whenever there is a visa denial, uh, everything after that is reviewed with a little closer eye, and depending on the basis for the denial or the refusal, it could have an effect on a future employment-based visa. I don't. You want to add anything to that, or?
No, other than like the denial of a B1, B2 is in very informal terms a nothing burger, because they're so easy to deny. Uh, you actually begin in the B1, B2 category with the presumption that you will be denied. You then have to overcome that presumption with the vice consul to show them that you have sufficient ties to your home country, that they are reassured sufficiently that you will return to your home country at the end of your allowed stay in the United States. So the fact that you were denied, and I'm not giving you legal advice specifically on this case, but the fact that somebody was denied a B1, B2 in their past, really in the immigrant visa context, will have little to no implications unless there were some misrepresentations, anything that could give you what we call a hard hit. And what those are ineligibilities that are entered into your record. And ineligibilities or inadmissibilities in the context of the application for the non-immigrant visa and that whole process.
Yes. And once again, I would say play safe, everyone. Avoid any sort of misrepresentation. Whenever you have the chance to give them the info which you couldn't provide earlier, you might as well do it when you get a chance. All right. So I think with that, we should wrap up the questions from our audience. But this question goes out to both of you, Rob and Philip. If you have any interesting case that has come up that you are dealing with right now, with reference to EB3 or L1A, especially after Trump has joined office, and you would like to share, you know, any note, it'll be really interesting to get to know.
Yeah, I mean, the most interesting note is not even a case from India. It's from another case that's not retrogress.
Okay.
And it's been going for working on 2 years now. Actually, and we're still don't even have the labor certification yet. So it was shocking to me personally to see in that case, you got the prevailing wage determination, took much longer than I thought, okay, and much longer than they were publishing at the time. It took 9 months. So that was good compared to today. And then we did the reasonable recruitment process. So that was another 6 weeks to 2 months. So now it's in the labor certification phase, and I check it, a couple times a month, and it's still just pending. So it makes you crazy because it's like this whole other hurdle you got to get to before you ever get to the starting line. The Department of Labor is really a challenge in this particular visa category. Anytime you need a labor certification, uh, not talking about the LCAs for for H2Bs or anything like that, but a labor cert for the EB2 or EB3 perm. Department of Labor is just a mess right now, in my opinion. I'm sure they love hearing that from me, but
Well,
I challenge somebody to explain to me how they're not a mess.
yes, I really hope this just gets untangled as soon as possible. And Philip, any last notes, maybe, to folks out there who are watching us right now? Anything you want to say?
Well, sure. I just want to reiterate that I know it sounds like there's a lot of doom and gloom, but if your goal is to come to the U.S. and whether it's the professional route or any other route, speak with a knowledgeable immigration attorney who can do a holistic analysis of your situation, can look for any type of visas you may be eligible for or any type of immigration relief that you may be eligible for. Just go to a trusted immigration attorney that can figure your situation out and give you at least three. What we like to do is give 2 to 3 viable immigration options, and then ultimately it's on the applicant, it's on the viewers for them to make their decision. But again, I know there's bad news in the EB3 perm category for Indian applicants from India, but it's not all doom and gloom. Okay.
Okay. At least that's a good, positive point to end today. So I would say thank you to both of you, Rob and Philip, for joining us. It was such an insightful session, really, and we learned so much about the current situation, what's going on. But always great, to consult with an expert, an immigration attorney, and they should definitely be Rob and Melvin. So go check them out, and their contact details are as follows. So this is for Philip. This is you can call him up on his number 979-776-1325, and you can email Philip, philip at dosrodlaw.com, and go visit www.dosrodlaw.com to get to know more about Philip. And you can also call and contact Rob, and you can email Rob at robmelvin@melvinlawgroup.com. And you can even call Rob in his number control, if you can please display. Rob's number is 512-293-3023. And once again, his email address is robmelvin@melvinlawgroup.com. And go visit www.melvinlawgroup.com to get to know more about Rob Melvin. So both of you, thank you so much for joining us once again, and I'm really looking forward for more great sessions with you.
Sure. Well, thank you very much. Quick note on those contact numbers for both Rob and I. They are available on WhatsApp for a lot of our international clients that use that communication channel. So again, thanks for having us. We're happy to answer any questions that your viewers may have, and you've put up our contact information. They can all feel free to send us an email, give us a call, or shoot us a text on WhatsApp.
And it's Philip with one L, not two. PHIL.
Yeah.
Nice.
Yeah. No, thank you, Pasa, for having us. It's always a pleasure. I know it's not, the news people want, but we shoot straight and we're transparent. So
Yes.
we're just going to tell you the how it really is on the ground, and we're going to tell you what the best alternate options are for everybody. So we're always willing to share the information that we have, that we're privy to.
Thank you, Rob. And really, thank you for joining us, both of you, today. So, folks out there, Rob and Philip, for you, do go and contact them and maybe have a one on one discussion. You can even let them know that you saw them here on Immigration Talk Show. They would be really happy to help you. And have a great day, both of you. And also to all you folks out there, thank you so much for joining us. You can also contact me. In fact, my number is 408 and my email address is nipa@staffingly.com. You can even WhatsApp me in this number. And if you have any questions for Rob and Philip, I could even direct those messages to them directly. So thank you once again, everyone, for joining us. Have a great day ahead and a splendid week ahead. Bye bye.
Take care. Thank you for.
Thank you.
Bye bye.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, after this very important disclaimer, I would also like to say that we are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So make sure to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And do follow us also on these many platforms and participate in our webinars. That would be lovely. And the best part is you can also, ask questions and queries whatsoever you are having right now, especially this very tough time. So ask as many questions as possible. Participate in our webinars so that you can get your questions. Ready. Your answers can be ready. So with that, friends, I would also like to say that today our topic is again very timely and very important, and that is about L1 visas and Dropbox changes in India. So recently, we got to know that on February 10th, 2025, there are recent changes in Dropbox process. What it is, how is it going to impact, especially the L1 visa applicants, and how the future will be, what challenges will be there, and also how can you overcome from those hurdles. We are going to explore in this webinar. And to help me out, to make this session a wonderful one, very insightful one, I have my very special guest, none other than attorney Uma Mantrawadi, who is one of the finest immigration attorney and also expert in US immigration policies. So thank you so much, Uma, for this time. I'm really happy that you're here again. So really looking forward to this session.
Good afternoon, Sam. It's a pleasure always to be back. And there's so much to talk about.
Absolutely. And we are really ready with our notepads, that what else Uma is going to share with us so that not even a single information could be missed out. But with that, friends, the best part is you can also reach out to our attorney, to our immigration attorney, Uma Mantrawadi, on the given number. That is 713-787-5297. You can also email her on uma@mantralaw.com and visit our website, that is www.mantralaw.com. So I'm sure that our friends would go ahead and reach out to our attorney. So Uma, before diving into our question, is there anything else that you would like us to know about any recent changes, any recent update that's happening in immigration?
Sam, I think with the Trump administration, there's never going to be a dull moment. There's always going to be something that crops up behind our backs. I go to sleep and then worry about what's coming tomorrow morning. And there's
That's right.
always something coming up. So there are a couple of things I just want to touch base. We'll talk more in detail when it becomes necessary. One is on 25th of February, the Trump administration and the USCIS has announced the upcoming launch of a new alien registration process. They are going to set up an online registration process. This
Mhm.
has not yet happened. Having said that, the Immigration and Nationality Act has always required registration of most aliens who remain in the United States for 30 days or more. And this requirement has always been not always been enforced. We saw a registration period after 9/11 when President Bush was there, and he required people from certain countries only to come forward with the registration. If they are here legally or here illegally, they had to come and do a registration. And I don't know if many people remember, they were given like an FBI number, so
Yeah.
all their cases were registered with the FBI. This was after 9/11 because of 9/11. And so similarly, President Trump is wanting people to register so that they know exactly who is where, and especially children who've turned 14 and above. They
Mm.
want them to be registered because a lot of children were brought into the country when they were 6 months old, or 2 years old, or 5 years old, and now
Yeah.
they are 14 plus. So, you cannot get fingerprints of children under 14 even now,
Mhm.
whether you're applying for a green card, citizenship, H1L1, I mean H4L2, whatever. But once they're 14, they'll have to upgrade that with their fingerprints.
Yeah.
So now they are asking even the parents of children who are 14 or 14 and above to go ahead and register, even if they are here illegally. But we as attorneys feel this is like a little trap for people, because once they provide their information, their address, their phone number, their email, we are pretty certain that ICE is going to go and pick them up. So this is not great news, but this is news that just came about. And they're also saying for those who do not uh, register, they're going
Mhm.
to um, fine them with a $5,000, and possibly also consider this like a criminal misdemeanor and could jail them for 6 months or more.
Oh God. Okay.
So this is getting serious. Like we
Mhm.
talked, uh, the loop around the neck is coming from all sides. People are getting, narrowed in, pushed in every possible way. When
Mhm.
President Trump talked initially about deporting, mass deportations, he
Yeah.
talked mainly that he's going after illegal criminals. But this
Mhm.
doesn't seem, they're going after criminals. Because if you're talking about 14-year-olds, you know, I don't know where this is going.
Absolutely. There's a lot to
So,
process just in the beginning of the session. All right. Yeah.
yeah.
Please go ahead.
And there's also something I would call it maybe funny for me, not funny for many. But President Trump has also announced that he's going to give it's called as a gold card program, where people have to invest
Yeah.
$5 million. And if they invest $5 million, they can get citizenship. And his idea is to repeal, meaning take out the current EB5, which is at 800,000 or 1,050,000, take that out completely and bring in this gold card with $5 million investment to get a
Mhm.
citizenship. Meaning,
All right.
I'm sure they have to go through the green card and then to the citizenship. I don't know if they're going to offer citizenship straight, but this is something that was announced. As attorneys, we don't think that President Trump can, uh, bring in this rule by an executive order. It
Mhm.
has to come through Congress. Congress has to repeal the EB5 Act and then bring in the new rule. So that's going to take time, and I don't know if Congress would really implement this because it's a huge, huge amount.
Yeah,
And I don't even know if 1% of the people in the world can afford to invest $5 million and get a gold. Now he's talking gold card. And like I said, to me, sometimes this seems funny. I don't know if he'll bring a platinum card.
that's right.
Uh, So we got to wait and see. I just wanted to bring this information as first and foremost. And I think we should talk about the alien registration process more in detail in the next coming weeks. Once the USCIS will give us more information as to who registers where, because there is some confusion about who has to and who doesn't.
Yeah,
So we'll talk about that, once we get more information. But this is not great news for any of us.
absolutely. I think for sure, Uma, this is a great topic to cover in the next webinar, and our viewers are, I would say, friends, go ahead and collect more questions on the upcoming topic as you got to know what our topic will be for the next session. So, with that, I would also like to come back to our today's topic, Uma, that today we are
Yes,
going to talk about L1 visa and Dropbox changes in India. So
yes.
this is a very sudden change and a very recent update that is our viewers are getting to know. But we would also like to know more in the detail. So with that, I would like to know my first question: that what specific updates have been made to the Dropbox process for L1 visa applicants in India as of February 2025?
Well, the changes in the Dropbox requirements is both for L1s, H1s, F1s, L2s, H4s. So it's for all the categories, Sam. It's not just for the L1 applicants alone. So earlier, the previous government said if you had the same category, you held a similar category for 48 months, you could use the Dropbox. You didn't have to go through an interview. Um, you could use the Dropbox process, but now they're saying no, we are bringing down the 48 months to 12 months. And if you've been in the similar category for at least the preceding 12 months, then you're eligible for the Dropbox, failing which all of the applicants will have to go for an interview, whether it's an L1A, L1B, H1, H4, L2, any of these categories, including F1s and F2s.
All right. Okay. And there's another question, Uma, that, before diving into other questions, I would also like to know the difference between renewing an L1 visa through the Dropbox process versus attending a regular in person interview.
As I just mentioned, if the person was in an L1 category in the preceding 12 months, then they don't have to go through the interview. That's what is a Dropbox. Basically, they're saying, drop off all your documents at the Dropbox that they have provided. Once they receive it, if they feel that you qualify for the Dropbox, obviously you're not going to have an interview. But even for those who have qualified for the Dropbox, sometimes if the consular officer feels that this individual still needs to come for an interview, they can still tell them, you know what, we've got your documents and we still need you to come for an interview. If they feel there's some kind of a fraud or they're missing documents or there's some clarity that is lacking in the documents that they feel that this individual has to come and clarify. So your Dropbox can always even convert into an interview. it's not a guarantee.
All right. Okay. So how does it going to affect the L1 visa applicant?
In what sense?
Like if this Dropbox is happening, then how those L1 visa applicants are going to be affected?
They're not going to be affected, but if they were not in an L1 visa in the last 12 months, as per the current rule,
Mm-hmm.
they have to go through the interview. Earlier, it was the eligibility was 48 months. They
Yeah.
brought it down to 12 months. So if you didn't have an L1 in the last 12 months, you don't qualify for a Dropbox. You will go through an interview.
All right. So, what do you think, Uma? Like, why the window has been, shut down? I mean, not shut down, but why reduced from 48 months to 12 months? What can be the reason behind it?
I think they're tightening up the vetting process more crucially because 48 months is almost 4 years.
Yeah.
So they want to know if this individual really qualifies for this. They don't want people to just fall through the cracks.
Mm-hmm.
So the vetting, as they have clearly mentioned, Trump administration, that we are definitely going to be more tightening the
Mm-hmm.
vetting process, whether it's an L1, whether it's an H1, whether it's an EB5, whether it's an immigrant visa, whether it's a fiance, whether it's a K3, it doesn't matter. I think the vetting process, we talked about this last week as well, that the vetting process is going to be tightened much more than what it was before. In
That's
my opinion, this is what they are. They brought down the 48-month rule to a 12-month to make sure that they have access to these individuals, get more information, making sure there's no fraudulent or frivolous applications being filed. Everything is credible, everything is correct, and these individuals are not just coming here to sit down. They're not being benched. They actually have a job as an L1A or as an L1B. What are they doing? Do they even know where they are going, what they are doing?
that's right. And I think, Uma, if we go through different articles also, then we have seen that Indians are not very much happy with this recent change. They are not liking this. They are saying that it's quite unfair for them because there are applicants, who got their visa expired on January 2020. And they were waiting because they were thinking that they have still 4 years to renew their visa. But
Correct,
suddenly they got to know that, this all won't happen. So, Uma,
correct.
my question
Even
would.
those applicants, I'm sorry to cut you off, Sam, but even those applicants who already had scheduled their Dropbox appointments were
Mhm.
told via email that their Dropbox is being canceled and they now have to schedule an appointment and come through the appointment process. I know this is very, very disheartening and disappointing,
Yeah,
especially if people from India who wait months and months and months even to get appointments, even for the Dropbox.
yeah,
It's not that the Dropbox is readily available for people. So it takes months and months for them to plan this, to get this. And now they get an email saying, sorry, you're not eligible for the Dropbox because we've taken out the 48-month and you fall into the 12-month. So you don't qualify. So go back, refile your DS 160 or whatever, and then get an appointment and come in the line. So, yes, it is extremely disappointing, no doubt about it.
that's right. And that too, I think it happened in a very sudden way, right? No prior information
Correct.
or
Absolutely.
notification took place.
Absolutely. What I would suggest to people is, if you're working for multinational companies and you're big companies, be it like Infosys, Wipro, TCS, these are all big companies.
Mm-hmm.
And I would suggest that each of these applicants who are coming to the US because of their employer bringing them, And if they're facing all these problems, their owners of the companies, the CEOs, the CFOs, should really write a letter to President Trump or to Elon Musk expressing their dissatisfaction because it's
Yeah.
affecting a lot of their employees. It's causing a lot of problems for them to come to the US in a timely manner. They may be losing millions of dollars because of the delays for these applicants to come. So, if they can express that to them in the form of a letter, and also, I would say they should also write to Prime Minister Modi ji, and express their
Yeah.
discontentment. I think the heads of the state should be discussing this if they get enough number of people complaining about the process and the sudden change in the process without giving them any notice. At least give them a 6-month notice, so those who already had their appointments would have at least gone through their Dropbox appointments. I think that was unfair. Yeah.
Yeah, I think it's not only some people are thinking. Most of the people, especially the applicants, they are really not liking this change. And I think, Uma, it's not only applicable, for those who are about to file the visa application, but also the ones, those who have already filed. For them also, it is being affecting in a very harsh way. So I think that's why they are also very.
Absolutely. That's what I was saying. The people who already filed, who
Yeah.
already were here on an L1 are, coming back on an L1 after a renewal or a break or whatever.
Hmm.
Even they are mainly the ones affected.
Yeah.
The brand new applicants are the brand new applicants. So they
Hmm.
don't qualify for the Dropbox.
That's right.
So it is the previously, you know, the people who held an L1, L1A, L1B, H1, H4, those are the ones who are affected.
That's right. And what about those applicants who were waiting for 4 years and maybe on January 2020 they got their visa expired, but now they're about to renew, but they are not able to. So, do they have to go
Right.
with the same process again?
Yes. Yes. They would, because that's some of my clients who
Mm-hmm.
got an email saying that, sorry, because of the new rule, you don't qualify. You didn't have this in the last 12 months. You had it in the last 48-month rule, but you don't qualify for the 12-month rule. So
That,
because they had a gap, they had to go back and wait. They were doing some work with the parent company and they were supposed to come back, but because of this rule, now they got, you know, kicked out
mhm.
from the line of the Dropbox.
Oh God, that's so sad and that's so, I would say, heartbreaking because, going through again with the same process, it really takes
Uh,
years and years to get that approval.
and it's a very, what to say, very stressful situation also because they don't know now under the new administration what the officers are really looking for.
Hmm.
That's a million-dollar question.
That's right. Okay. With that, Uma, I would proceed with my next question. And
Yeah.
okay, let's now understand about the challenges that our applicants may face. So, what potential difficulties might applicants face due to the recent changes in the Dropbox process? And also, if you could explain us how they can prepare themselves.
Well, whether it's Dropbox or whether it's an interview, Sam, I always tell people to go prepared. Make sure, check with your employer and take all the documents, the hard copies.
Hmm.
You're not allowed to show a phone at the window, of course.
Yeah.
So, take everything with you that is applicable. Talk to the company attorney, find out what all you need to carry. I would carry more than less, especially your transcripts, your degrees, your certifications, your experience letters, anything and everything you can carry. And if you've previously been on an L1 in the last 12 months, I would carry your pay stubs, your W-2s to show that you were maintaining your L1 status.
All right. And Uma, what difficulties might applicants face due to this change?
The difficulty is if you're not qualified for the 12-month rule, you don't qualify for the drop box. That's as simple as that. Since the 48-month has dropped to the 12-month. But you're still eligible to apply for the interview process. And so what I am telling people is people who are in the US, if you don't have to travel, please don't. Avoid traveling, especially if you don't have a visa stamp that will allow you to come back. Because you'll have to go through these headaches.
Absolutely. All right. With that, Uma, let's go ahead with our next question. That can an individual renewing an L1 visa utilize the Dropbox facility if their prior visa was in a different category?
Sorry, can an individual renewing an L1 visa, if they're, good question. I'm not sure. They can still say, yes, I'm eligible for the Dropbox because I had an H1, in the last 12 months. It was not exactly an L1, but if they say you didn't have it in the last 12 months in the similar category, then that person may not be eligible.
All right. It should be similar one, right?
It has to be, in my opinion.
All right. Okay. Okay. And also, what prompted the reduction of the Dropbox eligibility period from 48 months to 12 months?
I think we talked about it, and I said, I think this is more because they want to do a lot more vetting. They want to make sure one is the vetting process to ensure they're not bringing in any criminals into the country. Two, to ensure they have credible employees who are coming into the United States, whether it is L1, H1, whatever visa category.
That's right. Of course. Okay, so are L1 visa holders required to apply for renewal within India, or do they have to choose a different country for the process?
Sometimes a third country allows them to get L1, say in Mexico or Canada, but again, they'll have to check the rules of that country to make sure third country nationals are allowed to go there to get an L1 or an H1. I know right now Mexico is allowing H1s, but I'll have to check whether they're allowing L1s.
Okay, all right. I think with L1, it's a little different way, but let's go ahead and explore more topics about it. That is, here's another question, Uma, that if an applicant experienced a visa refusal after their last visa issuance, so are they still eligible to use the Dropbox facility?
No, if they've been denied, they'll have to go through the interview process.
Okay.
Now, it depends why they were denied. Was it a 221G? Was it a 214B? What were they issued? A letter would have been issued to them. So we'll have to see what happened. But definitely, if they were denied, they don't qualify for the Dropbox because they never held that visa.
Yeah. Okay. And also, Uma, I can see a lot of viewers have joined us. I can see Kunal is here. Then Winky is also here. Pratap is here. Monali. So thank you so much, friends, for joining us. It's really great to have you all here. And it's so good when we see a lots of comments here on our webinar. So don't
And
go.
I'll take just 10
Yeah.
seconds and be right back. You can continue talking.
All right. All right. Sure. So I think, friends, it's time to take a short break. So don't go anywhere. We'll be right back because I can see a lots of comments here, and we are definitely going to take them up just in the second part of our webinar. So keep watching Immigration Talk Show as today we are having a very insightful and very eye-opening, I would say, session with none other than Attorney Uma Mantrawadi on the topic L1 visa and Dropbox changes in India. So participate with us in this webinar and do like, share, and subscribe to Immigration Talk Show. Don't go anywhere. We'll be right back. Keep watching Immigration Talk Show. Hello, everyone, and welcome back to Immigration Talk Show. Today, we are having a great discussion with Attorney Uma Mantravadi on the topic L1 visa and Dropbox changes in India. So, till now, we have gone a lot of different information about the topic. We got to know about the latest updates and also the challenges and also how you can prepare. So, till now, we have covered a lot of questions from my end, and I'm sure our viewers are filled up with lots of questions. So, Uma, let's go ahead and it's time to take up our viewers' comment. So, I think I should take firstly Winky's comment. So, he's asking, going to apply for L1B, What's the timeline I should keep in mind to get the visa approved with premium processing and move to US?
I wouldn't know the answer to that exactly, Venki, because it all depends, you know, on the documentation your employer is providing. What if you get an RFE or don't get an RFE? It all depends on that. So I cannot give you a timeline. That's something you'll have to talk to your employer's attorney to find out. What is the timeline you should keep in mind based on their filing the application. So since they haven't filed it yet, we cannot even say, when are they going to file? We don't know that. So I would talk to the employer's attorney to find out. And I wish you the best.
All right. Thank you, Winky, for your question. And please go ahead and talk to your attorney so that he can definitely help you with it. Or you can also reach out to our attorney, our immigration attorney, Uma Mantravadi, on the given contact details. That is, you can see on the ticker that this side. With this, I would also like to take up Kunal's question. Kunal is asking, I'm applying for an L1A visa for the first time. I have an approved petition, and my company has been sending executives to the US regularly. So, will I be eligible for Dropbox, or do first time L1 applicants still require an in person interview?
You will require an in-person interview. You don't qualify for the Dropbox since you did not hold an L1 visa in the last 12 months.
All right.
And I also wanted to clarify your question earlier, Sam, where you asked, if somebody is on an H1B and now they're applying for a different
Yeah.
classification, such
Yeah.
as an F1 or an L1, will they qualify for the interview waiver? The answer is no. Even the Dropbox is with the 12-month reduction. They've clarified this as well. You will not. So if you had an L1 in the
Mhm.
last 12 months, then you qualify for the waiver. If you've not, you don't.
All right. Thanks
You
for
can't
answering this question.
crisscross the visa categories. Yes.
That's right. Okay, all right. Thank you, Ma, for mentioning that part as I was about to miss out that one. But that's great. And let me take up Pratap's question here. Pratap is asking that I went to USA with H1B visa on September 24th and returned to India on November 24th due to project went on hold. My employer did not process single payroll due to this. Now I'm planning to go to US with same employer, so we'll ask pay stubs at US immigration.
Will the US consulate ask for pay stubs? Yes, absolutely.
Mhm.
If you were here on an H1, and H1 is an employment based non-immigrant visa, and if you came here, whether it's for 1 month, whether it's for 2 months, whether it's for 2 weeks, whatever time you were here, they expect you to work and get paid. Now if your employer failed to do that, your employer is in violation, and whatever violations happen is going to affect you. Even with the Dropbox, you still have to prove that you worked. They'll ask you for pay stubs and W-2.
All right.
You're
So
going to have a problem. You need to consult an attorney before you do anything.
that's right. Okay. Then Monali is here and asking that I have had my L1A visa for 5 years and need to renew it. I heard about the Dropbox changes in India. Am I eligible to use the Dropbox, or will I need an in person interview?
If you've had the L1A in the last 12 months, Monali, you're entitled to the waiver. If you didn't have it in the last 12 months, you'll have to go for an interview.
That's right.
I would go and check the consulate requirements one more time. Go to the particular US consulate, whether it's Chennai, whether it's Kolkata, New Delhi, Hyderabad. Please check their website.
Yeah.
Even they have changes constantly.
Hmm.
Even they are going to put up their requirements, Sam. these are what I'm giving information what the USCIS is giving. But again, consulates are governed by the State Department. So they'll have their own requirements as well. So I would actually go and check it out.
Yeah, I think that's how it should be, and that's how you can make yourself prepared. So thank you so
Yes.
much, Uma, for taking these questions, and let's move ahead with one more comment I can see. Rajkumar is here, and he's asking that I'm on L1B visa, will expire on September 2025. So am I eligible for Dropbox L1B to H1B, same company?
No, you're not. You'll have to go for an H1B interview because you were not holding the same visa category in the last 12 months.
Yeah,
So
that's what
you'll
we.
definitely uh, have to go for an interview.
Okay. So I hope Rajkumar, you got your answer. And in case, not only Rajkumar, but anyone who is watching us right now,
Yeah, anyone in the similar situation.
there are many. I think most of the people are having similar questions. So, of course, they are having a lot of concern regarding these changes. But don't worry, friends. Keep on asking questions, and we are here for half an hour more. So, utilize
And
this
I
time.
also wanted to, sorry to interrupt you
No,
again, Sam,
please
my
go.
apologies. Also wanted to give a good news to people that I have an office in Hyderabad now.
Oh,
So if
wow.
anybody wants to reach out to me, I will share that in the next uh, podcast that we do. People want my information to reach out to me through my Hyderabad office. You're more than welcome to reach out to me. And
Wow.
we are there because of all these changes that are coming about, because of all these issues. We expect a lot of people to get a lot of 221Gs also, Sam, in the next coming months after the registration is done and the H1s are processed and people go for their H1B stampings. We are expecting a lot of 221Gs under this administration because we had seen similar history back in 2016 to 2019. So
Mhm.
we're expecting all of that to repeat,
That's right.
and if not more, you know.
Mhm.
Because we are seeing so much of changes. The focus right now is all about immigration and immigration and immigration, whether it's H's, L's, F's, doesn't matter.
That's right. I think that's a great news, Uma, that you also have your office in Hyderabad. I'm sure our viewers were waiting for that only because, it's much better to connect personally as compared to reaching out through phone or email. So that's great. And congratulations, Uma, for that. I would say big achievement, not only for
Thank
you,
you.
but for our immigrant friends as well, because they are also getting, I would say, a personal expert advice. So it's a great one for everyone. All
Yeah,
right.
it's very
Mhm.
frustrating
Yeah.
time right now, Sam. It's as you can see, and I'm sure you get a lot of emails, you get a lot of messages with people who are in India, in any other country for that matter. You know,
Mhm.
they don't know the laws completely. They're lost. They're going by blogs or vlogs or TikToks or, and these don't give all the information that you need for
Mhm.
your own individual case.
Yeah.
And every day I get clients talking to me about things like that. For example, I had a client who came to me yesterday and he did his master's in mechanical engineering from Italy. And his girlfriend was also doing a master's there. She completed her master's.
Mhm.
And this guy, along with a bunch of friends who were going to school in Italy, applied for a program here in the United States to come here and do a master's.
Mhm.
So he and some of his friends applied for the F1 visa, and some of them got it. but his girlfriend was repeatedly denied F1 3 times. And
Oh.
he was perplexed, saying, "Ma'am, we all got it. Why didn't she get it?" I
Mm-hmm.
said, in my opinion, typically, if you're living in a country temporarily, I wouldn't advise that individual to to apply for an F1 or an H1 from that temporary country. I would rather apply it from your country of birth, wherever you are born. So sometimes they can give a 214B because they can say you don't have ties to this country.
Yeah.
And which is true. She doesn't have ties to that country. She herself is there temporarily.
Mm-hmm.
So it would have been better if she applied from India.
Yeah.
The chances are, you know. So now they're getting married. He said, should I apply for her for the fourth time for an F1? I said, no. I said, better she comes on an F2 and then changes her category to F1. Or if she qualifies for an H1, she can
Mm-hmm.
apply for an H1 now or next year.
Okay.
So, and he was telling me how he found some travel agent consultant telling him all what to do. And he
Mm-hmm.
said, I went through the wrong advice. I didn't know I could do all these things. I said, this is exactly why, I tell people to talk to an attorney
Yeah.
because we give you the right advice based on the law. We're telling you what are your options. You're not stuck with only one kind of visa. There are options. Try those.
Right.
So this was just an example. You always ask me to give, real time examples, and this is something I'm giving. So this
I think.
happens a lot, which is why I tell people, talk to me, do a Zoom call. If you're going for an interview next week, talk to me this week so you will know what documents to carry. What are
Mm-hmm.
you not carrying is something I can tell you should be. What could be the problems, like the previous person who asked the question, I don't have pay stubs. What
Yeah.
will happen to me? You're going to have problems.
Mm-hmm.
I'm not going to hesitate to tell you that. Probably you go to a travel agent, they might say nothing is going to happen because they
Yeah.
don't know. I'm not saying they're intentionally doing things, but they're recklessly doing things because they don't have the knowledge. So, which is
Absolutely.
why it felt that I need to set up an office there so that people can reach out to me and I can be there to answer questions.
Absolutely. I'm sure viewers are feeling so motivated with that news, and it's such a good news. So, Uma, first of all, congratulations, and
Thank you.
congratulations to all our viewers also, because now they'll be having, right guidance, and of course, everybody, they are thinking that travel agents or maybe getting trapped into all those things because they're emotional, or maybe there's some other reason behind it. But
Sure.
friends, it's like high time, so please go ahead and reach out to the right attorney, take right expert advice. That's the only way you can make your preparation well and can save yourself. So
And
please
this is not the time to gamble with your immigration
yeah.
issues, whether it's an F1, M1, L1, uh, E2, whatever visa you're trying to come on. Immigrant also.
Yeah.
Immigrant visas too. I've seen people getting 221Gs on immigrant visas because they didn't provide the right documentation. So if
Mhm.
somebody thinks those are easy, no, they're not.
Yeah.
Forms are changing, requirements are changing. Like every day, we just heard about this on the 25th with the alien registration requirement. They're going to have a portal where you have to register. So things are developing so rampantly, so quickly.
Yeah.
You know, people may not even be able to keep up with it. We as attorneys are having a hard time saying, by the time I can wake up the next day, there's something else.
Yeah.
And also, let me remind people March 7th is not too far away. March 7th through March 24th is
Yeah.
your dates for the registration. If you're filing your H1s through your employers, please remind them if they've forgotten. March 7th through March 24th is your deadline to file your application. So make sure you comply with those dates. I just wanted to remind.
Of course, that's a very important reminder. Thank you so much, Uma, for putting up these very important pointers to us, and absolutely making this session a wonderful one. With that, I think it's time to take up some Facebook questions as well, because we have
Sure,
taken up viewers' comments. So
sure.
yeah, here are some Facebook questions that we would also like to know the answer from you. Okay, so this is the first question, and a viewer is asking that I have an L1A visa interview. What
Mhm.
questions should I be expecting? I have worked in the US before on H1B for the same company. All right.
Well, they're going to definitely ask why you're going on an L1, whether you worked for the parent company or the subsidiary, depending on what it was, for at least 1 year in an executive or a managerial capacity. They'll ask for all your documents, your job description, job title, and they can ask what you worked on an H1B while you were in the US on an H1B. They can ask you for pay stubs, W-2s, if you were here for 3 years, 2 years, depending on how long you were here, possibly your tax returns. And sometimes, Sam, they can even ask for bank statements,
Okay.
okay? Because they want to match your bank statements to your
Yeah.
employer. If your employer was depositing your pay, doing a direct deposit, they want to see that.
Yeah.
So sometimes if there's a red flag, they feel that this individual, is showing only paychecks, and somewhere, there's a red flag. I'm not saying the person is doing anything wrong,
Mm-hmm.
but if they feel in their mind,
Yeah.
then they can ask for bank statements because they are going to then match everything. And of course, they'll want to see all the employer's documents, of both the companies, the US as well as the India company.
Yeah.
Nothing
Okay.
is guaranteed. You can get a 221G or you may get an approval. And also, let me say this one step further.
Mm-hmm.
Under this administration, let's say you get the L1 approval, for 1 year, 3 years, whatever time period. When you fly into the US at the port of entry, also there's no guarantees. The CBP can ask any number of questions.
Oh.
And has the CBP been told about this? Yes.
Mm-hmm.
They are going to be strictly enforcing whether it's an L1, H1, F1, tourist visa, whatever visa you're coming on. They can ask you any number of questions as well. The visa stamp is not a guarantee that CBP will admit you into the United States.
Oh my God.
I just want, and this is not something new, this has always been there, but the enforcement is going to be more strictly
Mm-hmm.
enforced.
All right.
So sometimes people may be taken into secondary inspection, asked more questions if there is any red flag going off.
Okay. All right. So it's still not the surety that if there's a stamp, then that person is going to have a US life, right? They can still be like returned back from the port of entry.
Exactly.
Oh God. That's so, I would say, disheartening that, people are so excited as they land in the airport, and still they don't have to be that sure. There's still a chance of returning back.
And the reason I'm not trying to scare anybody
Mhm.
off, Sam, I'm just trying to tell people to be more vigilant, more prepared, more careful, so that you don't have this preconceived thought in your mind that I got my visa, nothing is going to happen.
Right.
So you've let your flag down.
Hmm.
so you're not as prepared. I'm saying till you actually come into the United States, be prepared at every step.
That's right.
This is not to scare off anyone. This
Mm-hmm.
is, I mean, a lot of people are even coming and saying, our attorney is trying to scare off people. We're not doing that. We're just telling you to be more prepared, more careful.
Yeah. I think that's how it should be, Uma, because you are the one who are meeting with hundreds and more than 100 clients a day. So you know what people are, getting deported even with a small mistake. So
Um, Next
that's
month, I
how.
have a tour to the uh, international airport at Houston. We get these tours 2 or 3 times a year. So we
Okay.
actually get to meet the Customs Border Patrol officers. We
Yeah.
get to talk to them. We ask questions during the tour. They tell us how they admit people. They
Hmm.
tell us how the problematic cases, how where do they go, what do they do, what are their rights, do they have any rights, can they
Hmm.
call an attorney, can they not call an attorney. So all this is explained to us during the tour, and we are having one on March 6th or March 9th. I'm forgetting the date, but we have one tour coming up. So even we learn the new things that are being implemented each time there are changes.
Hmm. That's right. Okay. I think there's a lot to process, Uma. Thank you so much for putting up these very valuable examples and making us aware that these things are also happening and these things
Yes.
may happen. So I would say that again. Thank you so much. And should we move ahead with the next question?
Yes, and continuation of the last question,
Hmm.
uh, can anybody take it for granted that if they get a stamp in the passport that they would be, admitted automatically at a port of entry in the United States? The answer is no, and that includes even tourist visas.
Oh.
I know I didn't mention tourist visa. I mentioned most of the other categories, but I'm including the tourist visa because a lot of people come and say, ma'am, I have a 10-year, they can't stop me. And I tell people, don't take it for granted.
Okay.
For example, Sam, if somebody has come here, let's
Mm-hmm.
say in 2024, was here for 6 months or 9 months or
Mm-hmm.
10 months, they go back and they come back in 3 months again. The CBP will say, why are you coming back so quickly?
Mm-hmm.
So they can cancel that 10-year visa and send that person back.
All right.
Because the
Okay.
word tourist, you're supposed to be touring. You can't be touring for 9 months,
That's right. That's right.
right? And then
Mm-hmm.
you come back after 3 months again. So they'll say you don't have a job in your country, you don't do anything, you're just coming here. So the doubt comes this person is either coming here to work in a gas station or a motel
Mm-hmm.
or a liquor store. Something is up the sleeve. So
Yeah.
these are the red flag that goes off.
Okay. All right. Thank you so much, Uma, for mentioning this again, a very minute detail, because I'm sure our viewers doesn't pay attention, to these very small, I would say, pointers, and these are overlooked, and through these mistakes only, we get caught. So
Yes.
very important to mention. All right. I think now we have. I mean, we should move ahead with our next question. So here's another question asking that, hi, I'm on L1B visa and I'll be completing with my third year in September 2025. My company will apply for a green card and they said that I should extend my L1 visa for another 2 years and at the same time apply for an H1B visa as the green card process may take more than 24 months. So my question is that can I get an H1B visa on a future date? Can I apply now and get the visa after the expiration of my L1B? Or do I have to move to H1B immediately once it's approved?
That all depends what they are putting in the H1. I don't think they can do an H1B with a future date of 2 years. They can do it with a few months ahead, but I don't think they can do it with a 2 years. So if you're going to apply for an H1 and you get the H1, why
Mm-hmm.
not jump into it? What is the issue of not moving to the H1? How is it going to make any difference?
Mm-hmm.
I don't understand why not. My question is that, you know, because obviously at some point you are going to move to an H1. And if you are from India, you have at least 25 years of waiting with the current processing dates for EB2, EB3. So you
Yeah.
might as well move to an H1 because the H1 will allow you to get that 3-year indefinite extensions. Whereas an L1B, the max is 5 years.
Yeah.
So might as well get the H1 and jump into the H1.
Okay. All right. I'm sure this advice is going to be helpful for our viewer. And let's move ahead with our next question that we got from our Facebook viewer. That is,
Sure.
hello, just after advice, traveling to US from Australia on my L1 visa with my family. I only have booked flights there as we will be staying minute 1 year. So I think a minimum. All right. Staying minimum for 1 year, so can't book return this far out, and my contract could also get extended. So will this be any issues at immigration or with airline? I am assuming with the visa stamped in our passports, it won't, but just checking.
No, on an L1, you don't have to have a return ticket, whether it's an L1 or an H1. They know that you're going for an employment based, you could have an extension. So they don't expect you to hold a return ticket. So you don't have to worry about that. And, you can tell the officer that you're an L1 and your L1 could be extended or may not be extended. You don't know that. So if your project is completed, your job is completed, then typically the employer purchases the return ticket for you. So it would be up to them to make sure that you are repatriated back to your country.
All right. I think that's a point of relief. Let's move ahead with our next question. I think this we took already. Yeah, this one. Okay. Hi, friends. I'm a Canadian citizen and my L1 visa was approved last week at the New York border. How do I find 13 characters long petition number or receipt number so my non Canadian spouse apply for her L2 visa at the US consulate? All I have is L1A visa stamped on my passport and my I-129 approved stamp, so I can travel to the US, but for my spouse's visa, I need to have petition number, receipt number. I called CBP, but they are not able to provide that information.
Your attorney, your company, your employer should provide you with that. The approval has the receipt number. So your employer should be able to provide with that, or the employer's attorney should be able to provide.
All right.
However, you mentioned that you have an I-129, I-797 approval. If you want to reach out to me, show it to me. I will make sure if that's the correct document. And then, you can then apply for your spouse's L2 visa.
All right. So I think, Uma, these were some of the questions that we got from our viewers on Facebook. And we already covered live questions also from YouTube platform. So I think now we are done with all the questions, all the queries. So lastly, I'm just left with thanking you, for bringing up such insightful information and making this session again a very wonderful one. So thank you so much. We are really honored that we get the chance to have shows with you on every Thursday. So hoping to see you soon on next Thursday. Thank you so much for being here.
My pleasure, Sam. It's always a pleasure to come on Immigration Talk Show every week after week with the most current information that we both, find, gather, and I get information because I'm a AILA member. So every day, every hour, literally we get information. Whatever we get, we bring it to you and to the viewers so that they're updated with this information. So once I have more information about the alien registration requirement, I'm going to bring that up because there is a lot of confusion whether an H1 should register, whether an L1 should register, whether a F1 should register, or their families need to. So there is this confusion. So we are not clear ourselves. We're waiting on clarification from the USCIS. Once we get that, we can do a brainstorming session on that.
Absolutely. I'm waiting for it. All right. Thank you so much, Uma, for being here. I'm so happy that you took us
My
some time
pleasure.
being here. So, again, it was lovely having you, and thank you so much.
Pleasure. Have a good week, Sam.
Same here, same here. All right, friends. So, this was the end of our session, and we got to know a lot of information in today's webinar. Hope you all have enjoyed this session and filled up with yourself with lots of information. So, thank you so much, everyone, for joining us. And you can also reach out to Attorney Uma Mantravadi on the given contact detail, that is 713 with the email ID, that is uma@mantralaw.com, and the website is www.mantralaw.com. So that's all for today's webinar, friends. Thank you so much for being here. Don't forget to like, share, and subscribe to Immigration Talk Show. We'll be coming out with more important topics and more exciting webinars. Don't go anywhere. Press the bell icon so that you can get the notification every time we come live with different attorneys. And that's all for today's information. Thank you so much for joining us. See you next time, and keep watching Immigration Talk Show.
Hello, everyone, and welcome to Immigration Talk Show. I'm Napasa, your host for today, and I'm happy to be back. So, welcome once again, friends. We have got a very interesting webinar lined up, and before I introduce you to our guest for today, I have this very important disclaimer. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. With that said, friends, today we are going to have a very familiar face who has been a part of Immigration Talk Show for quite some time now. And he is an immigration attorney from Dallas, Texas, from SPB Law Firm. So without further ado, help me welcome Attorney Chant Parvathaneni. Hi, Chant. How are you doing today?
Hello, Nipasa. How are you? Pretty good. And thank you for inviting me again on this show. Hopefully, we'll have a very good discussion today about some of the current topics on the immigration side as it pertains to the employment based immigration.
Absolutely. And it's the H1B season, so nothing better than our topic of discussion for today. Yes, friends, today we're going to discuss about H1B RFEs on the rise this year, 2025, and what it means for the March lottery. And of course, Chand is going to be here to answer to all of our questions, mine, yours, and you can participate in this webinar by commenting. So wherever you're watching us, you can put your questions in the comment or even join us on call. Actually, you can call us on this number 425-436-6335, and the access code is 988-888. There is 8 5 times, so 988-888. Join us and it'll be very nice. So Chand, what can folks out there expect from today's discussion on this topic today?
Sure. So we have a new administration since January, and a lot of things are changing because, again, anytime a new administration comes into office, because they do things a little bit differently. And right now, the Trump administration, they're kind of refining all the processes, not just in immigration but across all the federal agencies. And what that means is we will see things a little bit different. And on top of it, the Biden administration, while they were leaving office in December, what they have done is they have changed some regulations. They came up with strengthening and modernizing H1B regulations, and they came out with a final publication of a rule where things from January 18th, they got changed a little bit. So now we have these new regulations that the previous administration finalized, that started in January. And then on top of it, we have a new administration where they're revamping and re-looking at their own processes. And what that means is we are seeing different kind of RFEs. We have started seeing new RFEs, new ways of USCIS adjudicating things. And on top of it, based on the current administration's priorities, we know that a few things will change. And we will use this opportunity to see today, discuss what is changing, what are the new kinds of trends we are seeing in terms of new requests for evidences for H1Bs. And since the new H1B lottery will start in about a few days, it's starting on March 7th. So we're just a few days away from March 7th. So we'll also talk about what people can expect once the lottery starts, and once the lottery is over, what they can expect and how we can do things to make sure we are in compliance with the rules and regulations of USCIS. We are in compliance with the requirements, and people do things the right way. And by doing things efficiently, they can at least try to aim for an approval, because this process is pretty expensive. The whole application for H1B, the employers have to spend a lot of money. They have to pay a lot of money to the government. And on top of it, the employers also have a burden of ensuring that they comply with a lot of federal regulations.
Right. And so, friends, thank you so much for joining us once again. You can follow us and don't forget to hit the bell icon. We are on YouTube and our handle is at Immigration Talk Show. So, yes, subscribe to us at Immigration Talk Show. Also, check us out on Facebook, LinkedIn, Instagram, and also on X. All right, so now let's not wait any further. So, my first question to you, Chand, is that there are so many reports out there saying and speaking about the increase in RFEs for H1B petitions, especially this year. So, what do you think are the main reasons behind this trend?
Sure. So in the last 1 month, we definitely saw a little bit of uptick in increase in RFEs. I would not say that we are drastically seeing a huge increase, but I definitely can say that at least for the H1B petitions, we are seeing new kind of RFEs, and we are seeing a little bit increase in the number of RFEs. And I think the primary reason for that is definitely the new H1B rules that came into effect in January. So this stemmed from the final rule where they published these regulations, uh, stating that they're strengthening and modernizing the H1B regulations. And a part of these rules, what they've done is they're focusing more on the bona fide nature of the job. So in terms of focus on added focus on that, nowadays they're requesting for contracts. Now you have to show the contracts, you have to show the purchase orders, you have to show the content of the purchase orders, and client letters, vendor letters. So this new requirement, I think, is causing USCIS to issue new kind of RFPs. So they're coming back and saying that the old memo, the memo that got issued in 2020, so in the RFPs they're stating that this memo has been rescinded, and now they are asking for some additional evidences. So that is where we are seeing some increase in RFEs. And then we're also seeing increased RFEs for proof of maintenance of status. So if a company has applied for a H1B in the past and that same employee is getting filed for an extension, one of the things that USCIS will see is whether that employee has been maintaining his prior status. So there is a lot of focus on USCIS's side, where they're actually looking and asking us to prove that the previous petition, the employee has followed the terms of that petition. And what that means is, if it's a transfer, the employee has to work with the previous employer. He has to have pay statements. He has to be in that particular role. Or if amendments are required, amendments have to be filed timely, and so on. So USCIS has been definitely scrutinizing what employee has done in the past. So before applying, so the previous H1B petition, has the employee been working as required, and so on. So we are actually seeing a lot of scrutiny on that. And the reason for that is this new rule, the regulations that went into effect in January, they actually talk about ensuring that the employee has maintained his prior status. So that's also is contributing to this trend. And on top of that, the new administrations, because of the new administrations way of looking at things. So again, they are looking at employer-employee relationship in a different manner. They're looking at wage level discrepancies in a different manner. If it's a wage level one, so we are seeing an uptick in RFEs where USCIS is questioning the wage levels. And in general, because USCIS, as they kind of look at their own data, they want to prevent fraud. So there are increased fraud prevention measures, and a part of that, what USCIS does is they have something called Vibe Check, validation instrument for business enterprises. So it's their database where they cross-reference employers' information. They look at their data. They look at the data that's coming out in the I-129. They want to make sure employer is legitimate, the number of employees, the revenue of the company, and so on. So they have their own internal database, a Vibe database. So they check against that database. So as a part of increased fraud prevention, we are seeing RFEs which specifically talk about Vibe, where they say that things don't match up, things don't line up. So they ask for more information. And so this is another reason why we are seeing a little bit more uptick in the number of RFEs. And then overall, I think I would say this whole H1B modernization rule and the codification that went into effect in January. The USS officers, they're also having to look at this new modernization rule and look at things in a different manner. So initially, what that means is because even the officers are new to this rule, so sometimes the likelihood of RFEs increases, which I think is what has happened. And all these factors have contributed to the rise in RFEs in the last 1 2 months.
Exactly, and I think it was 17th of January, right? Many things, many new updates started, and these new rules also apply. And the lottery is going to start up in about just a week or so. So there's a lot of
Yeah.
changes and things that you have to keep in mind. So maybe you could give out a few tips, Chand, for folks out there who are going to participate in the lottery.
Sure. So again, the good thing about the lottery this year is it is beneficiary centric, and what that means is 2 3 years back, we had a lot of issues with multiple registrations, and multiple registrations means some companies are colluding together because the companies are owned by the same set of individuals or their relatives, and the companies are colluding together, and they're trying to increase the chances of somebody in the lottery. So that was giving some people unfair advantage. And what USCIS has done is they went back and forth. They changed the rules last year. So now it's a beneficiary centric process. And a beneficiary centric process means even if an employee has multiple legitimate job offers, say Microsoft is filing for him, Google is filing for him, Apple is filing for him, whether a person has one job offer, has multiple job offers, the chances are exactly the same. So this is a good thing. So what that means is no matter how many job offers somebody has, the chances of getting selected in the lottery is exactly the same. And what that means is it will definitely prevent fraud. It will definitely prevent collusion. So that's a good rule that went into effect last year. And after that rule went into effect last year, the number of registrations dropped dramatically. So they almost came down 50%. That's what happened last year. So that's a good thing for all the folks out there who are getting the registrations ready by their employers, because nobody's going to get any unfair advantage. So everybody is on the same level field, which is a good thing. The only drawback this year is the registration fee. Last year, the employers were paying $10. This year, the employers have to pay $215. So that's a big hit. So employers will have to pay a lot more for the registration this year. In a way, that's really bad, because some employers might be discouraged even if they have a good employee, because if the employee does not get picked up in the lottery, the employer will not get that money refunded. So the money is gone. So whether somebody gets selected in the lottery or not, that $215 that they have to pay to USCIS is gone. So for that reason, some employers might not really be willing to spend that money unless they know, hey, my employee is going to get selected in the lottery, and it's a good use of money. So for that reason, I do think that the number of registrations might come down. But the other side, the positive side is that anybody who's just trying to register just because it is cheap, they will not register. So at least the good thing about $215 registration fee is only if the employer is really serious, they know that the employee is highly qualified, they would not get them into the lottery. So there are positives and negatives about this new $215 rule. But in reality, what I think would happen is you will definitely see a decrease in the number of registrations. Last year, because of the new rule, we already saw the decrease in registrations. But last year, I think it was a good rule because it eliminated the multiple registrations problem. This year, we have to wait and watch. But one thing I can say based on my discussions with our clients is this year clients are going to, I mean, the employers are going to file only if they're really serious of that employee, because it's an expensive process this year compared to the $10 they were paying last year. And in terms of suggestion, employers, I think, should file only if they have a bona fide job offer. If they don't have a bona fide job offer, they should not be getting into the lottery because it's an expensive process. And not only that, they're going to waste somebody else's slot. Number one. Number two, people have to make sure they have a valid passport. And not only that, they have to make sure they're entering the right passport, the right information. If there are any typographical mistakes like date of birth or passport number or anything, tomorrow USCIS could come back and cause a problem when you finally apply for the H1B. For this reason, people have to be very, very careful when they are doing the registration. Make sure the data is accurate, the passport number is accurate, the names are accurate. And if somebody's passport is not valid, has expired or about to expire, make sure that you apply for a passport renewal right away, because for a lot of countries there are ways to expedite passport. So people can, if somebody's passport is expiring, there are ways where somebody can quickly get a passport. Like for example, in India there is Tatkal, so people can get a passport in about a week. So anybody whose passport has already expired or is about to expire, it's a good time, well ahead of the lottery deadline, they should go ahead and get their passports renewed. And one final advice is there is something called master's quota and regular quota when they apply for H1B registration. People have to be cautious. And if somebody marks it inaccurately, they make a mistake and they put somebody's quota as master's quota when they don't qualify for master's quota, that H1B registration will be invalidated. So always make sure that if somebody is getting put in the master's quota, verify the name of the university, make sure the graduation date, and so on before putting somebody in the master's quota. Okay. So again, the registration part is pretty simple. Again, if things are, the data is accurately input, it's a very simple process. And before March 31st, the lottery selection will be done. And then the actual filings will start.
Very, yes, thank you so much for those wonderful tips, Chand. And I'm sure that folks out there are liking all these tips, since, H1B lottery is really knocking at the door, almost the season now. And talking about the fees, $215, it's a huge hike, 200% almost or more. So, what do you think is going to happen with the money, that US is going to accumulate with this? The registration process.
Sure. So USCIS is a self-funded agency, and what that means is they're not really relying on the government for the funds. They are self-funded. So basically, they generate their own revenue and they use it for immigration purposes. So what that means is, again, the money is not going into private hands; it's going back to USCIS. So hopefully, that money is required to be spent for USCIS purposes. And what that means is they use it for hiring, they use it for making the processes more faster, more efficient, and so on. So normally when we hear about any government shutdowns, typically USCIS is not impacted because they have money. So the $200, it's a huge money, and hopefully USCIS will use that money to refine their processes and make things a lot more smoother for others. But again, even if they get 200,000 applications, which I think they will definitely get this year, because last year they got 400,000 registrations. So 400,000 registrations at $10 for each registration, that's equal to about $4 million. This year, $215 times the number of registrations. So it'll be a couple of millions of dollars. It's a huge amount that USCIS will be getting, but hopefully that money is being spent for modernizing their computer systems, making things more efficient, which is what eventually will happen with that money.
Absolutely. Thank you so much, Chand, for taking that up. And, at this moment, I would just like to say hello to all our folks who have joined us with their questions as well. And also everybody out there who are watching us. Thank you so much for joining us on Immigration Talk Show. Please don't forget to subscribe to us if you haven't as yet already. And our handle is at Immigration Talk Show on YouTube. We are also on LinkedIn, Facebook, X, and on Instagram. So check us out, follow us, connect with us. All right, so hi to Nandini, Rag. Rag says hello, Nipasa and Chand. Hello, Rag, one of our very frequent viewers. Always good to have you. So, Rag, if you have any questions, also please feel free to comment. Also, hello to Geeta, Reddy, Abha. We are going to take up your questions. Please stay with us. All right. So now, Chand, my next question to you is, you know, there are probably certain job categories or industries who are seeing a higher rate of RFEs compared to that of others. So, if so, why is it like that?
Sure. So when we talk about H1Bs, the majority of the H1Bs go to the IT and the tech industry because the tech jobs are who use the H1Bs on a large scale. So when we talk about just the numbers in general, normally the IT and tech industry is where we typically could see more RFEs. The other industries that use a lot of H1Bs are nowadays a lot of the pharmaceutical industry, the semiconductor industry, healthcare industries. They're also using a lot of H1Bs. And normally, my uh, experience is healthcare occupations typically have very, very low rate of RFEs. And the reason for that is since COVID, I think the general consensus has been that healthcare is pretty, pretty important. And USCIS normally they tend to do healthcare petitions a little bit quickly, and healthcare I typically don't see issues. And after COVID, a lot of focus has come down to bringing industries back to US, which means the pharma industry and the chips, the semiconductor industry. So we're seeing a lot of jobs come back to US, at least a lot of validation engineering, the pharma jobs, and the semiconductor, those kind of jobs coming back into US. Those also we typically don't see a lot of RFEs in general. And even within the tech industry, if it's a staffing kind of a company where you have an end client, so basically you have a situation where employee is an employee of a certain company, and through a vendor they're working for another end client, and the end client is somebody else. So those are the kind of areas where we tend to see a lot more RFEs. And I mean, again, historically, anytime you have a consulting or a staffing kind of an arrangement, they definitely face higher volume of RFEs. And the reason for that is for the last 15-20 years, always USCIS goes back and forth with this employer-employee relationship. If somebody is a full-time employee, the employer-employee relationship is pretty easy, very easy to establish. But when you have this situation where you have in the consulting world and the staffing world where somebody is working at the end client, the employer-employee relationship is a little bit difficult to establish because who's giving the direction for somebody's work, who is directing and supervising somebody's work, and so on. It becomes a little bit hard. And then in 2020, we had a lawsuit, and USCIS came out with this memo. And ever since, employer-employee relationship became a little bit easy. But again, in the new modernizing rule, again things are a little bit different because that old memo was rescinded. And what that means is consulting and staffing companies can anticipate RFEs even going into the future. And again, the lesser used industries like education positions, research positions, a lot of universities use research positions, creative positions. So those kind of fields, I do think that we will not be seeing a lot of RFEs. And staffing kind of roles, and even within the staffing roles, so there is something called own it. So every H1B that gets filed, you have to map it to an own it occupation, you have to map it to an own it code, you have to also give the wage level. Normally what happens is when the wage levels are low, or some particular occupation, some particular own it occupations who don't really have a bachelor's requirement, when you look at the occupational outlook handbook and look at their requirements, those are the ones you typically will always see a lot of RFEs, because specialty occupation is something you have to prove on every H1B petition. And some own it codes, by the nature of their data, by the nature of their occupation and how it is in the occupational outlook handbook, the USS will routinely come back and say that is not a specialty occupation. Okay, so high level, some industries are always a target, and even within the industry, some own it codes are always going to be problematic.
Okay, Chand, thank you so much for taking that up as well. And I think we should take up a few questions from our audience right now so that they do not wait too long. So let's take up Nandini's one. Nandini is asking, I have an IT consultancy offering me an H1B, but I heard that USCIS is increasing RFEs for third party placements. How can I prove that I have a valid employer employee relationship for the entire duration of my visa?
Sure. And so again, ever since we have this H1B modernization rule in January, so the way USCIS is looking at third party placements has changed a little bit. So they even modified the I-129 form. So now you have to actually put the end client name and a few things about end client on the I-129 itself. So this is a new thing, and it was not there prior to January 18th. And how do you prove? So again, because we have done a lot of filings in the last 1 month, and what we are seeing is, so the way you would prove the employer-employee relationship is, you have to initially prove what your assignment is. And what that means is, if it's a third party assignment, like in your case, you have to produce the purchase order, you have to produce the statement of work, or you have to produce the vendor letters, or you have to produce the client letters, one of these documents. I mean, again, USCIS does not say this is mandatory or that is mandatory. It is the company that has to prove the bona fide nature of their assignment. And if they're able to establish the nature of their assignment, USCIS does not have a problem, because staffing is allowed, consulting is allowed. And the purchase order, even if it is not for 3 years, because it's very hard for every employer to have a 3-year purchase order. So even if it's a short-term purchase order, at this point of time, we are not seeing any issues with USCIS. However, what USCIS wants is, do you have an assignment on the day of filing? Whether it's a 6-month assignment or a 1-year assignment, as per the purchase order, that's okay. But you do have to prove that on the day of your filing, you do have a valid bona fide assignment with a third party, with the end client. And how do you prove it? The easiest way is, the company will sign a purchase order or a contract with somebody, and you use that to prove that you have a valid assignment. And if you're able to show that, we are not normally seeing any issue. So if somebody comes to us and says, hey, we don't have any contract, but we want to place somebody on a project after we do the filing, that cannot be done. On the day of filing itself, you need to have a bona fide assignment, which means on the day of filing, you need to have the contract signed. So if that is the case, in general, you should not have any problem with employer-employee relationship, even in the current new rules.
Okay. Thank you so much, Chand, for taking that up. And Nandini, I hope you've gotten your answer. Thank you for participating. Now, next up, we got Geeta Reddy asking, I heard USCIS is scrutinizing specialty occupation criteria more than ever. So, my H1B job title is Market Research Analyst, and I have an MBA in marketing. Could this raise red flags, and how do I prepare for potential RFE?
Sure. So, market research analyst, that particular owned code, historically it had a lot of problems. And if you Google, you'll see a couple of lawsuits filed for USCIS denials on marketing research and analyst positions. And in 2000, I think it was like 2020 or 2019, so there was a lawsuit where the court said market research and analyst, I mean, it is definitely a specialty occupation position. And in general, it is prone to RFEs, but again, we are not seeing challenges in the last couple of years if the duties require a bachelor's degree. So again, in your case, you said you have a degree in marketing, your position is market research analyst, and if you look at own it, market research analyst on an entry level also requires a bachelor's degree in a specific field. So more than likely you'll be fine. But historically, we did have challenges with that occupation previously, a couple of years back. So even now, as long as the job duties are detailed and there is a nexus between your degree, your qualifications, and the job duties, and the job duties do require a bachelor's degree or above, and in your case you have a master's degree with focus in marketing, so more than likely you should be good. And this is a field that is prone to RFAs, but again, if you're able to prove, you should not have any issue.
Okay. Thank you so much for taking that up for Geeta. Geeta, thank you for participating. And well, Rag is also here with a question. So, Rag is asking, with the current state of RFEs, will it be better to go for a blanket L1A instead of the individual N1A provided the company is eligible for both?
I mean, I would go with individual L1A rather than a blanket L1. The reason is if you go with an individual L1A, if you get an approval and everything looks good, tomorrow, normally what companies do is the companies look at explore the EB1C option. So I would say, if the company has a blanket L1 and you're also qualified for individual L1A, L1 can be done in premium. So to me, it's always worth taking that extra effort and trying for an individual L1A, because if you get an approval for L1A, you're able to prove you're basically proving that you're a manager on the offshore entity side. You're coming here to work as a manager on the US entity side, and tomorrow you use that to explore EB1C options. And EB1C option is a great option to explore. Not a lot of people qualify. So when you have the chance, I would always say that like maybe you should take the harder route. Look for the individual L1A. The good thing is it's possible to do it in premium, so you'll get a quick answer. And if the company has L1s, blanket L1s, I'm pretty positive that the company is a huge company. It's a big company. So based on your role, definitely I think I would say try for L1A, and if you get through, EB1C becomes a great option for you.
Thank you. And Rag, thank you for participating as well. I hope you got your answer. And next question, this is from Abha. Somebody with family preference AOS already filed. Can their employer apply for H1B? Things that need to be kept in mind given the pending AOS. And when you say staffing companies and consultancies, does it also include consulting companies like EY, McKinsey, etc.?
Yeah, yes, technically, even they are consulting companies, and in the past, before 2020, even they had denials for H1. And if you look at like just Google Infosys or TCS, Infosys got a huge penalty, I think, last year for immigration. TCS, I think there is an issue about TCS. Recently, I think it's in news about some issue that they had with immigration. So even big consulting companies could run into issues. That being said, it's not about uh, the consulting company or not. In general, whenever you have a consulting company and you're saying that your employee will work at a third party location, the rules are a little bit different. The analysis is a little bit different. So, a small company, I have seen lots of small companies with one or two employees not have any problems with their H1B. Sometimes big companies could have a problem, or big companies might not have a problem. So the whole thing is, it is what exactly is the assignment. So the big companies, if they're able to prove the assignment, they'll not have a problem. And even if it's a big company, if they're not able to prove what that assignment is, they will have a problem. So, but again, in general, whenever you say it's a third party kind of an arrangement, in the new rules, in the new I-129, they are actually asking for that information on the I-129. And what that means is whenever they see that it's a third party kind of an arrangement, the analysis will be a little bit different. But again, if it's a big company like E&Y, McKinsey, normally they have a valid assignment, they have valid bona fide assignment. So it's a lot easier for them to prove when you're a big company. But again, in terms of USCIS officer looking at things, yes, even big companies get RFEs. Even again, it's just a part of their job. So every case is different, and the occupation for the case is different. The salary they're providing for that case is different. So all these things will contribute to the H1B. And going back to the other question, so you have a pending AOS. Pending AOS means based on your family relationship, somebody has filed for a green card. You can always pursue a H1B even if you have a pending AOS. So even if you have a pending green card application, H1B is a dual intent visa. So you can have employment based H1B non-immigrant visa processed simultaneously along with the pending family AOS. It's completely legal. And what I advise is it's always better to maintain your own status until that other AOS application gets approved. Because if something were to happen to that AOS, H1B is your backup. So legally, you can pursue both. So you can stay on H1B while the pending AOS application is in progress. The only thing is, if you're on H1B, you have to make sure you're following the terms of H1B, which means you are working as required, you're getting paid as required, you're staying in the same metro where you're working. So all these requirements about H1B. So as long as you maintain valid H1B status, you comply with the rules of H1B. Having a pending AOS will not cause you any problem, and it's actually a good idea. If you have a pending AOS, pursue it in a legal way, and be on H1B until that case is approved.
Okay. Thank you so much, Chant, for taking that up for Abha. And right now, I think I would say that we should go for a short break. But we also have Sanjay who has joined us with his questions. Sanjay, stay with us. We will take up your questions after the break. And Chant, I also have some more questions from my end. So for now, we'll just go for a short break and be back on Immigration Talk Show. Folks out there, don't go anywhere. Stay with us. It's Napasa and Chant. Hello and welcome back, everyone, to Immigration Talk Show. I'm Napasa, and today we have a very interesting webinar with none other than Attorney Chant Parvathaneni from SPP Law Firm, Dallas, Texas, and we are discussing about H1B and the most common RFEs this year. And he's also giving out tips on how can we prepare ourselves for this upcoming lottery, the March lottery. So thank you so much, Chant. It's been great so far, and also folks out there for joining us. Abha, and we got Rag, Geeta, and Nandini. And also, let me tell you that if you're enjoying this session, do not forget to subscribe to us. Our handle is at Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, X, and also on Instagram. Do check us out. And also, if you want to contact Attorney Chant Parvathaneni directly, have a one on one consultation, maybe have him guide you for your H1B this year, call him on this number 817-523-8247, and you can also email him at law@spblawfirm.com, and do go visit www.spblawfirm.com to get to know more about Attorney Chant Parvathaneni. So, also, friends, you can join us on call. Why don't you call us? I mean, Appa or even Rag, maybe even anybody out there who's watching us. Why don't you join us on call to ask your questions yourself? 425-436-6335. That's the number. And when they ask for the access code, dial in 988-888. Okay, so I was saying after the break, I'm going to take up Sanjay's question. Sanjay is asking, I work in STEM field, but my job requires a mix of technical and managerial skills. If USCIS issues an RFE asking for proof that my role is a true specialty occupation, what kind of evidence should my employer provide?
So USCIS has certain requirement on how you would prove a job is a specialty occupation. So the way you would do it is you look at the normal industry standards. So you look at the industry standards for the job. And if you're working at a client location, you look at what your client requirement is. You look at how specialized your job duties are. you look at for that occupation, you look at what the occupational outlook handbook says regarding those job duties. And so there are like a whole bunch of ways you can do it. So you can also get expert opinions from a professor, where the professor will talk about the nature of the job and so on. So USS has a certain requirements. So they have like four prongs that you can meet any of those prongs in general to prove that your job is specialty occupation. Again, the goal is as long as your job duties require at least a bachelor's degree or above in a field, in a relevant field, not like any field. So when I say relevant field, it could be like computer science, IT, software engineering. It could be like different fields, but all of them have to be related to the job duties. So if you say like software engineering, computer science, IT, they're kind of related to the job duties. But if you say mechanical, that's completely a different field. So you, as long as a set of closely related degrees are required to do your job duties, pretty much that job is a specialty occupation job. And the way you prove it is just looking at the detailed job duties, seeing how does somebody qualify, the industry standards, if you have a client, the client requirements, and so on. And that's how they would do it. And again, if you are in a very technical role, more than likely you should not have a problem.
Thank you so much, Chand, for taking that up, Sanjay. And Rag was back. He was still asking because okay, he asked, "Thanks, Chand. And are blanket L1A not eligible or tougher for EB1C?"
So EB1C is basically where your company will apply an I-140 on your behalf in that managerial category. So again, when the company applies for EB1C, you don't even require an L1. In general, like L1A is not even required. But what happens is when the company applies for a L1A, as a part of the petition, they're trying to prove that you are a manager in India, you're a manager abroad, and your role in US. They will talk about your role in abroad entity, the role in US entity. They'll try to prove all those things. So normally, what happens is you can reuse a lot of that data when you apply for EB1C, because EB1C is again it's like independent application. So whether you're an L1A or not even on L1, the company can still apply for EB1C directly. But since if the company does an L1A, individual L1A for you, the company is documenting all those things, they are getting everything ready. Your EB1C normally becomes a lot easier because you have all the documentation ready. You can easily convince your company that, hey, we already have all the data. It's a lot easier. But in terms of eligibility, L1A is not even required for EB1C. EB1C is completely independent by itself. And the company will have to do it independently. So theoretically, even if you don't have an L1A, individual L1A, if you are eligible, the company can still file EB1C for you.
Okay. Thank you so much, Chand, for taking that up. And Rag, I hope you've got your answer. We also got K. Vishwanathan with a question saying, "Hello, Sam. Hi, K, but I'm not Sam. I'm sure you miss Sam. Sam is going to be back with another webinar at 2 p.m. Eastern Time, so don't forget to tune in to Immigration Talk Show, all right? And I'm sure that this question is also going to be very relevant at that time. But Chand, if you would like to take it up, or maybe you could just briefly answer to K. Vishwanathan asking, "My question is L1A visa interview getting into any challenges or hard vetting? I'm waiting for appointment scheduling for L1A 2 with family. Should I go alone or with family together?"
Sure. So I think starting from January, we are seeing a lot of issues with appointments in India, and they've been canceling appointments. And again, like 2 weeks back, they actually announced and changed the rules for Dropbox. And what that means is more and more people are required to go for interviews, and we are seeing challenges where appointments are getting very, very tough. And we also heard some news about 10% of the staff at Department of State, so at the consulates, could be reduced in the next couple of months. And what that means is the staff gets reduced, and now the Dropbox appointments, people are not getting Dropbox, but they're mandated to go for in-person interviews for a lot of other visa classes. All of these are going to like create more challenges at the consulates for your interviews. We expect things to slow down even further. And what that means for you is keep checking the website, and rather than go with the family, try to book an appointment for yourself. The minute you get an appointment, try to at least get your appointment done. And unfortunately, because so many rule changes, so many staffing changes, uh, getting appointments could be tricky, could be taking longer. And to me, if you ask me, definitely go. Uh, you as the primary applicant, I think you should go get your visa first, and then the minute the family gets their appointments, they can go for their appointments.
Thank you, Chand. Thank you. So he also is asking another question. Kay, what's your thought? He's saying, "Hi, Chand. What's your thoughts on L1A staying in same city as mentioned in I-129 petition, or take risk to move to another city, but I work legally and justice to my job and organization and my client."
So this is again something you might have to talk to your company, because you have to make sure you follow the terms of your petition. So whatever the company's petition is, you do have to follow the terms of your petition. So just make sure you check with your company, and if you got an L1A, you're probably working at a big company. So and again, the company will know what they've done in their filing. So as long as you maintain the terms of your petition, you will not have a problem. So you cannot do anything that is violating the terms of your petition. You cannot have material changes. So just make sure you check with the company and see what they have filed, what they have notified USCIS. And as long as you maintain the terms, you should not have any problems. If you have any material changes, typically that's when you could have issues.
All right, Chand. So, thank you for taking that up. And Kay, I hope you've got your answers. Also, my next question to you, Chand, would be, if you could tell us about specialty occupation again, and what specific documentation can H1B applicants provide to avoid or effectively respond to RFE related to specialty occupation issues?
Sure. So when you talk about specialty occupation, you have to convince USCIS that that particular job requires at least a bachelor's degree or above in a particular field. That is pretty much what you're trying to prove when you apply, when the company applies for your H1B. So in terms of what you can provide upfront to avoid these kind of RFEs, the first and foremost thing that you should do, your company should do, is they should give a very, very detailed and elaborate explanation about your job duties. And normally where I see an issue is some companies are giving only 5 or 6 lines of the job duties. And if the job duties are not clear, not very elaborate, that's basically your biggest risk, because USCIS has to know what your detailed job duties are. You're asking for a H1B for the next 3 years. And what that means is be as elaborate as possible. To me, that means maybe 2 or 3 pages of detailed job description. Put percentages. Okay. So what that means is, say you're working on client calls, and so client calls don't require like any education. So you have to be very, very specific. If you say client calls, you're calling the client, you're getting on the client calls to discuss about technical requirements, for example. So you have to detail your job description. You have to put percentage, how much time do you spend, because you have to spend your time on complex tasks, specialty occupation tasks. So give as detailed explanation as possible about your job duties, very elaborate description. Put the percentage of time that you will allocate. Okay, just don't give some random duties, but very clear, and give a very clear picture to USCIS on how your day looks like, or how your week looks like. Maybe 40% of the time you're spending on software development, 10% of the time you're spending on software testing, 10% of the time on requirements gathering for your technical product, and so on. So uh, elaborate job descriptions with percentage allocations is the first and the foremost way that you go to USCIS. That's first thing. Second thing, again, if it's a third party client, if at all possible, try to get vendor letters or client letters where the client or the vendor, they talk about the education requirements. So if the client comes back and says, hey, for doing these job duties, our normal requirement is so and so degree in so and so field, that adds a lot of value. So what you should be doing is, if it's a third party client kind of an arrangement, get a letter from the client, get a letter from all the vendors discussing the educational requirements for doing this job. So that will give a very good clarity to USCIS on what kind of a job, what kind of an education requirement you need. And the other thing is your employer themselves actually telling USCIS what the education requirements are, their normal practices are for that particular role. That is also very important. And again, some employers go ahead and submit some kind of proof upfront, maybe like a expert opinion from a professor, or maybe some of their prior hiring history, and so on. But on a high level, at least the basic these basic things have to be tackled upfront. And on top of it, you have to use the right onet code. So when you use the right onet code, good practice is to also include the occupational outlook handbook documentation, because the occupational outlook handbook documentation or Bureau of Labor Statistics, their reports, they clearly show for this occupation what is the standard. For example, if somebody is a software developer, the industry standard is a bachelor's degree in computer science or a very close field of computer science. But if you see something like basic web developer, for example, if you look at occupational outlook handbook or own it, the general requirement is not a bachelor's degree. So including those documents upfront as a part of the filing, showing the onet code, showing what the occupational outlook handbook requirements are for that onet code, that upfront will tell USCIS what that requirement is. So these are some of the things that you do to reduce the risk of specialty occupation RFE.
Thank you so much, Chand, for taking that up. Now we have Galela, who has another question for us. Hi, Galela. Thank you so much for joining us. I wish you can also join us on call. If you can, dial this number 425-436-6335, and the access code is 988-888. So Galela is asking, do I need to mention about my green card application in DS-160? Perm process just started. I have a visa appointment in May 2025. I am on L1B right now. I am in USA changing H1B, same company.
So the question that the DS-160 asks is, do you have an immigrant petition filed on your behalf? So perm is not the immigrant petition. So if the perm has just started, your immigrant petition has not been filed. If somebody's I-140 has been filed, I-140 is the actual immigrant petition. So if the I-140 is filed, you would always mark it as yes and give information about your immigrant petition. But if the perm has just started, the perm is just a Department of Labor application. So perm is not really an immigrant petition. The I-140 or the I-130. So for family-based folks, I-130 is filed, or for employment-based folks, I-140 is filed. So, and for like investors, like EB5 investors, I-526E is filed. So if one of these petitions are filed with USCIS, that is when you have to mark it on DS-160 and notify the Department of State, the consulate, that an immigrant petition has been filed. But if it's just the perm is not really an immigrant petition, so you don't really have to put that on your DS-160.
Thank you so much for taking that up. Galela, I hope you've gotten your answer. Rag is back with another question asking, I am in current light. Could applying as a third country national work if consular appointments are not available for work visas?
So be cautious about the third country nationals, the TCNs. So what is happening is now all pretty much like every consulate is overburdened because of so many people trying to apply for visas in the last couple of months. So even before President Trump started, there was a talk that people, I mean, I guess people thought that things will slow down. So there were like countries like Mexico. We saw a lot of challenges. Even in December, November itself, people were finding it very, very challenging to get an interview appointment. So, and what this I mean, these foreign consulates, a lot of these consulates, if you're not a resident of that country, they tend to prioritize things for their own residents. So the rules for the consulates keep changing very, very frequently. So you would have to actually call the consulate or talk to the consulate and look at the rules. We had a number of cases where at the last minute appointments got cancelled. So whenever you're in a third country, uh, be aware that the third country, every the consulate, they can make their own rules. So things keep changing. For example, if it's Mexico, if it's first time H1B stamping, they don't do it for TCNs. If it's Canada, they're doing it. And again, within the country, you have multiple consulates. So the answer for you is you would have to personally check with that consulate's requirements, because the consulates don't have uniform rules. So every consulate is different. And if you're not really a resident of that country and you're going to a third country as a third country national, they may or may not accept you.
Okay, thank you so much. And okay, Key is saying, just for your information, my friend I-129 is approved, say 131 and 310. in his family visa interview. So about 20-30 days lag for now, I see. I'll update next week the dates I get for myself. Okay, thank you so much for the information, Kay. And I think, yeah, Chan.
Yeah. And again, what I see with the dates is all of a sudden the dates get opened up. So I think you have to constantly look for the dates because they open up dates and then you have to take appointments. And again, right now I can tell that there is a lot of demand for appointments. The reason is this whole Dropbox, the way they change the Dropbox rules. Now they're saying that majority of the people have to come for in person because a lot of people who used to be eligible for Dropbox, they simply never had to go for an appointment. Now those people are having to go for in-person interviews. So so you'll have challenges, but again, keep constantly looking at the slots. The slots will open up at random times, and then you just have to book a slot whenever they open up.
All right. Thank you, Chand, for taking that up. And with that, I think we should also take up a few questions from our Facebook groups, if that's all right with you, Chand. Control, if you can display,
Yeah,
please.
sure.
This is Brinda asking, hi all, I have H1B visa started on 10/2022 and expiring it on 10/2025. When should I apply for extension?
So one can only apply for an extension when they are within the 180-day time period. So if it is 10/2025, 6 months, so basically April 2025. So from April 2025 till October 2025, during that 180-day period time, extension can be applied. And our recommendation is applied as quickly as possible. So what that means is, in April, she'll be eligible because that 180-day the time window will start. So as quickly as possible, which means April or May, it's a good idea to finish off the extension part.
Okay. Thank you for taking that up for Brinda. And Kay says, wow, as we chat, I got my soft copy for I-797B. That's really nice, Kay. Congratulations. All right. So let's go on to our next Facebook question. Control, if we can have that. Yes. So this is from an anonymous member, Chand, asking how much usually the cost for H1B extension, H4 extension, and first time H4 EAD with average attorney fees. Company is small scale business, less than 25 employees.
Sure. So the H1B extension, so I'll tell you the fees. So for a company that is less than 25 employees, the first time they file a H1B, it is $2,010. For the first extension, they have to pay $500 less. So it is 1,510. So 1,510. That's the first time extension fees. And the second time, it gets even lower. So the second time, the fees is even lower. It decreases by another $750. Okay, so that's the USCIS fee. And then when it comes to H4, the USCIS fee is $470. EAD again has its separate fee. EAD, the fee is $520. So you're looking at about close to $1,000 for H4 and H4 EAD, just the government fee. And then that attorney fees, I mean, typically you'll start seeing from $1,000 for the H1. And depending on what your company is doing, whether they're doing it in-house or they're using an attorney, the price could differ. But in terms of the USCIS fees, those are the constant fees for anybody that has less than 25 employees. Once they cross 25 employees, the fees increases a little bit with USCIS.
Okay. Thank you so much, Chand, for taking that up. Now, our next question is on the screen. This is also from an anonymous member. I received my I-120, I guess. I want to prepare myself for the interview. Why is the best question about why USA? What can I answer about I want to finish my studies now because I haven't studied for years? How can I answer this question and how can I convince her? I want this really. I got rejected twice before, and the second reason was that I wasn't proficient with English.
Sure. So I think so when you go for an interview, I think for an F1 interview, the officers are looking at two main things. One, what is your real intention? Are you coming to study and follow the rules of F1? That is the first thing. The second thing is your intention to go back to your home country after your studies are done? So the focus will be a lot on these things. And what that means is So they have to be able to convince that they have ties back to their home country. So they have to show through evidence what their ties are to their home country and why they would come back. That is very, very critical. And the other part is what exactly are they studying, how it will fit in their career plan, and what exactly is their goal. So once they finish their studies, what exactly is their goal? And if somebody is not able to articulate the reasons for studying, the reasons, their future plan, normally we see issues. So the thing is, you have to be able to articulate and explain to USA's officer what your the nature of your study program is, how it would fit in your career aspirations. And everybody's case is different, so that, and everybody's program is different, because some people are taking computer science program, some people are taking English as a second language program. It could be different programs. So overall, the nature of the program is very important, and they have to establish their ties to the home country. And again, every officer is different, and the consulate officers have a lot of discretion. And if they deny the case, unfortunately, you cannot get it reviewed, you cannot file a lawsuit in the court. So the thing is, they have a lot of discretionary power. So all that means is that particular office, a lot depends on that particular officer. So you have to be able to convince that particular officer. And if they are convinced that somebody's intention is to come and follow the rules of F1 and then go back to their home country, they are successful. If not, they typically have challenges with F1.
Right. Right. Thank you so much, Chan, for taking that up. And now we have another question. This is also from our Facebook group and from an anonymous participant asking, "Hi, I am on an L1B visa and I will be completing my third year in September 2025. My company will apply for a green card, and they said that I should extend my L1 visa for another 2 years and at the same time apply for an H1B visa, as the green card process may take more than 24 months. My question is, can I get an H1B visa on a future date? And can I apply now and get the visa after the expiration of my L1B? Or do I have to move to H1B immediately once it's approved?"
So again, in the new rules, when I mean, first the first thing is somebody has to go get through the lottery, and if they get through the lottery, the new rules say that you can apply for with a future date. So when you apply, you can put a date that is 6 months ahead of time, and that can be done. And the other thing is whether somebody has to move to H1B right away or not after the approval. There are two different ways of doing a H1B, and this is applicable to even students. You can do H1B as counselor processing, or you can do H1B as change of status. And if you do it as a change of status from the day, so if you do it as a change of status filing, the H1B is immediately active from the date of that change of status approval date, validity date. If somebody files a H1B as counselor processing H1B, so people can always take some time and they can convert into H1B in the future. So a lot depends how the company is filing the H1B, whether they're doing it in counselor processing or filing it directly with change of status request.
Okay. Thank you so much, Chand. So now we have another question, right? Control, if we have, can you please display it, please? Okay. I'm on OPT. I want to travel to India in April, return back in May first week, and my OPT is ending on 17th of June. Did anyone travel from Canada to USA on F1 visa from Montreal Airport to Toronto Airport? My question is, where will be the immigration in USA or pre-clearance in Canada, and they ask? What do they ask for?
I'm not sure if Montreal has pre-clearance. I mean, like some countries, like for example, Abu Dhabi. So you can have customs clearance done in Abu Dhabi airport. I'm not really sure about Montreal, how it works in Montreal, but at a certain point of time, they have to go through CBP, and CBP officer has to be convinced. So a CBP officer, only if he's convinced, they'll grant admission. So definitely, whether it's either in Canada or in US, you have to go through the CBP. Some airports like Abu Dhabi do have the CBP officers in the foreign country itself. I'm not really sure how Montreal does their things.
Okay, Chand, thank you for that. And I think we can take one more from our Facebook group. This is I applied for a change of status F1 here in America and got approved last year. I'm planning to visit my home country, Philippines, this June for my sister's college graduation. Will it be hard for me to come back to America? I've heard mixed opinions from other people that I will have a hard time. Your opinions and suggestions are highly appreciated. Thanks.
So I think the challenge is because it was a change of status approval. So when he goes to Philippines, they have to go for stamping. So I think basically that word mixed opinions from other people. I think it's because when you go for stamping, anything is possible. A lot depends on the officer. So this person has to go for stamping for F1, and depending on the officer, if at all there is a denial, there is a problem. But my experience is if somebody is already studying in US, you have a lot to prove that you're paying your tuition, you're actually uh, progressing towards your degree, you're getting all the pass grades and so on. So most of the time, when you're able to show that evidence, I think the office it's easy to convince the officers because this person has already started his F1. He has done a change of status. He's in US, already studying in US. So in general, it's a lot easier to convince the officer showing all these evidences. That being said, it is not 100% guaranteed because the officer will still have to give a visa. Only if the visa is given, he can come back. So that uncertainty is always there until he gets his visa stamping done.
And so the mixed reactions, the mixed opinions, right? Thank you so much, Chant, for taking up all of our
Yes.
questions so patiently. And I have this one last question to you, because there could be chances also that people would not make it to the lottery. So for those who would not be selected in the H1B lottery, what alternative visa or work authorization options should they explore?
So again, if somebody is in US, most of the time they are in US either on F1. Majority of the time, some people on H4 because they try to convert from H4 to H1, or sometimes people are on L1 and they try to convert to H1. So if somebody is already in US, again, they can continue that status. The only problem is if it is H4, you can't really work on H4 until you're eligible for H4 EAD, which means you're dependent on your spouse getting I-140. If it's a student, most of the time what luckily happens is students still have their OPT period, and some people will be having like STEM OPT and so on. So if somebody is a student, has their EAD card, continue on your OPT as long as you can. Some people, what they do is they extend their F1. They again get enrolled in another program. And if you're doing it, make sure that that college is legitimate. You're actually following all the F1 regulations if you're doing that F1 program. Uh, and for the folks that are not in US but are outside the US, again, in terms of work visa, again, you have the O visa option. So O visa again is a good option even for people in US. However, O visa is very tough. But again, a lot of people have been exploring O visa. So everybody that is not getting selected in the lottery can look at their O visa options. And some folks who are eligible for L1 because they're working in the foreign office, the company is also in US, they definitely should explore the L1 option. So L1 and O1 are actually very good options. And other than that, I think there are not many options for specialty occupation. But if somebody is from some other countries like Mexico or Canada or Australia, there are other options. There are like options called TN visa. There are options called E3 visa and other options. So depending on where your country, where your passport is from, you might be able to find some other options in general.
Okay. Thank you so much, Chand. I'm sure that would be of great help, to folks out there. So, folks, if you resonated with today's webinar, and I'm sure you did, do not forget to, subscribe to our channel. We are Immigration Talk Show on YouTube, and we are also there on LinkedIn, Facebook, X, Instagram. Do check us out and also go visit www.staffingly.com. And in case you want to have a one on one discussion with Attorney Chant Parvathaneni, why don't you go check him out as well? His website is www.spblawfirm.com, and you can also call him on his number 817 523 8247. And it'll be best if you can actually email him with your case, because every case is different and need its own attention. So his email address is what you can note down. It is law@spblawfirm.com. Thank you so much, Chand. And yes, I think H1B lottery season is knocking at the door. So maybe if you have final words, to folks out there who are watching us right now, it would be great.
Sure. So again, the H1B lottery. I mean, I definitely think we will have a lottery, but I think the numbers will come down compared to last year. Last year we had 400,000 registrations. I definitely think the numbers will come down, and the big reason for that I think is the $215 fee. And that being said, I think the companies should not wait until the last minute. March 24th is the last day. March 7th is when it starts. So I don't think people should rush and file on the very first day, but at the same time they should not wait until the last minute. So try to do it maybe like in the middle somewhere around March 15th. So that way you're doing things carefully, making sure all the data is accurate, and finish the registrations. And just because I think the numbers will be lower than last year, I think the selection percentage, the selection chances more than likely will be a lot better than last year. And I think people should just, I think, look out for the lottery once it is done. They have 90 days to do the actual filing. And we have cases where people wait until the last minute and then they miss the deadline. So getting through the lottery next month, that doing it cleanly with the right data, that is very important. If they're selected in the lottery, remembering that there is a 90-day deadline, and again, not waiting until the last minute, but doing it a little early than the deadline and wrapping it up, that's also pretty important. And hopefully, I mean, again, at this point of time, we are not really seeing like denials or anything for H1B. As long as the company is legitimate, the job is legitimate, USCIS is still approving cases. And President Trump's administration, they're also saying that they are not really in favor of doing anything to H1B. Yes, they're talking about changing EB5 and other immigration things out there, but in terms of H1B, most of the administration officials, they're coming and saying H1B is valuable, and they don't have any plans of removing H1B or making any drastic changes at this point of time. So hopefully, I think people get selected in the lottery and they get through and use this as a part of their career and move ahead.
Absolutely. All the best, folks out there, especially those who are going to, try their luck in this H1B lottery this season. So thank you once again, Chand. It was such a pleasure and an honor having you here on Immigration Talk Show. It was a great discussion and a very insightful one. So thank you once again.
Thank you,
Have a great
Natasha.
day. And folks, do check him out and also check us out at Immigration Talk Show. Do not forget to also, check us out at www.staffingly.com. And you can also email me. My email address is nipa@staffingly.com. You can also WhatsApp me. My phone number is 408-335-6444. This is also where you can call me and message me on WhatsApp about your case or questions. So thank you once again. Folks out there, have a great day and stay tuned on Immigration Talk Show because we got more webinars lined up. Thank you for joining us.